case number 8500 of 2022 in the matter between the Public Protector of South Africa and the Speaker of the National Assembly and 16 other respondents.
Applicant in this matter, my learned friend Mr. Shabalala and Ms. Mata as a committee.
Thank you, Mr. Dorfman. Thank you, Mr.
As a piece of short I appear for the first respondent, the Democratic Alliance, together with my learned friend, Mr. Bishop.
Thank you, Mr. Bablanya.
I'm led by the way, as you see,
Thank you. And your name, sorry?
it's Davis, my lord.
Davis.
Davis.
Justices, the name is Adwan. I am here together with my learned friend, Mr. Masuku, and Mr. Simelane for the 10th, 11th, and 16th respondent. I don't understand civic duty. In other words, we are here for all of the country. That's just so we see that.
Thank you, Mr.
This is,
I see that you have not been able to agree as to the allocation of time for each council.
we have now.
You have.
Yes.
That's very well.
Yes. I'm sorry. There's still somebody to put themselves on the record.
Oh, I'm sorry.
Yes.
Good morning, my lords. It's Brian. I'm appearing for the acting public protector along with Ms. Davis.
Thank you, Mr. Brandes.
And as God pleases, my lord, we have, well, let's start with the news. We might have to request the court to indulge us a little bit after 4 o'clock, but we'll see how we go. Maybe we'll revisit that question by lunchtime. But it might be that we are alarmed for no reason. But as matters stand, this is the following breakdown. It's going to be 3 hours for the applicants. And by applicants, I'm using the term broadly, including the supporting respondents.
That's a lot of time, Mr. Boko. I mean, the issues seem to be a bit narrow, but
that's exactly why I started with that calculation. We might finish in the next 5 minutes, and therefore we don't have to worry about
that might be
about
too short.
about 4 o'clock. Yeah. Thank you, my lord. And then the other side, which is
the 3 hours would be for the initial address and the reply, or only the
initial address. But my lord, I'm very optimistic. I think that it's going to be much shorter than that. Once I've just outlined the issues, but this is the worst case now. Then the other side will take 2.5 hours, and we were going to ask for a 45-minute reply, all things being equal. Now, the only spanner in the works is the issue of the intervention. The intervening party has asked for 15 minutes. We, as far as I know, at this stage, are the only people who have filed papers to propose that, and will also not be more than that 15 minutes for the intervention. So what has been agreed is that that issue once again just be disposed of at the beginning, if the courts will.
So we start with the issue of the intervention.
Yes. If we do that, then in fact that formulation might impact my time because some of the issues of the intervention overlap. Yes, unless I'm left anything out from an influence, yes, that is the agreement. And then again, another indulgence we'll ask for is if it looks like we're overstepping, we might at that time maybe ask for a shorter lunch adjournment. But again, as I say, these are just precautions. Speaking for myself, I doubt it will.
Thank you. I see that Mr. Mpofu has been conferring with you as he was speaking, so it won't be necessary for me to confirm with each council.
Thank you, Justice.
Maybe just to confirm, and it's exactly what Mr. Mpofu said, the 3 hours covers my learned friends, Mr. Mpofu, Mr. Masuku, and Mr. Ngalwana, that's the intention. And then the 2.5 hours will cover Mr. Pillay and myself. We divided into the sides, in a sense, just so that there's no confusion. But that's exactly what my learned friend said.
And so now we start with the intervention. I suppose
Yes, my lord.
the spenders will kick in.
Yes. Well, it looks like we're, some of us, we'll go again.
All right, the Reinders.
Thank you, my lords. First, I must express my gratitude that you've allowed me to do this virtually because of my COVID situation. Secondly, my lord, as I've said, I appear with Ms. Davis. Third, do my lords have the heads of argument of the act? It's an 8-page document. It's called Heads of Argument, Acting Public Protector.
Mr. Reinders?
Yes.
You may proceed.
Thank you. So, my lords, do you have the heads of argument?
Yes, we have received, some are being printed, but I do have a copy, so you can.
Thank you. Good. So, my lord, the heads are fairly straightforward. They set out what is sought by the acting public protector is intervention for the purpose of filing an affidavit. The court is also asked to admit the affidavit. Why is leave to intervene sought? In the leave to execute. Sorry, my lords, I'm not sure if you're aware of the echo.
Yes, we do have an echo, which is a bit distracting, but I don't think that. Let's just get on with it.
Thank you. In the affidavit in support of leave to execute, Advocate Mkhwebane made 3 allegations. The first was about and the second was the delay and destabilization in the Phala investigation. And the third was delay and destabilization in other investigations. And the acting public protector put out an affidavit to deal with those allegations. Now, she isn't a party, as you know, and so she has to seek leave to intervene. We set out the requirements for leave at paragraph. A direct, substantial legal interest, subject matter of the allegation. The application must be serious and not frivolous, and they must and leave to intervene must be legitimate, where leave to intervene is after judgment. Now, on direct and substantial interest, we say there is one, and we say so for the following reasons. The acting public protector is currently the incumbent by virtue of the legislation, Section 2A of the Public Protector. And that confers on her statutory authority to perform the functions of the public protector. The executive authority. As the current executive authority, she has a direct and substantial interest, my lords, in the questions whether the office has delayed or stabilized the Phala investigation or other investigations or the work of the office, or whether Advocate Mkhwebane has been denied access to crucial documents as a result of her absence of the office. These are factual questions, my lord, that the court must decide when determining leave to execute. And we say that where there are serious allegations, and where such serious allegations are made, it is the duty of the public protector, the incumbent acting public protector. It's her duty as a Chapter 9 institution and organ of state to not only, as we say, well, she's got to tell the truth. She has to put all the true facts, all the material facts before court. And that's what she does with this affidavit. And if that's the case, my Lord, we really say that there's a direct and substantial interest for two reasons. The first is, well, as the acting PP, there's a direct and substantial allegations concerning the performance of her office. And two, as a Chapter 9 institution with heightened duties to assist the court to get to its independence and so on. She has a direct and substantial interest. Next, my Lord, we say the application isn't frivolous, and that is self-evident. I mean, she puts up the facts relating to whether there's a denial of access, whether there's a delay or destabilization. She puts up the facts, and it can't be said that such an affidavit is, an application to put up such an affidavit is frivolous. And also, if it's an affidavit which attempts to assist the court to get to the true facts relating to the office of the public protector, well, it can't be a frivolous application. Lastly, my Lord, legitimate reason, we say, well, there is a legitimate reason here because she complies with her legal duty, the legal duty of the office, by assisting the court to put up the true facts. If that's the case, well, it's a legitimate reason to intervene. And my Lord, we say, therefore, that she's complied with the requirements. And if she's complied with the requirements, the court should permit allow her to intervene, and then the advocate in Khwebane hasn't raised she hasn't put an affidavit, but she's put up a Rule 65D3 notice, where she says the affidavit contains irrelevant and vexatious and defamatory matters. The problem with that allegation is it doesn't say which the irrelevant, vexatious, and defamatory matters are. In fact, my Lord, my Lords, the matter in the affidavit is virtually bland. They just set out what the facts are in relation to whether there's been a denial of access or whether there's been delay and destabilization. There's nothing controversial, there's nothing defamatory, there's nothing irrelevant about it. So we don't understand that. To say that the second point she makes is, this is Advocate Mkhwebane, she says, well, the acting PP lacks locus standi. Well, of course, that, again, if she's the acting PP, public protector, then, well, she would have, as we set out in the heads, all the duties conferred on her by Section 2A7. And she's the executive authority, and it can't be said that the executive authority of an organization doesn't have locus standi when there are allegations about the performance of that organization. Lastly, non-compliance with Rule 12, that there is no direct and substantial interest. Well, we've shown you, my Lords, there is direct and substantial interest. One, because she's the executive authority about whose organization allegations are being made that must be set right. And two, she has a heightened duty to place before the court facts to enable the court to properly, justly decide the question whether to decide those three allegations. In other words, has there been access and has there been delay and destabilization? For those reasons, my Lord, we submit that the acting public should be admitted as a party and the affidavit admitted as an affidavit. Those are
So, Mr. Brendas, if I understand you, if we are with you, the only purpose for which the acting public protector wants to intervene is to place the correct facts before the court and make no submissions in relation to the relief sought by the applicant.
correct. In fact, the public protector takes no stand on the suspension of the leave to execute. She doesn't say whether it must or mustn't happen. She does not enter into that debate.
But then, is he not conflicted in the circumstances of this case?
What was the question? Forgive me?
Yes, I was just saying, is the acting PP not conflicted in the circumstances of this case?
But why would she be conflicted if what she is doing is setting out facts relating to the office, and insofar as she sets out facts relating to the office, of course she's the public protector, but she makes no, I mean, there's no personal interest of hers here that she is promoting. I mean, one could only talk of a conflict of interest where she herself would be conflicted with the purpose of running the office, or of providing information on behalf of the office, but there's no evidence that she's conflicted. And there's no interest of hers that conflicts with the interest of the office of the public protector, and then with the necessity for the office of the public protector put the true facts before court.
Yes, thank you.
Thank you, Mr. Brendas. Mr. Volkman.
Thank you very much. I'm going to just pause before I respond. I forgot just some of the housekeeping issues earlier. I have here a copy of our submissions. I'm not sure if the bench have them, which were filed yesterday. The heading says Section 18 applicant submissions.
Yes, no, we
okay,
do
good. Then I also have, and I'll hand it up in due course, a signed version of our replying affidavit, but I'm sure the Russians have got the unsigned version.
Yes.
Okay, no, that's fine. And lastly, I just wanted to check, coming now to this issue, whether the learned judges have got our Rule 653 notice.
Do you have a spare copy for me?
Yes, I do.
Documents have been coming in drips and drabs, and
yes, I know this kind of thing becomes untenable. Perfect. I have 3, I think, 2 copies.
not 2 will do.
2 will do. Okay. Yes, that's what I'm saying. Yes, I actually have that background. All right. Sorry, have initialed my name. That has continued my problem. Yes. No, that's okay. Now I don't have one. I shouldn't have handed that.
You can have
the one with my name, please. I can't.
You can have this one.
I thought this was it, but it's in any other one. I apologize. Thank you. I'm going to try to be very short on this. Firstly, Your Lordship should appreciate that because of the time, but also because we don't really want to waste the court's time. It's regrettable that this is happening again. We have chosen probably the shortest route to deal with this, which is in terms of Uniform Rule 65D3. The Lordship should know that that rule says basically that an applicant or rather a respondent in an intervention in any application may simply raise points of law in opposition. And in that case, then one doesn't file an affidavit. And we're doing that for various reasons, my lords. Also just for, good governance. We don't think that it's something that should be encouraged, that the public protector and the deputy public protector are putting affidavits unnecessarily in the public domain about each other. So the public protector decided basically to be the bigger person. So what she has done is simply to put those three grounds that are in the notice. One, that affidavit contains irrelevant, and that's the emphasis, irrelevant, vexatious, and defamatory matter, insofar as it portrays as either misleading court or something like that. And then we say Rule 12, the Rule 12 applicant is lex locus standi. Again, I won't waste much time on that. I'll just mention what we mean by that. The real defense is the third one. There is non-compliance with the requirements of Rule 12, in that no direct and substantial interest has been alleged and or established. And we are happy just to deal with established because there's some vague reference to direct interest. So we don't want to waste the time of the court. My lords, really it's perplexing and puzzling as to what is happening here again, as happened in the previous matter where we had to waste time before we deal with the real issue. The public protector, that is now the public protector of South Africa, says in her affidavits, or rather, let me start with what Mr. Brenda says there are various statements which are untrue, which they want to put into perspective. What are those statements? The only statements that have been made by the public protector in a context that is clear that it has to do with this application for leave to intervene, that we could even fathom to be close to what she's saying is one will find at page 11 of the papers, 12.3. And that is linked to 12.2, which mentions the Phala matter. And all the public protector said, and we know that the role of the Phala matter in this matter, I don't have to go into it. All she says that on the day of the judgment, as it happened, the judgment came, I think, at about 2:30 or something. At 1 o'clock or so, there had been a march to the public protector's office by among others, the clients represented by Melanie France, Mr. Galwana Masuku and Simelane. And she says that there is a perception around that much that there is a delay in that matter. That's all. That perception is borne out by, you'll see in Mr. Ngalwana's papers that there's a memorandum signed by Mr. Zungula, which was handed over to the acting public protector. I don't have to bore you with it, but it's replete with complaints of delay, 3 or 4 pages. So all she says, the public protector at 12.3 is the following. The main grievance of members of the public who marched was the perceived undue delay in attending to the urgent matter of Palapala. And that an undertaking was made that this would be looked into in 7 days and so on. That's all. Perceived by the marchers, not by the public protector. She's putting a fact that's what happened. And then paragraph 35. And quite frankly, what we say here is nothing compared to what Mr. Olomisa and the deponents in the Arab David say about it. So I don't know why not attack them, but attack us, was simply saying it is their perception. And then paragraph 35. Which is at page 17. Says the investigation is pending and has been unduly delayed inter alia because of the unlawful suspension. Now, that one really it takes cake, because all the public protector is saying is that because of the suspension, there's been destabilization and delays. Now, that is not blaming anybody. It's just an obvious statement of fact. And it is defined easily. The best way to look at it is if you go to page 868, the reply affidavit of the public protector. Yes, thank you, Carlos. Paragraph 50, she says, it is self-evident that the general work of the public protector suffers whenever there's only one occupant of the 2 offices of public protector and deputy public protector. That's all she's saying. She's not saying the deputy public protector has done anything wrong. She's simply making a statement of fact that if it doesn't matter, let's assume it was the deputy public protector who was suspended. That would then burden the public protector with 2 jobs, so to speak. And that's all she's saying. She's not saying this one is, didn't do this or didn't do that. Certainly, whatever she says cannot attack an affidavit of 30 pages or so, which is double the affidavit of the public protector in this application. For what? And the reference is the same. This court, no less, said the following, which agrees with what the public protector is saying in those passages. This court said that paragraph 153 of the judgment. It says the second is, you find that on page 84, typed page paginated 84. Well, it starts to deal with the main reason for the judgment. So the second is against that backdrop. At the time of suspension, the president was sitting with a letter from the applicant with a long list of questions that the president was required to answer within 14 days. And he had about 12 days to do so at the time of suspending the applicant.
Yes, you can.
Yes, I can continue. And he had about 12 days to do so at the time of suspending the applicant. And then he says this court, to suggest that such a suspension would not have any effect on delaying the course of investigation would be a difficult proposition to convincingly sustain, says the court. So is this court now then telling an untruth? Because that's when the public protector makes the same point that this court has made, she's told that she's said an untruth. But this is a self-evident issue, as I say, that there will be inherent delays if something like this happens. We're not saying it means that the whole office is going to collapse or anything like that. But we're saying that, as the court says, it would be a difficult proposition to convincingly sustain. So why are we here? Why is there even a so-called intervention, which comes to the real issue that Justice Lekuleni asked? And that covers both the locus point and the third one. We don't want to get into those technicalities. But the reality of the matter is that the situation is not as easy as the Deputy Public Protector wants us to believe. It is common cause, right? That as at 2:30 on the 9th, the Public Protector was reinstated by the order of this court. There's no debate about that. It is common cause that she then made arrangements. She reached out to the Public Protector and said, thank you for holding the fort and so on, all these nice things. She never blamed her for anything. And then she spoke to or rather sent a WhatsApp to the CEO to say, please, I'd like to come to the office tomorrow. Can you make sure that the security arrangement is fine? The other person, all this is in the papers, wrote back and said, thank you, congratulations. I'll talk to security. You can get the keys or whatever. Everybody understood what the court had done. 5 hours later, I'm cutting a whole lot of things that happened. 5 hours later, there was a so-called application for leave to appeal, which then ostensibly at least suspended the judgment. But there can be no debate about what happened in between. If the judgment had been in the morning at 7 o'clock, the Public Protector would have gone to work at 8 o'clock or 9 o'clock or whatever time she goes to work. Let's put it like this. We all know as lawyers here that the party that is putting an application for leave to appeal has got 15 days to do so. So let's assume that on the 15th day, the DA had filed an application for leave to appeal. Anybody who can suggest that for the 14 days before that, the Public Protector should not go to work is just would be, so the mere fact that it's 14 days or 3 hours or 2 hours is neither here nor there. The legal situation is that she was back at work. Now, so the question of locus standi arises like this: whether by the DA's submission of the application for leave to appeal, that it might suspend the judgment, but does it then reinstate the acting Public Protector? Because her term, in terms of the presidential minutes, had expired at 2:30 on Friday, as it would have if it was the 14 days or whatever. So on the 15th day, a new act of reappointing her would have had to be made. And as I say, it doesn't matter if it's, for the purposes of this point, whether it's 14 days or 12 days or 2 hours or whatever. So that's where we say there's no locus standi, coupled with the fact that this court has held that she is she cannot act she's not the Public Protector of South Africa. So that's the locus. Even if we are wrong on that, the real point is, and it's coupled to this, what is the test? I've never heard of this test that Mr. Breinders is telling us about, the need to put the facts or whatever. The test is very simple. The test is whether you have a substantial legal interest in the subject matter of the litigation. The subject matter of the litigation here is the Section 18 application. And that goes directly to
putting into operation the order.
The order of this court. Yeah. So what interest that goes to Justice Likuleni's point? The only interest that the acting public protector, so-called, can have in that is to stay in that post for as long as humanly possible. And surely that's a conflicting interest, because it's not like she's just some neutral South African who has nothing to gain by the non-operation, let's call it like that, of the order. The longer the order is not operational, the longer she stays as the acting public protector. So Justice Likuleni hit the nail on the head. And what that interest, quite frankly, it's fine if we all want to hold offices. So, but that is not the legal interest that is defined in the rule. Certainly is not. And just quickly, just for the sake of progress, go to D1-139 of Erasmus. I hope this is, oh yeah, it is 2021. D1-139. That's the commentary on Rule 12. It says, Erasmus says, as in the case of joinder, as of right, the applicant for leave to intervene must show that he has a direct and substantial interest in the subject matter of the action. Okay. The authority for that is a case called the Henry Viljoen versus Aubush Brothers. It's an old case, 1953 to SA 151, but that has been, sorry, I've just missed. And 51O at 167. But it has been confirmed in many cases, including in the Constitutional Court, as a riding for the Disabled Association, otherwise known as SARDA. I think we referred to it the last time we were here. National Land Claims 2017-5, SA1, Constitutional Court at 4F. It's a well-known test in the subject matter of the action. Such an interest is more than merely a financial interest, which is only an indirect interest in the litigation. I pause there. So any indirect interest in the litigation is not sufficient. Here we don't even have an indirect interest. What we have is at best a conflicting interest. And then it says it is a legal interest in the subject matter of the litigation that may be prejudicially affected by the judgment of the court. And let's pause there. What interest may be prejudicially affected by the judgment of the court that belongs to the Deputy Public Protector, except the one that was asked by Justice Likuleni? This means that the applicant must show that he has a right adversely affected or likely to be adversely affected by the order sought. So the order here being the Section 18 order. So even if you, let's leave out the factual stuff, let's leave out that it's just an unwarranted and gratuitous attack for stating, neutral facts. Let's leave out the technicalities about whether the public protector was reinstated at a particular time and so on, and whether there's local standing. Let's just go to the nub of the issue. What is the interest that is required by the law for this kind of application? For this court, and really we have to apologize to this court for what is clearly an abuse, because to have a 30-page affidavit with tables and chapter and verse about how many reports were finished in what month and what have you, what is the relevance of that to the issue before this court? Zero. Put aside the 400 pages of evidence, we'll talk about that later, that is put up by the DA coming from the Section 194 inquiry. But it's just an abuse of process. This is an ancient court. The reason why we did our affidavit to be 14, 15 pages is because we could have gone on and give historical accounts of this and the other. But we knew that this is ancient court. We need to come and say what we have to say and get out, you know, and not tell this court about all sorts of long stories. And we have lots of them about this matter. but you know, it was explicit. Go in Section 18. We met the requirements, yes or no, and let's move, you know. I don't even want to tell you what is contained in that affidavit, but that's why we did a Rule 6 deeply, because we said, let's assume all those facts are true, assume all those tables are true. So what? What has it got to do with what we're debating here? Number one, so it's not relevant. B, it certainly doesn't conform with Rule 12. So, and we would like the court, we don't have to ask for punitive costs and things like that, because again, we don't want that kind of acrimony. But the court must please, whenever it makes a ruling on this, just express its displeasure at what now has turned out to be. We ask for this court, we beg the judges to come earlier than the normal time, and the judges indulged us. But now all that has been cancelled by something that is completely unwarranted. And this is not the first time. This last time we had the same thing about Siametho and the attorneys and joining and the definition of PPSA and so on, which had nothing to do with the business that we were about here. So if the court doesn't put a stop somehow to this, then it means that it's just going to happen again. It's bad for on every front. Public protector, the acting public protector, deputy public protector, whatever she is, she must sit, wait, and when the outcome comes, whatever it is, then if it favors her, it favors her. If it doesn't, it doesn't. But you can't induce a particular type of outcome by trying to paint unfairly and unreasonably so about the actual public protector as somebody who, I don't know, misled the court or has good facts that are not that are not true, because they are true. People did much, and they say in much stronger terms that she has delayed the matter. It doesn't matter if that is true or not. We simply say that's their perception. That's why they marched.
Reynolds, you want to short reply?
Thank you. Lord, in deciding the execute application, the advocate Mkhwebane said in the affidavit that part of the reason that you must never leave to execute is because she makes, as we say, 3 allegations. Those allegations are denial of access to crucial documents and delay and destabilization in investigations. Now, those are factual questions which my lords must decide, my lords must determine. Lords must ask themselves, is it correct that there is a situation alleged by the advocate Mkhwebane that requires strict survey? Now, the allegations on which she relies, the acting public protector are not true. And the acting public protector says, in order, here are the true facts, so that you, the court, can make a proper and full determination. It's surprising that our learned friend says, well, what does it matter whether those facts are the truth? And that's a rather cynical attitude towards the court and the truth. It does matter that it's the truth. Because, of course, we're dealing here with a Chapter 9 institution, a public institution, and we're dealing here with the right of Advocate Mkhwebane to get leave to execute. It is important. The true facts must be available so that my lords can decide whether on those facts leave to execute should be granted. Saying that the acting public protector doesn't have direct substantial interest, we say she is by law the incumbent and therefore has a direct and substantial interest in a finding by the court on the conduct of investigations in her office. She has a direct and substantial interest, in fact, in the finding by the court that her office has denied Advocate Mkhwebane, who has a right to crucial documents, that it's denied that during the inquiry. So, my lord, she obviously has a direct and substantial interest. But finally, my lord, and we come back to what we said at the end of this. You're concerned ultimately with truth, and you do so by applying independent, impartial minds. It seems to us that under our constitutional dispensation, our courts are particularly concerned that they decide matters on the true facts, and that organizations like the Public Protector Office places before court to assist court to come to a just decision. And those are reasons, my lord, why should allow intervention or permit intervention and admit the affidavit. Thank you.
Thank you, Mr. Brendas.
Yes, I apologize, my lord. Just one small thing that I forgot to mention. My learned friend, Mr. Brendas, said that earlier in his address that the application is not frivolous. I've addressed that, but I just want to point out one thing just so that we can see what we're dealing with here. Look at the heading of the application that has been brought. The applicant is the page 816. The applicant is the Public Protector of South Africa. And then it says the first respondent is the Public Protector of South Africa. And then in red, the Public Protector of South Africa versus what is that? So the Public Protector of South Africa, and that's only one person, that's is suing the Public Protector of South Africa as a first respondent. I mean, and that's to try and escape the effect of the earlier judgment of the 9th of September. If that is not frivolity and wasting the time of the court, then nothing ever will be. And again, as far as the documents in the office, it's common cause that was raised, it was resolved, but one cannot escape the fact that all the public protector is saying that because I now have to go via asking people to get documents, I'm now affected in the Section 194 inquiry. That's all. It's not a blame game of anybody. So this application should be dismissed with some serious censure of some kind.
Thank you, Mr. Prof. We will consider the submissions relating to the application to intervene and deal with it in our judgment. We may now get into the
Thank you.
And just to facilitate the main matter, may I ask if there is still any party which seriously opposes the issue of urgency so that we decide whether we spend time on that or whether we get on with the matter?
My lord, we persist with urgency, but we are content to argue it in the course of things. We don't seek to raise it at this point.
Thank you, Madam. We haven't raised it in the system, but in our head, we're happy to proceed with amendments in our applications.
All right. You may then proceed.
Thank you, Madam. Thank you very much. That actually assists me, that question. What I will then do is I will not address the issue of urgency because likewise we have addressed it exhaustively both in the heads and in the founding papers and the supplementary papers and the reply. And it's also
Sorry, I didn't give Mr. Ngalwana an opportunity to comment on that.
You might want to oppose.
I'm sorry, Mr. Ngalwana.
We do not oppose. We did want to make one or two submissions in relation to the intervention application, but we missed the point to accept that.
And that vote has said.
The only thing I want to say about the agency, for what it's worth, is that it's just to flag to this court that the fact that the so-called application to the Constitutional Court by the DA says that the matter is urgent. So apparently their application to the court is urgent, and it had to be done within a few hours. But ours, when we react to that, is not.
And then on the issues, it seems as if the issues have kind of crystallized into, firstly, the issue of Section 172.2 and whether it applies. Because if it applies, then the question would be, would Section 18 be applicable?
Yes. That's the, let's call that the preliminary issue, and then the merits. Yes, that's correct. That's correct. In fact, yes, that was the judge took the words out of my mouth to say that there are actually two separate issues. One, let's call it the eliminate point, which is the Section 172 / Section 18. I think it's been articulated in the DA answer affidavit as follows: whether Section 18 applies, and then you take it backwards to 172 and so on and so on. Then, of course, the second issue is the merits, whether the test has been satisfied. Let me start with the first issue, because that's the one, there's so many smokes and mirrors around it. But we're going to try and simplify it as much as possible. Again, let's keep the eye on the prize. The prize is, does Section 18 apply to this matter? That's because if it doesn't, well, then that's the end. We must all go home. And then if it does, we deal with the merits. So the argument then goes something like this. The order that was given by this court, they say, is an order in terms of 172.2. And when I'm talking broadly about that section, I'll just say 172.2. There's going to come a time where I differentiate between A, B, and C. And we say, no, it's an order in terms of 172.1. So that's the first departure. Then, the reason why that is important is the implication of what, as we move towards the price of the applicability of Section 18. They say that if it's an order of 172.2, then it's subject to confirmation by the Constitutional Court. We say that the order is a 172.1 order.
Can I interrupt you that I don't quite understand that, because my understanding of the scheme of that section is that an order made in terms of Section 172.1 carrying conduct to the constitutional.
172.1A.
Yes.
Yes.
Is not effective until confirmed by the Constitutional Court. Yes. That's what Section 172.2 says.
Yes.
That's what Section 165 says.
Yes.
So it's not an order. There won't be an order in terms of Section 172.2, but it will be an order in terms of Section 172.1.
Yes.
And then 172.2 talks to that.
Yes. Okay. Fine. Let's assume that is so for the sake of progress. Then the point is this still. In fact, I think Mr. Padland, either in his answer affidavit or his head, says that it's both, which is what they're saying, Justice. No.
No, I just want to
explore
so that you can clarify that for me if my understanding is correct or I'm missing something.
No, fair enough, yes, because it has been raised. But I'm saying I really don't want to waste the time of this call. I'm saying let's assume that is so. Let's assume this is an order of invalidity. We strongly say it is not for various reasons, including the fact that it derives not just from the constitutional invalidity, but also from the common law and so on. We've made those points. We say that at best that order is a hybrid order that talks to even if you accept that decision and conduct, again, I don't want to enter that debate. Let's assume the decision and conduct is synonymous for argument's sake, which again we deny that is so. But for the sake of progress, let's say that's the same. So even if you accept that, then you have to accept as well that the order comes from two things. Let me postulate it like this. Let's assume this court had said, Mr. Mpofu or public protector, we're not interested or not going to find actual bias. And we're also not going to find a reasonable apprehension of bias, what we call the common law bias. And the court said the only premise upon which you are succeeding is section 96(2) of the Constitution. Then that would clearly be a quintessential 172(1)A order, which is based on the constitutional violation of conduct, and therefore 1B, and on the formulation we've just now agreed for the sake of good governance, which flows to 2B. But that's not what happened here. And that is actually another crucial distinction between this case, for example, and EFF Nkandla. Because in EFF Nkandla, the premise of the conflict was 96(2)B. That was it. Here, we have a hybrid situation where there's a 96(2)B conflict, but there is common law conflict based on actual. It doesn't matter whether it's actual or reasonable apprehension for the purposes of this argument. Both of them are derived from the common law. Now, what we say is that, take my example and flip it backwards. So the public protector, therefore, theoretically could have come here and say, I'm just coming here on the question of reasonable apprehension of bias. Forget the Constitution, throw it away. I'm saying there was a reasonable apprehension of bias, and therefore the suspension should be set aside. That's it. That is competent. It's something that she should have done, or rather she could have done. The mere fact that for the sake of proper pleading, you lump all those things in one set of papers is irrelevant. There's nothing which could have stopped her from saying, I'm here only on the common law bias or actual bias or reasonably perceived bias. Then we wouldn't be having all these debates about 172(2) or this one or that one. It would be a matter of setting aside the issue because the common law rule has been breached. Full stop. Okay. So let's park that. I'm even prepared to concede that. You'll see how I'm going to make this so easy. Let's assume I'm wrong in all that. There's no common law element. It's all 172(1)A. The question is, so what? Because the even on their version, my lords, even on their version, we should place this as a 172(2)A matter. Then this is what that section says. Sorry. So let's say for the sake of this argument now that this is a 172(2)A order. maybe let me pause before I do that and explain something which is also crucial. This order that we are debating now, justices, must be understood in the context of the judgment. We all know it's Trial Law, Firestone versus Territorial Court, I think is the case, that says a judgment, an order must be interpreted like any other legal document, and using the reasons as the surrounding circumstances. Now, the order at 187.5 is the only order that can conceivably be called a 172.2a order. And that's the declarator. There's no doubt about that. So the decision of the president, let's say, the decision of the president to suspend the applicant is hereby declared invalid. But what has all that got to do with the order at 187.6? The order at 187.6 says the suspension of the applicant is hereby set aside. And then it says effectively from the date of this order. So we've said in our replying affidavit, that order is what we know as a compound order. There's nothing compelling the court to separate. It's just a question of style to separate the orders. It could have put one long sentence if the court wanted. So, but because we're here now, we have to dissect this order. The first part is the suspension of the applicant is set aside. Full stop. And then there's it could have been a 187.6a or b. The effective date of this order is the 9th of September. That's really all that's communicated there at 187.6. Now those two orders or sub-orders combined into one cannot, in anybody's language, be called 172.1b orders. Here's the catch. Again, the court will know just from its own experience. The public protector, it happens here, it happens in the labor court, it happens everywhere, could have just come to this court and say, I only want one prayer to set aside the suspension. That's it. And nobody would have said, no, but why don't you first ask for a declarator? She said, I don't want it. I just want to set aside the suspension, as happened in the labor court. Now, who would have then said, no, that order setting aside the suspension must be confirmed by the Constitutional Court? Nobody in their right mind. Now, so it's important to distinguish between these two, and that's where this issue of the common law is important. It's important because, again, that order derives, let's assume again in their favor, let's say somehow it also derives from the 172 declaration. But there can be no doubt that it also derives from the common law findings of this court. And with the greatest respect, we say that it is rather disingenuous, and we use that word advisedly. We say this at paragraph 27 of our heads, or rather 23, sorry, page 6. So it is disingenuous for the respondents to deny at this late hour that the said conflict was specifically pleaded on the basis of two common law grounds, namely actual bias and or reasonably apprehended bias, and separately upon a constitutional ground, namely section 96(2)b of the Constitution. There's no doubt about that. There has never been any doubt in anybody's mind. You might remember, I even said, criticizing the court, the Part A court, because it actually did the opposite of what my learned friends are now saying. You take that judgment of the Part A court, you will not see the words Section 96(2). It's not there. So, and we said that is what we had pleaded, but it has not been addressed by that court. That we were doing that for the purposes of making a separate argument. So all the court did was simply to address only the common law bias grounds. So for these parties who have been the biggest supporters of the Part A judgment, to now come here and say that that judgment, which was based on the common law specifically, was not based on the common law. That's complete disingenuous. And then we say that this distinction was highlighted in both Part A and in both the Part A and Part B papers and arguments, even in this court, as I've just illustrated. It was never disputed. This is further, we say this is further illustrated by the following dictum of the Part A judgment, which the respondents have always roundly supported. And sorry, we didn't put the part. It's paragraph 103 of the Part A judgment, which we criticize for this very reason. This is what the judges said in Part A. The applicable legal principles on this issue, in other words, on the conflict issue, emerge from the common law. They have since been re-articulated in the right to a public hearing under Section 34 of the Bill of Rights and in a sequence of appellate division judgments. And I think they wanted to say constitutional court judgments, because if you see the footnote, it's only constitutional court judgment. Then says, consequently, contrary to what is contended by the incumbent, she, in other words, this was used against the public protector, now it's almost being weaponized against her. She is not possessed of a freestanding claim for the refusal of third respondent, independent of the common law principles as set out in our jurisprudence. That's what was found, exactly because we had pleaded the common law ground as well as the constitutional ground. Our only criticism, at least before this court, was that that court only concentrated on the common law ground and did not address the other leg of the. But now, the script is now being flipped to say, no, this has nothing to do with the common law. Now, so the reality is this. If let's assume again that the Part A court has found in our favor. If it had done so on the way that the judgment is formulated, it would have done it so purely on the common law ground, which it has articulated in its paragraph 103. And it would not have made any reference to Section 96. Now, if that does not illustrate the fact that the order in 187.6, at best for them, derives from the constitutional ground, but also derives from the common law ground, then nothing ever will. And the importance of that, my lords, is that that order has a life of its own. It's not ancillary to the order in 187.5, as it is said. In other words, it doesn't flow from it symbiotically, so to speak. It's a freestanding order which could have even been granted either on its own or based on the finding of a judicial.
I can't remember now. I could have read one of the reference to a decision which said when the just and applicable remedy is ancillary to either the review setting aside or the declarative.
Yes.
I think it's one, I can't remember.
Yes, it's the armed magistrate something.
I don't think.
Lord, can I assist the court?
Yes.
The McBride decision of the High Court, which is referred to in our heads. That's the case your lordship has in mind.
Yes, and in fact I've got it. Yeah. Let me explain what is said. This is what I've just been addressing now, as to whether the order, the second order, let's call it that, flows only from the first order, or whether it can exist, or it could exist on its own. Now, I'm saying, A, that order, remember when you look at an order, you must read the whole judgment. You don't just go to the order. We must look at the context. The context starts with Part A, which I've just read out, which makes it clear that the basis for the conflicts were common law. In fact, that court went overboard by basically saying it was only the common law, and I've addressed that. It was wrong to do that. I've also addressed that point from the basis of saying even that this honorable court could have found against us, let's say, on the section 96 point, and still come to the same conclusion based simply on the common law. That's the second point. I've addressed it thirdly by saying the public protector could have come here and simply asked for the setting aside without any declarator for anything by anybody, and simply say she's seeking the setting aside of the suspension. So on those three grounds, it should be very clear that the existence of the order in 187.6 is not dependent on the order in 187.5 at worst for us. At best, it is not wholly dependent on the order in 187.5. Now, where does that then take us? It takes us to the following. The first, I'm not going to spoil Mr. Ngalwana's argument, but with his permission, let me borrow one of the points that he makes. If that is so, then we have an order under 172.2. Then that order, at least let me start with my argument. Then that order is an order for the dealing with the conduct of the president. But then what must happen? That's the issue. Remember, all this is not just for academic purposes. It's to answer the question whether Section 18 applies. All right. Now, the fallacy of the argument from the other side is that they want to read only 172.2a. They don't want to read 172.2b. And that is really the total answer. Because 172.2b makes this very clear. It says an order of any conduct of the president and so on must be confirmed, what have you. And then at A, and then at B, it says, and I'm going to read it because this is the crux of what I'm saying. A court which makes an order of constitutional invalidity. Let's stop there. In other words, there's only one court in this country that can deal with this matter under 172.2b. It is this court. So if we decided to go to Pretoria and say, no, we want the public protector to go back to work and so on, that court would say, but what are you doing here? It's very clear that it's only the court which made the order of constitutional invalidity that may deal with this. And so there are two arguments, mine and Mr. Ngalwana's. Mr. Ngalwana's is that that's exactly what this court has done in what I call the second part of the order in 172, or rather 187.6. Because this court has then given the second sub-order and said, this order now. Right? So this court could have said, conceivably, we're setting it aside, but we're not going to give any related relief. But this court did give the relief. It said it's effective now. So on Mr. Ngalwana's argument, then where's the problem? Because the court has pronounced on what must happen in the interim, so to speak, assuming there's going to be confirmation proceedings. The court said the effective date is now, and you can't change that. And but here, let's read on. Now coming to my take on it. They say this court, a court which makes an order of constitutional may grant a temporary interdict or other temporary relief to a party Let's pause there. This court may grant an interdict or other temporary relief to a party. Is the public protector a party? Yes. Is she seeking other temporary relief in the form of Section 18? Yes. So again, whether you look at it, take it from the point of view of Mr. Marwana or my point of view, there is no problem. Surely, but surely, anybody, any lawyer who is interpreting that, it amounts to this. Yes, the default position is in Section 2A, but then it says you never know what the circumstances might be. You might have confirmation proceedings. By the time they happen, let's assume it's about a child or whatever. The child is gone or whatever, or it's about a sick person or whatever, some emergency. And that's why the constitutional writers, in the drafters, in their wisdom, then empowered this court, which already knows the facts of the matter, which already is seized with the matter and knows the dynamics, rather than some court in Pretoria, on my example, which will have to go back and say, and basically redo all those arguments. No, it says this court, not even the constitutional court, this court that made the order may grant other temporary relief. How can, unless if you're going to tell that Section 18 is not other temporary relief, it is.
So if I understand the submission is this, where there is a declaration of constitutional invalidity, that order must be confirmed.
Yes.
In those circumstances, Section 172(2)(b is the equivalent of Section 18 of the Superior Court Act.
Absolutely. No, I'm not saying it's equivalent. Yeah, well, it's equivalent, yes, in the sense that it does the same thing. Yes, I understand. But what I'm saying, Justice Nogu, is that the drafters of the Constitution were aware, must have been, you see, when anybody who drafts legislation puts a thing like this, you know what they're doing. They're just saying, we can't think of all the examples of what might happen. So they say you may get
well instances where it would be unjust to wait for confirmation.
Absolutely.
And in those circumstances, the court must be empowered to give an interim.
Absolutely. And that's why they even went, it could have stopped there, Justice Nogu. It could have said, may grant a temporary interdict. But the drafters of the Constitution realized that the relief sought might not come in the form of an interdict. It might come in the form of a Section 18 application, as we're here now, for example. So that's why they widened it to say, or other temporary relief. I mean, that can mean anything. It could be an anti-pillar, it could be whatever. It can be wider than that. They could not have expressed it wider than that. And somebody is going to have to stand up here and say the other temporary relief that was envisaged in that phrase excludes Section 18 relief. What is that? Because Section 18 itself tells us that it is by definition temporary relief. If you go to Section 18, in all its incarnations, whether it's 18.1 or 18.2, the abiding words are the following. Unless a court under exceptional circumstances, the operation and execution of a decision which is the subject of an application for leave to appeal or an appeal is suspended pending the decision of the application or appeal. So that section deals with nothing but temporary relief pending the happening of something else, right? So in which world can we say that Section 18 postulates something different than other temporary relief? And then it says it may even adjourn the proceedings pending a decision of the Constitutional Court on the validity of that act. So in other words, pending, again, look at that word, pending, at 172.2b. So it's not you're going to give, in other words, if the respondents are correct, you would give the relief here pending a decision of the Constitutional Court on the validity of that act of conduct. That's why it's important where we started, because where we started, remember I say it's a 172.1, but I'm saying assume that I'm wrong. But this court is constitutionally empowered to grant temporary relief in the form of Section 18, pending a decision of the Constitutional Court on the validity of that act of conduct, if they are correct on their interpretation of the orders, which we dispute. But I'm at pains to go into this debate on the assumption that they are correct in their characterization of the order. I've told you the reasons, this honorable court, of the reasons why I differ with their characterization. But I'm saying throw that all to the dustbin and say that yes, what we're dealing with here is so-called ancillary order or whatever. But it's and it's one that needs to be confirmed. Whatever. That's the answer. It lies in 172.2.
So it's a very important point that you are making, Mr. Mpofu, and I think we just need to
sit on it a little bit, yes.
So you are content for us to determine the matter on the basis that Section 172.2 applies.
That's why I want you no, okay, let me explain myself. Yeah. I'm trying to be of assistance to the court, but by doing that, I'm not going to as much as I'd like to assist the court, I have to stay on my course. I'm saying, Justice, let me summarize it. I'm saying the orders must be read separately. The order in 187.6 is a self-standing order for the reasons I've explained. And I say that order derives, among others, from the common law finding made by this court. And that's crucial, because this court did make the finding of actual bias and
maybe I phrased my question clumsily.
Yes.
I think the applicant's case is still as stated in the papers. But if you're saying that if you are wrong on that,
I'm prepared. I'm saying even, yes, in fact, that's a better way. So even if I'm wrong on all those things, I'm saying then 172.2b. In other words, even if I'm wrong in everything I've said, 172.2b was designed for exactly this situation that we find ourselves in. Let's assume this court had said, Justice No, explicitly, which it didn't, by the way, and that goes to 5 Nyalwana's point. Let's assume the court had said, setting aside the suspension, another order. This order of setting aside up here is cannot be implemented until there are confirmation proceedings. Let's assume the court had said that. Unlike what the court actually did, which was to say it's effective now. And that's why I agree with Leonard Friend's point. Because this court didn't keep quiet on the question. It answered the question. But I'm saying let's assume it answered it against us and said, no, it's not effective on the 9th of September. It should be effective in November or whatever the confirmation proceedings. Let's assume that was so. We, in terms of Section 172.2b, justices, we would have been entitled to come here, right, and say, yes, we know that this is what you said, but here are the exceptional circumstances, what have you, and so on and so on. Please grant us other interim relief in the form of Section 18, and you say yes or no. That's exactly the purpose of Section 172.2b. Unless if anybody is going to say we wouldn't do that. If you had said specifically, this order shall not be implemented until such time that it's confirmed in the Constitution, we would still be entitled in terms of 172.2b to come here and say, yes, we heard you. However, the public protector, whatever the facts are, and you would have to evaluate those facts. If you like them, you grant us the relief. If you don't like them, you deny us the relief. Everyone will be happy. So it's a waste of time. This whole, it's just smoke and mirrors. this whole 172 thing, it's a red herring. It really has nothing to do with the application before us. The third issue, which, if this doesn't put it plainly beyond any doubt, then is the following. We know that what has happened in real life is that the DA and the president have, well, the president simply copied what the DA was doing. Well, let's just use one example. So that what the DA did was to file hurriedly. Let's leave all those things about whether they did it hurriedly or not. Let's assume that they did it after 15 days. But what did they do? They filed a notice of appeal and what? Alternatively, notice of application for leave to appeal. Common cause. Right? Now, what? And again, we've said those notices are not genuine, they don't make all the necessary allegations. In fact, they are not properly before the court. For example, the Section 19 application is supposed to state why you're not going to the SCA and going straight to the Constitutional Court. They didn't do anything with that because they were just rushing. So they left out all the requirements of Section 19. But again, today I'm in a good mood. Let's assume that it applies. Assume that it complies. Assume everything is perfect that they did. Well, let's go to the source, Section 18. Because I'm at pains to make sure that this clause is not waylaid into irrelevancies or fancy footwork, which is really all this is. This is just all this is an attempt, a very clumsy attempt to resuspend the public protector. This time, he being resuspended by the DA instead of the president. But let's see. But even if you do that, you must do it properly. That's what I'm saying. So let's read again, and I apologize for doing this. I'm now doing it for different purposes. The last words. Section 18. Subject to subsection 2 and 3, and unless the court under exceptional circumstances otherwise orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or for an appeal is suspended pending the decision of the application or appeal. So, if there is an application for leave to appeal or an appeal, that's exactly what they have done. They have filed an application for leave to appeal or an appeal. So, in which world then is what they have done? So, they can't say what they have done suspends the judgment. And in the same breath, say that Section 18 doesn't apply. Where's the logic in that? Because the real reason we know they did what they did was not for the love of justice. It was to secure a suspension of the order. But so they want to have their cake and eat it. So they want a situation where they do something with the aim of suspending the order. But what the law provides as an antidote for that thing that they've done, which is Section 18.1, must not apply. That's like wanting to fight somebody in a boxing ring, but they must be, their hands must be tied at the back so that they can't hit you back, basically. That's what they're doing. Because how can you have it both ways? How can you have it both ways?
As I understand, what they seem to be saying is that the effect of noting an appeal or applying for leave to appeal in respect of an order which is subject to confirmation, it does not suspend because that order is incoherent.
Good. If that's what they're saying, then I'm going home right now. Because if that is true, then we're dealing with an inchoate order. We're dealing with an order which is not a final order. Then what are we doing here? Because that situation is covered in section 18.2 of the Superior Courts Act. It says, subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order not having final effect of a final judgment, which is the subject of an application for leave to appeal or an appeal, is not suspended pending the decision of the application or appeal.
No, but then they say that that scenario does not apply here because here what applies is section 1722B. So the applicant could only come to court to say there is this inchoate order, but I can't wait. So I seek this interim relief or interim interdict, and that applicant is not done.
That's true. That's what we're doing here. That's what I'm busy doing right now.
They say you have come under section 18, which does not apply. It's section 18 of the Superior Courts Act. But in these circumstances, you could only come under section 1722B.
But this,
I'm just putting that.
No. I understand. That's why I'm saying
so that we
yes,
can engage.
I accept that, but that's the absurdity of the argument. Because they're saying we should come here under 172.2b. And I'm saying here, we're here under 172.2b to seek other temporary relief. So that's that's why I'm so indulgent on this argument. Because if they are right in all of that, then I'm saying you have to then say two things. This court would have to make something dramatic. It would have to say that the words other temporary relief in 172.2b do not include a section 18 application. I don't know on what basis you can say that, but it would have to say that first. Secondly, it would have to say the words appeal and application for leave to appeal in section 18 do not include the appeal that they have put. I mean, so in other words, you'd have to say the words appeal in section 18 have a qualification that we all don't know in the whole country. That actually you have to rewrite section 18. The court would have to rewrite section 18 and say which is the subject of an application for leave to appeal or an appeal, except for an appeal that is brought under section 172 by the DA and the president. I don't know, something like that. You'd have to rewrite the section. In other words, you'd have to qualify the words appeal and leave to appeal. Because an appeal is an appeal. That's what they've done. They have appealed, right? So the section 8, whether you look at it from the point of view of section 18 or look at it from the point of view of 172, you come to the same result, which is that if you look at it from 172 point of the vintage point, then you say this is exactly the temporary relief is what we're seeking here. If you look at it from the point of view of section 18, then you say the word appeal means appeal. And what did they do? They appealed. So, I'm sorry.
Did the DA appeal to the Constitution?
Yes.
Not to this court. So how can one use an appeal lodged to the Constitutional Court? Justifying people to get.
But there's no appeal here.
There's no appeal on the basis of no appeal.
Yeah.
Before us.
Yes, there's no appeal. That's not up here. Let's just be clear. There's no appeal here. There's no appeal in the SCA. There's just an appeal which they have, according to their logic, lodged in the Constitutional Court. That, Justice Francis, is exactly what is envisaged in 172B, if you read it A. Right? What does A say? It says that the thing must be confirmed not by this court, but by the Constitutional Court. Right? then you must go to 172.2d to clarify that question. 172.2d is the answer. It says, any person or organ of state with a sufficient interest may appeal, or underline the word appeal, or apply directly to the Constitutional Court to confirm or vary an order of constitutional validity by a court, which means this court, in terms of this subsection. In other words, the empowering section that allows them to lodge the appeal is 172.2d, on the basis they are any person or organ of state with a sufficient interest. For present purposes, they are a party, so they're a party. So the point I'm making, Justice Francis, is the following, and that's why it's there's no jurisdiction issue. When we come here, let's say, for example, they were appealing to the SCA, right? Which they would have to do because this is from a full court. And then they just decided they did just the right thing, not this other stuff that they did. Let's say they did the right thing and say on day 15 or whenever. We're not happy with this judgment, we're appealing it in the SCA. Then what must we do if we want it to be executed? We can't go to the SCA, we have to come here and say, in terms of section 18, this court must give us a section 18 order. Now, you can't then say, no, but they are in the SCA or the Constitutional Court or the Court of International Justice. It doesn't matter. The point is, an appeal is an appeal. The effect, and that, unfortunately, I don't know if the Tassima case, if I may actually just hand up some of our authorities, unfortunately, they are this morning from Johannesburg, so I'm not looked at them. Somewhere there, and again, to save time, is the Department of Transport versus Tassima. You'll find it's page 95 of that bundle of authorities. You'll see there, there's a discussion. I think it starts from paragraph 2. I want for the court with it. It's up to 40, up to about 50, where the court discusses the Klameza case, one of the leading SCA cases on this. Yes. Let's go to paragraph 49. This is what the Constitutional Court said. It is, sorry. Yes, it is now appropriate to revert to a consideration of the import of section 183, I'm sorry, section 18.3 of the Superior Court Act.
Sorry, paragraph, what paragraph?
49, my lord. 49, yes. Page 101 of that bundle we just
I've got it.
So, but what this court is called upon to determine in the context of this case is the import of 18.3. In particular, this aspect of the case raises the question whether an order made under 18.3 retains its legal force beyond the date of the decision of the appeal that finally determines the dispute between the protagonists. To answer this question, it is necessary to emphasize the point that all the subsections of 18 are interlinked and therefore to be read contextually. Let me just pause then. The conventional wisdom, which is correct, which was set out by Justice Francis in Canada and confirmed by the Constitutional Court here, is that if once you get the Section 18 order in the lowest court possible, the one that made the decision, let's say it was one single judge, the purpose is to suspend that order, and the appellant can go all the way. They can go, let's say, to the full bench here. If it was one judge, but it's still suspended. Go to the STA, it's still suspended. Go to the Constitutional Court, it's still suspended. Why? Because an appeal is an appeal. So if the section says it is suspended pending an application for leave to appeal or an appeal. So it doesn't matter where that appeal happens to play itself out, as it were. That's the import of what the Constitutional Court was saying. It goes on, but I'll try and save time. If necessary, I'll deal with it in the plan. But so there's no issue really, whether it's in the Constitutional Court or the SCA and so on. In fact, that's where by the definition, when it's called an appeal, it means it's in a higher court. It can be an appeal from the same level. So by definition, an appeal is in a higher court. So okay, let's just then go back to the point I was making. In fact, I think I'm done because as I said, let's keep the eye on the ball. What is the ball? Does Section 18, is there any, let me put it in the negative, is there any reason that we can think of why Section 18 does not apply, or why Section 18 is excluded from the other interim relief that is envisaged in 172(2)(b)? The answer to that is simply no. And as I said, you can look at it again from the other side. Is there any qualification to the word appeal or leave to appeal in Section 18? And the answer is no. And I'm happy for the court to look at it from whichever vantage point, because the result is exactly the same. So the Section 18 applies, there's no doubt about it. The only, if I were I'm not here to give them free legal advice, but what they could be saying is to say that when the court grants the relief, if the court says we're granting it with section in terms of 172(2)(a) to be read with Section 18, as we're saying, then they can say, well, it must be pending the confirmation proceedings and so on. That if I was them, I would make that argument, but it's not the one that is made here. So I'm not going to waste time on it. Yeah, so the question of applicability of Section 18 is very clear. Let's now go into the merits. And you see, this matter, you have to look at it in its true perspective. The reason why we're distracted with these gymnastics about whether Section 18 applies and so on is simply because there is no answer to the Section 18 application. And I will demonstrate that now. The actual Section 18 application, for all intents and purposes, is unopposed. And I will explain that, and I'm not exaggerating. Because they had no answer to the actual Section 18 application, they had to find all these fancy, that's why we say in our head, clever by a half. The 172 argument is clever by a half because you just dig yourself into the hole of the actual interpretation of 172(2)(b) in Section 18. Now, why is this? Why am I saying it's unopposed? Right, this court, I'm not going to bore the court by dealing with the test in detail, except to say this. I've learned this dealing with Section 18. In fact, one of my opponents, let me say, learned it the hard way because they pleaded only the what I call the statutory requirements, the 3 statutory requirements. And this was a matter that involved some mining matter. I'm digressing into it for a purpose. And as the court knows, so we had succeeded with the one judge, and then they appealed under the automatic appeal provision. And then they went on exceptional circumstances, no irreparable harm, and irreparable harm on the other side. And all we needed to do was to go to the, I think it was Justice Park, was presiding, was simply to say, well, yes, those are the 3 requirements, statutory requirements, but the courts have now infused a 4th requirement, effectively, which is the issue of prospects of success. And the court said, where have you pleaded that? And they pleaded it, and that was the end of it. I'm saying that in aid of the following. Forget the statute for now. Well, don't forget it, but read it together with the rest of the law. You might remember that when this was still, Section 18 was regarded as a novel invention back in 2013, 2014. Because we had just migrated from the South Cape case and Rule 4911. And one can never understand this area of the law without always going back. In the case of South Cape and Rule 4911, the distinction and our, okay, I won't let secrets of my team, but I was talking about this regarding the essence of what Section 18 is about. Section 18 is a departure. The only thing really that Section 18 has done is to depart from what we all used to do until 2013, which was to go to court and say you must do a balance of harm. You remember that expression, it was called balance of irreparable harm. So prior to this intervention by the legislature, you had to come to the court, this court, and say that the harm that I'm going to suffer if you don't grant this is more than the harm that the other side will suffer, right? The legislature intervened decisively. So we no longer, that's spelled out in Klemeza, spelled out in AfriForum, it's spelled out even in TASIMA. We no longer do a weighing exercise. What the legislature has done is now to separate the test. You have to prove that you will suffer harm, and you have to prove on the balance of probabilities that the other litigant will suffer no harm. So it's no longer, there's no weighing exercise anymore. It's this one will, in Klemeza actually it's underlined, in SNAPSA JA, underlines the word will and will not. And that is what we know in the business as the heightened test. That's really all that has happened. It has now therefore introduced the heightened test on the part of, because, why is that so? Because it has been said that this is not an ordinary remedy. The default position is that the winner must wait, basically. And, you know, I explained this to my daughter, who's not even a lawyer, and she understood it. To say that if we're fighting about a pen, then I win, and the pen is supposed to come to me. And you put an application for leave to appeal. If you had the pen, then you say, oh, well, I'm keeping the pen until the appeal. Why is that so? It's for a good reason. Because what would be the point of giving it to me, and then I use it and I write and I finish it, then you win some appeal a year later. So the law, the default position is that it must stay where it is until the appeal is. But I said to her, if I can go to the court and demonstrate that there are exceptional circumstances, that I will suffer harm if I don't get the pen now, and you will not suffer harm because you have 1,000 other pens. But for me, that's my only pen. Then the court will say, okay, you Mr. Mpofu, you can have it. That's all really. That is all. So the default position, all the law said is that this default position must be departed from, not so much after the so-called weighing exercise, but the test is higher now. I must show harm on my side and no harm on the other side. That's all. So where are we then? Taking it back to this case. We have said, and if the court wants us to, again, I don't want to waste the time of the court, but if there is a case that has exceptional circumstances, it is this one. This case, all that anybody has to do is to read the judgment and understand, and I'm sure my learned friends are going to deal with that extensively because they feel strongly about it as parliamentarians. But let me just give you some of the highlights. What have we got here? We have a situation unprecedented where the president of a country, what Mogoeng CJ called the highest raw state power, has, according to this court, abused that power, acted improperly, actual bias, also reasonably apprehended bias, also a breach of section 96(2), because this involved his personal interests. That's what we have here. Now, we are told that those circumstances are just, usual. This happens every day.
But what is the argument that the exceptionality of the circumstances must be relevant to why it is that the default position must be departed?
No. Well, firstly, I don't know where that comes from, but yes, that was the argument. But the argument is very simple. That the law is very simple. That and it is what we have put in as a preamble in our heads, so that it's clear. And this is the relevant, or how relative, or maybe I'm calling it. So this statement has been endorsed by all the courts, from Sutherland and Jay in Quebec. It says, necessarily, in my view, exceptionality must be fact specific. Okay, that's the first thing. The circumstances which are or may be exceptional must be derived from the actual predicaments in which the given litigants find themselves. Who are the given litigants? It's the public protector, the DA, the president. The primary, the primary litigants is the president and the public protector. The other parties have joined one side or the other. Really, it's just now we've got the tail wagging the dog, so to speak. But that's a story for another day. So the actual litigants, for the purposes of this, again, let's assume that the DA is the primary litigant. All that is said here, Justice, is that exceptionality must be relative to them. And I'm saying, I'm talking about one of those litigants called the president, right? And I'm saying what has been found here, just dealing with the issue of exceptionality, I'm saying that it is the most exceptional thing to happen. we have said in the founding affidavit, this case is even more exceptional, to use that word, than the EFF Nkandla case, which it follows. And when we say that, we're saying it's a tool of analysis. So we're saying, for example, if you think that the Nkandla circumstances were exceptional, then it's not logically possible to think that these circumstances are not exceptional, because these are 10 times worse than what was found. I've already alluded to the fact that Nkandla was only about the low threshold in section 96.2. There was no finding of actual bias there. There was no finding of impropriety. There was no finding of effectively malafides, an improper motive or ulterior motive. It was simply an appearance, a risk of conflict is sufficient. It doesn't even have to materialize. Here, we have the worst end of the spectrum. If this is a scale of 1 to 10, Nkandla is at 1 or 2. This case is at 10. Full throttle. Because it's got everything. What more can you be guilty of? 96.2, apprehension of bias, actual bias, ulterior motive, bad faith, and abusing the state machinery. And I'm saying this, let me make this statement, and I'm making it boldly. This case involves abuse of state power. Nobody in their right mind can dispute that statement. But what kind of abuse of state power? It is the kind of abuse of state power which amounts to the highest form of corruption. Because there's this notion that this case does not involve corruption. When you abuse state power, whether you are taking a bribe as a traffic police person, or giving a tender to the wrong person, or suspending the person who is supposed to investigate you, all of those people are doing exactly the same thing, justices. They are abusing power that we gave them as citizens for personal gain. That personal gain might be 100 Rand in the traffic cops example, might be 1 million Rand in the tender person, and it might be whatever amount it is here in the Pala situation. If you don't believe me, you must believe the Constitutional Court. Because this is what the Constitutional Court said in the United Democratic Movement, the Speaker of the National Assembly, 2017-5, SA. Okay, they've got the wrong one. It says SAZ, ACC, paragraph 6 and 7. I'll give you the law report citation. I think it's 2017-3 SA, page 300 CC. But the if that is not the correct citation, I'll give it now. This is what, in that case, I hope this time Mr. Butlander will not forget, because he was my engineer in that matter. This is what the Constitutional Court said. This is the so-called secret ballot case which we did in the Constitutional Court. And it explained the linkage between abuse of power, abuse of resources, state resources, power that you have been given in that office, and what I call effectively corruption. This is one of the most profound statements ever made in our courts against this kind of corruption. It was directed at the president. You'll find that, my lords, at page 12 of our heads, paragraph 45. And I'm going to read it slowly because it's the heart of what I was saying. The president is an indispensable actor in the proper governance of our republic and bearing important constitutional responsibilities. And I jump some parts. Then it says public office in any of the three arms comes with a lot of power. That power comes with responsibilities whose magnitude ordinarily determines the allocation of resources, money, for the performance of public functions. The powers and resources assigned of each of the arms do not belong to the public bearer of the office. So there's some black protector there as well. Public bearers who occupy positions of high authority therein. Let me just repeat that. The powers and resources assigned to each of the arms do not belong to the public office bearers who occupy positions of high authority therein. They are therefore not to be used at the advancement of personal or sectarian interests. Amanda awethu, manda diashu, matakiarona, or matima yaina, power belongs to us. And Maibuye, Africa, restore Africa and its wealth, are much more than mere excitement-generating slogans. They convey a very profound reality that state power, the land, and its wealth all belong to we, the people, united in our diversity. These servants of the people, are supposed to exercise the power and control these enormous resources at the beck and call of the people. What the Constitutional Court was saying there is that if you are given power to be the license giver, the tender giver, or the traffic police person, that power does not belong to you. It is state power. And it comes with resources that we all invest to make you the president or whatever office you hold. And we put millions of money and prestige and all that around that office. That power should only be used for its intended purpose. Once you use it for personal gain, you are stealing our money, right? You are taking away what we said. We are giving you 100 million rand so that you can grow some forests or whatever it is. And you take that 100 million rand and you use it for personal gain. That is theft and corruption. That's what this passage is. Now, if that is not exceptional, even when it is performed by the highest office in the land, well, then we can all go home and it's fine. Then we'll accept that.
But how does that answer the question as to why can't the applicant wait until the appeal is settled?
Okay.
Because I think that's
yes. Okay. Then let me come to that. Okay. Then let's take a word, Justice Mugu. Wait. Right?
I borrowed it from you from example about the pen.
That's fine. No. I'm okay. I'm taking it back. I'm saying let's share it. Wait where? That's because that then touches on the issue of harm, Justice Mugu as well. Wait where? She must wait in the condition of being suspended. That's where she must wait. She must wait in the degrading and undignified position of her dignity being vilified. She must wait where her reputational rights are being infringed. She must wait where her right to work and practice her profession and occupation is being taken away from her. That's where she must wait. And the point I was making, Justice Mugu, because I was coming to that, is that who is this person who must wait? It is the person who is the victim of the most egregious abuse of power ever seen in this republic. And we say, no, it's fine, she must wait. And the person who says she must wait is the person who put her in that position. So effectively, what we are then saying is that the victim of the abuse that I've just described now, of the corruption, of the theft of public money, the target of that abuse of the highest form of state power must wait.
Right, Mr. Mpofu, we are going to take a tea adjournment. May I ask that during that tea break, you now amongst yourself agree as to until what time so that
Yes.
we can then
So,
work.
we will do so. How long is the break?
We'll reconvene at 11:30.
As cost business.
Just sign up.
You may proceed, Mr. Bolton.
Thank you.
I understand that there might be load shedding around 2. I don't know what we are going to do if that happens. But perhaps we'll see.
Yes. Thank you, Justice. Well, I'm going to just want to round off this issue of exceptional circumstances. What I'm saying is and I'm responding directly to the question you raised, Justice. When we look at exceptional circumstances, according to the formulation of Sutherland J, we must look at what he calls the actual predicaments of the litigants. So the actual, and that's why I'm saying this overlaps fortunately with the harm issue. So I don't have to repeat the submissions. But the predicament of these litigants is what when we took the lunch, rather the tea break I was talking about. The predicament of the public protector is that she is sitting for 3 months and a week now. 3 months and 1 week in the position, in the circumstances that I described, where all she has ever done was to do her work, according to the judgment at least. The thing that put her in that position is that she was discharging her duties to investigate without fear, favor, or prejudice. In a nutshell, that's all. So that's her predicament. Then let's look at the predicament of the DA. I don't know what it is, I'm sure we'll talk. The only predicament of the DA is vindictiveness and vengeance and hatred and all of those. Because the DA has already had, as you said, the history of the matter is that, and that's in the judgment as well. From day one, they've been hounding Advocate Mhlabane. And to the extent of having the court can take judicial notice of the fact that when the announcement was made of the suspension on the 9th of June, the leader of the DA was on national television saying that they are popping champagne. And the reason they were popping champagne is because they are the complainant, coming to the facts of this case. They are the so-called complainant that brought about the Section 194 committee, which in turn brought about the suspension. So it goes back to Justice Likuleni's question in the morning. None of these parties here are not conflicted. Their interest is a perverse interest to ensure the oppression of a black woman whose only sin is to do her work. So we have to accept that as the starting point. And then we say, no, fine, let's leave it like that. Let's leave it like that's exactly where they are. So that in the next 3 months, in fact, up to the point, one can only speculate. Remember the so-called presidential minute, Justice, says that
there was just a note to say that there's a court which might not be affected by
load shedding.
Load shedding, but I don't know if the logistics will permit.
Yes, hopefully, yes. Okay, but at least they know there's a plan B. So the point I was making was that the DA's interest, apart from the perverse interest of just wanting to see the public protector suffer, is that as I said, as a complainant in the Section 194 committee, they aren't necessarily conflicted. And in fairness to them, they accept that in their papers. They say that it was the DA that brought the Section 194 committee proceedings. There's no other interest. They don't claim any shame. They don't. They just say it's all the other South Africans and what have you. Well, the law is very clear. The predicament of the litigants. Yeah. So that's where you start. Of course, I'm not going to stand here and say, if you have a predicament as a litigant, you can't then say, well, in any event, that also affects the wider society and whatever. But that can't be the only thing you're bringing here to the table. To say what the starting point, what is the predicament of the DA and the harm that they will suffer? Zero. But if they had some, and then they say, well, on top of that, you can also look at this one, that one, that one. Then it will be zero, zilch. So this is the classical.
I'm not oversimplifying it, Mr. Mbofu, because in their papers they seem to suggest that her going back to the office might have impact on the witnesses who might testify.
Yeah.
And this is a matter that has not been dealt with on substantive reasons for her suspension.
Yeah. Yes. Let's assume that is so. What is their interest? I'm saying well, firstly, that only confirms what I'm talking about when I talk about the perverse interest. Because when they say that, Justice Snook, they are confirming exactly what we're saying, that they want to suspend her. Because what you've just told me now, those are reasons for suspension. Interference, classical reasons for suspending a person is interfering with witnesses or evidence and so on. So in what world are we going to give the Democratic Alliance the power which the Constitution decided exclusively lies to the President of suspending for the reasons that you just mentioned? They can't. Neither the Democratic Alliance and, with the greatest respect, this court has the power to suspend the public protector. For whatever reason, doesn't matter. Let's say she's going to go there and shoot everyone, or whatever. The Constitution has decided.
She's going to go there and shoot. That might well be a reason why she should wait until.
No, I'm making a different point. You know.
I'm saying that lighthearted.
No, I understand. I'm saying that let's assume she's going to do that. Okay. It's the classical what they say in the streets. So what are they going to do about it? It is not for the Democratic Alliance. It would be, even in that situation where she's going to go and shoot everybody, the only person constitutionally empowered to intervene is the President of the country. There's a reason why the Constitution did that. There's a reason why the court itself cannot do it, or the person next door, or the inspector of whatever. There's only one person constitutionally empowered. So if this court is going to allow the DA to suspend because it feels that she's going to interfere with witnesses, against that's an insult to this court, because this court, with everything that they've said, made a decision that the suspension must be set aside with immediate effect. But no, the DA says no, but what about, there's no parking there or whatnot. So it's the DA now that must decide. Well, that's wrong, because I say not even the court is empowered. So it's not simplifying it, Justice. I'm asking a very simple question. What is the harm that the Democratic Alliance will suffer if the order is granted? There is none. Okay. Now, and I was saying that this is the classical case that was envisaged by the drafters of Section 18 of a situation where the loser, the losing litigant, has no harm that will befall it. And the victorious litigant has obvious harm. And that's why I'm conflating, I know, the issue of exceptional circumstances, because these issues are related with the issue of harm as well, so that we can save time. So I'm saying that apart from the exceptional circumstances, which I would have thought speak for themselves and which I've spelled out of this particular case, there is patent harm to anybody, by the way. It doesn't have to be the public protector. I gave this court cases that show that that come from the statement that says suspension is the employment equivalent of arrest. That statement is very profound, because what it means is we as lawyers maybe know about arrest more. Arrest is prima facie harmful, right? So suspension is prima facie harmful to you because it affects your reputational rights, it affects your dignity. I gave the case of Maseka. Justice Sachs said that an incumbent does not live by bread alone. So the fact that the person is getting paid is neither here nor there. It is what goes with the office. I gave you the case of Wachenuka, Home Affairs versus Wachenuka. The judgment of Justice Nugent, who said in paragraph 27 of that that a human worth, self-worth, is work is about self-worth. I gave you the case of it's the Northwest, I think it's more it's one of the cases we cited previously, where this thing about suspension being the equivalent of arrest comes from. So, it would be so cynical to ask somebody who's been suspended that what harm are you suffering? You just find you're on holiday. Because our courts, I'm sure, are not that insensitive. And the fact that there is no harm on the other side just makes the question, the point very clear. As we speak, the public protector is watching all this from a sick bed because of her health. She would otherwise have been here. But she doesn't want to be neither on her sick bed or here. She wants to be where she was, the job she was appointed to do by the people of South Africa, which is to protect them. And therefore, that's the situation where you can ask for the wider harm, because you must first show the harm to yourself. And then you say, then there's also harm to the office, then there's also harm to the public, which we again, we would hope that would be self-evident in this case. Quite apart from the fact that, as I said, the court has made a decision, correctly so, in my respectful submission, that a victim of this kind of abuse must the effect must be immediate. Now remember this, I said this the last time. In our law, the only reason that this court did not give an order of retrospectivity, and we support that, by the way, of this court, was because, as courts usually do, I think this has happened in the DPP cases. So they say, okay, this DPP was not right appointed or whatever. Then they can't say, well, it's a retrospective effect because that means all the criminals were being prosecuted and say, well, you were prosecuted by the wrong person. So this court did the right thing. But it must not detract from what it means, an order of constitutional invalidity. I explained it. An order of constitutional invalidity does not go back to the date of suspension, ordinarily. It goes back to 1996, when the Constitution was passed. That's how it, otherwise it nullifies, that it's like there was no suspension. It did not happen, constitutionally speaking. So that's where we are. We know what that means. If, to go back to our example of assessment, it turns out that tomorrow the public protector is going to shoot everybody. All this court has said, it didn't say then she must not be suspended lawfully so. No. It says she might, if she's going to be suspended, it must be a suspension that is lawful. In other words, by a person who's not convicted, who doesn't have an improper motive. So let's not, we can't exaggerate a situation A that has not happened, or B that if it happens as if we will be helpless. We won't. The issue that we want to undo is the effect. Let me put it this way. What you are being asked to do by them is to basically resuspend her, but through the DA or the president, the same president who is convicted, now what is going to suspend her. Instead of using a letter of suspension, he uses something called a notice of application for leave to appeal. It's the same thing. That's all they want. The DA, again, to his credit, if I can use that, says so in its letter, the letter to us on that day. Remember what they say, Justice. They start by saying 172. We tell them no, it doesn't apply. A few hours later, they put the notice of application for leave to appeal. And then BDA BMDA 4, page 104. Then the truth comes out. They write at, let's say, 3 o'clock, judgment comes at 2:30, 3 or something past 3, they write to us and tell us the story of 172. An hour later, we write to them, we say, you've misread the law. And then this is what they write to us in the evening at 1:04. If your client is correct and the High Court order is not subject to confirmation by the Constitutional Court, the High Court order is in any event suspended by our client's application for leave to appeal. Paragraph 5 shows the real motive. In the circumstances, whomever is correct, the High Court order is not presently operative and your client's suspension from the position of public protector remains effective. That is the purpose of this entire exercise. That's why we're here. Maybe it was a slip of the tongue, but they made it clear here that the so-called appeal is just a route to paragraph 5, which is the client's suspension from work. That's what they're doing. And it will allow them, anybody, really, to abuse the law to that extent, by clothing them with powers that they don't have, of suspending a person who has been unsuspended, quote unquote, by the courts. Then we will deserve to have a banana republic where people can just do, use clear subterfuge, very clear, undisguised, where they say themselves in their own words. This is not me, this is them saying it, to achieve nefarious ends. So none of these parties are here with clean hands. They are conflicted. They have they're abusing this expression called abuse of court. When we explain it to students, we explain it in simple terms. Abuse of court, of the court process, means this: using the machinery of the courts not for the purposes that it was intended. So you use section 18, not for the purposes that it was intended, but you use it to resuspend a person, as they are saying here. That's classical abuse of the court process. But as if that is not enough, in the case of the DA, they then come here. They then come here and, in line with what Justice Noku is saying about witnesses and what have you, they come here and seek to deceive the court. They give 400 pages, I think. Now, this record has got 9 volumes now. Half of volume 3, volume 4, volume 5, volume 6, volume 7, and yes, up to the things that should not be before this court. It's just obfuscation. They give you those hundreds of pages of so-called evidence that's happening in the Section 194 committee. This is the agent court. And you give 400, 500 pages of irrelevant stuff, and then they apologized yesterday for doing so. Now, let me tell you where the deception is there. That is supposedly evidence. Let's assume it was relevant for a minute, which it is not. It's evidence, affidavits of some of the witnesses who have given evidence in the Section 194 committee. Just their affidavits. The fact that they've been cross-examined, some of those statements have been retracted or contradicted and so on. No, you're not given. You're just given the raw statement as if that is all they have. If they really wanted to inform this court about what's happening in the 194 committee, they would have given you the record. And say, this is the record. Witness number 1 said this. This was the cross-examination. This is what happened. Witness number 2. No. They come here in motion court and simply give you the unadulterated version. That shows again the perverse interest that and I want to say this. If the court stands by and allows itself to be abused like this, firstly, this is a waste of valuable judicial resources. The fact that we're here for some simulated so-called appeal, which is a fake appeal. It's not a real appeal. It's just something make-believe. And then in that process, we are then saddled with hundreds and hundreds of irrelevancies and what I call clever points, which take us nowhere. Then we have something coming. So let's move then quickly to the last point, which is prospects of success. Now, here we have summarized the position. Because of this rushed job, maybe, they again shot themselves in the foot. Because all that has been done, really, they just say, okay, the court was wrong to find that there was no reasonable harm. That's called the ground of appeal. How can, where are they saying there are prospects of success because there is this or that law, or the court misdirected itself, or did not read this document or that document in terms of the Fiumayo test or whatever? No, because there's no such thing. This court has said something very profound. I think it's a paragraph 155 or 157. That there is no other plausible explanation for the conduct of the president other than the fact that he was abusing his office. He was abusing the power that we gave him as South Africans to be the president and therefore be the person who is mentioned in Section 194.3 to shield himself away from the investigation of his Phala scandal. That's all. So where we should be getting an analysis that say, no, the court got it all wrong. So there are prospects of success because here's the plausible explanation. This and that and that. But it's the reason why that is not done is because it does not exist. There is nobody in their right mind who can find a plausible explanation for this. Knowing, and this is pointed out in the judgment, knowing that there's a judgment which is coming. Let's say, for example, he didn't know that it was coming on the 10th. Knowing that there's a judgment that is coming imminently, soon. Knowing that there are undertakings, and I know the court made its own findings on that, knowing that there's an undertaking that might suffer whatever defects the court found, but there's an undertaking nevertheless that will give you some pre-warning of the suspension. Knowing all that, and then you get being a party to the litigation. It's not like some other person who's not a party. You are a party to this litigation. You have been all along. You yourself have said that if that conflict ever arises, I will delegate it to somebody else. And knowing all that, you issue. And the president says the following. I mean, honestly, he says, I did not know that the judgment is coming tomorrow. And let's grant him that. So I went to the assembly, I addressed the assembly, and only then did I learn, because of some coincidence, the 1434 effect, as we say. The court here issued the thing at 1434, and the letter also came out at 1434. Let's assume all that is coincidence. But this is what he's saying to the court with his straight face. When I realized in the afternoon, when I finished in the National Assembly, that the judgment is coming tomorrow, the following day, I just went to bed. Who does that? How could, let's think about the President of the United States, or even here, where there's capital punishment. So let's say the President, our President, let's say we still have capital punishment. He says, I've signed the letter of execution for the person. I signed it at 3 o'clock. I didn't know that there's new evidence. I went into Parliament. But at 6 o'clock when I came out, I was told that, no, that is the wrong person. It's not the person who killed. The real killer has confessed. And he says, well, I've signed the letter. There's nothing I'm going to do. Kill him. That's what we're being told. That even when he discovered afterwards, he didn't have it in himself as a human being to say, oh, well, if the judgment is coming tomorrow, I'm withdrawing my letter or whatever it is, and I'll reissue it after the judgment. Just out of respect of the court, if nothing else. Don't worry about respecting the public protector. Just out of respect of the court to say, I'm withdrawing the letter, I did not know, genuinely did not know, and we will see what the court says tomorrow. If the court says I can suspend, I will suspend. If it says I can't, I won't. No. He said, let's watch the news or whatever. Now, this is, we are told that on those facts, there's prospect that another court can find what? That on his own version that he knew after the National Assembly address and did nothing about it. That on his own version, not forget about us, write us off. On his own version, he, by that one single act of omission, would he have done that if he had the Ubuntu and the empathy to know that this suspension is going to befall all the consequences and go on for 3 months and so on.
But then was he not conscious of issue after the letter was issued?
No, yeah, Justice Lekulen, you know, those are nice Latin terms, functus officio. But we must never entrap ourselves in those things, because technically the rule of functus officio is defined in this book that Mr. Bishop agreed that he'll give it to me when I need it. Administrative law in South Africa, Cora Hoekstra and Telford, as this. Once a decision maker has made a decision, a court, let's use the court. Once the court has made a decision, that's it. There's nothing you can do about it. And it is the origin of, for example, Rule 42. The first words you will get in the commentary on Rule 42 will be about the functus officio rule. It says it's a D1-561 of Erasmus. The general well-established rule, and the point I'm really making is that we have all these general rules with nice sounding titles, but they all have exceptions to cater for the kind of thing I'm talking about. So the general well-established rule is that once a court has duly pronounced a final judgment or order, it has itself no authority to set it aside or correct, alter, or supplement it. The reasons for are twofold. The court becomes functus officio, and its authority over the subject matter ceases. Secondly, the principle of finality in litigation expressed in the maxim, inter res re publicae ut sit finis litum, in the public interest that litigation be brought to finality. And then it says, that's exactly why we have Rule 42. So that in certain circumstances where you are able to show that despite the functus officio rule, the outcome is going to be oppressive if the court, the very same court that said, we're done, goodbye, comes back and says, we will listen to you. Because legal rules are about justice, not just about mechanical applications. So imagine who would have said, I think, speaking as a citizen now, everyone would have said, what a great president we have. Nobody would have said, but what about the functus officio rule? If he said, I came out, my office didn't tell me, in the evening I discovered that a court of law, you know, a full court is going to give judgment tomorrow on this very thing that I was intending to do. And I'm saying I'm withdrawing the letter, and the judgment was at 8 a.m. or something. At 10 o'clock, I will make an announcement one way or the other, depending on what the court says. No, then we say, no, the functus officio rule, no. That would have been the proper responsible thing to do. And it would have been the opposite of a breach of Section 96(2). And it would have demonstrated the exact opposite. So what am I saying? I'm saying that there is no prospect, and that I'm deliberately using the president's version, because I can come here and tell you about our version. You know our version. When you know our version is that this whole thing was just a pala hit back and so on. I don't want to go there. I'm saying use their own version. You can't change the facts. That's one thing we know as lawyers. When you go and appeal, you can't change. The record is the record. And the record says that he became aware of it on the 9th in the afternoon on his version. So the prospects of success, with the greatest respect, are zero. Particularly on the question of reasonable apprehension of harm. I'm sorry, reasonable apprehension of bias. So let's say all our theories are wrong. Because remember, we say it's actual bias. We say he knew and he did it deliberately. Assume we're wrong. Who can say that there's no reasonable apprehension of bias for his failure to act overnight? Who can say that the breach of Section 96(2) did not happen where the threshold is lower than low? The threshold in 96(2) is that if there's a risk of a conflict, you must not act. And the EFF Nkandla case says that risk doesn't even have to materialize. So all you have to say is, what will people say if they know that I've got these 31 questions from this person and I'm now about to send them and there's a judgment that is coming? What will people say? They might be wrong, those people. They might be crazy. But what will it look like? That's perception, reasonable perception. To a reasonable person, what will this thing that I'm going to do to this person look like? So there's no issue. And by the way, this issue of prospects of success was not done, it was not added by the courts to amend the legislation. The legislation still has the 3 elements. But again, like everything in law, the courts were saying, look, we can't just be abused. You can't just say, when, you know, the court says the sky is blue, and then you say, I'm appealing. And then they say, okay, for the purposes of the appeal, the sky will be red. You know? So it was meant for those kinds of absurd cases where the court could, it basically was entitling the court to say, no, but we know you filed a notice of appeal, but it's so hopeless. It's, you know, there's no court that's ever going to say the sky is not blue. So it's meant for those. Otherwise, the statutory requirements remain the statutory requirements. They are onerous enough on their own. But we accept that the courts have added this, and we don't quibble with that. We remember that Justice Sutherland originally said the issue of prospects of success does not come into it at all. But Justice Binsward in this division found differently in the Justice Alliance case, and the SCA in AfriForum and Kemeza found that, and this division, with the greatest respect, has been leading in this area of law in that respect. And I've taken the liberty in my head to refer to the judgment in Eitzach, which is also in Erasmus, which you can, even if you are the loser in an interim order, you can still invoke Section 18. And the reason I put it there is because the judge who made that profound decision was none other than a certain Masuku AJ. So there has been great developments in the so what acting judge Masuku was explaining was a purposive interpretation, that the purpose of this thing is to protect litigants. So we mustn't mire it in technicalities. But and that's another great contribution from this division in this area of law. Let me deal quickly with the question of costs, and I'll deal with it again in reply, but in fairness, so that my learned friends can respond. Let's take the big picture. What's the big picture? The big picture is that we have been brought here by, you know, the irony is this: the underlying problem with the judgment, or rather with the conduct of the president, was the hurried nature of his suspension, which was clearly intended to run away from accountability. We are back there right now. We have another hurried suspension, quote unquote, or resuspension by the DA. One can ask the following question rhetorically, hopefully, so that it doesn't need an answer. The Democratic Alliance assumed this was a confirmation process. Two things should happen. One, if it was a 172.2 matter, then the law says in Rule 16 that the registrar of this court must take that order and submit it to the Constitutional Court. So why did they not wait for it? Rule 16 says that in 15 days, they can appeal. So why did they not wait for that? Why did they have to do it in 3 or 4 hours? Why? And do a shoddy job at it of not even complying with the section. There can only be one answer. To borrow the words of this court, there is no other plausible explanation for that hurried activity of the DA, apart from what they say in paragraph 5 of their own letter, which is to revive the suspension. So the court does not allow this kind of thing. We would implore this court to mulct these respondents with punitive costs. And we don't say this lightly. You know, Justice Madlanga said in the case of the public protector versus the South African the Commissioner for SARS, that it has become fashionable, I'm paraphrasing, to mulct the public protector with punitive costs, personal costs, and so on. And the basis, for example, and he said that this must stop. And he said the one case in which the Constitutional Court had endorsed such an order was the Reserve Bank case, especially RB versus 2019, volume 6. Oh, by the way, the reference to the UDM case, I just got the volume wrong. It is 2017-5, not 3. SA, and the page was correct, 360. But so what Justice Madlanga was saying is that it should not be so easy to mulct the public protector with cost. And the justification that was given to the bias and reasonableness. Now here, and actually I'm glad that's what they said, that I can make this point. We've alluded, for example, to a cross appeal which might come from us. We ourselves are not are aggrieved by the judgments of this court, by the way. And that's why we are talking about the possibility of cross appeal. In respect particularly of the interpretation of section 194.3a. And this issue I was talking about of the interpretation of the agreement between us as council and government. Many issues, the sub judice rule, or what have you. But on the, assume, let's say it was us that we were appealing. According to this interpretation, that should suspend, we should do that appeal and then run away from the office. These are some of the absurdities of this case. But I'm making that point to say that there might be a cross appeal, which we're very confident about, by the way, on some of the other points. That even makes the case for the possibility of the prospects of success even bigger. Because if we have any prospects of interpretation, or whether there was a removal committee and so on, then that makes the situation even better for us, in the sense that we now have prospects of success. The prospects of losing again, even on a different point. Let's assume they had good prospects of success on this conflict point, but we have good prospects of success on the 194 point. It cancels out, and therefore, whichever way you look at it. So we implore this court then to say that if a person who was biased, such as the president, and who acted unreasonably, can escape the clutches of an adverse cost order, that's exactly why these parties do this. That's why they bring us back here. They say, further road and smaller child. So if the court at some stage, and we accept the issue of judicial restraint, but there must come a point where the court says this far and no further. We're not going to be abused day in, day out by people who should not even be here trying to achieve what is unlawful by using the court just as a conduit fight, of doing exactly what the court has said must not be done. So this is, with the greatest respect, the matter where on the merits at least, there is no defense that has been mounted on any of the requirements. And this is the classical case where the court should grant. This is the reason why Section 18 was promulgated. Let me put it that way. This is exactly that reason, where there are exceptional circumstances, no harm to the other side, palpable harm to the one side. That's what the legislature wanted to achieve. Let's not stand on the way of the legislature. Yeah. Okay. Well, for what it's worth, since there was mention of weaknesses, I'm reminded to point out that we have made it clear in the affidavit that in terms of the Section 194 committee, there's only 1.5. There's a witness who needs to be cross-examined, and then another one who's going to talk about the costs and so on. But there's basically half a witness, let's say 2, so that I don't have to split hairs, that are left. So there's no suggestion that those witnesses would be intimidated. But really, as I say, all those things, they have their own recourses. So if there's a witness who's intimidated, they know what to do. They go to the police station or do whatever they need to do, or tell the chairperson of the community. But we can't keep the public protector in the dungeon simply because there's some theoretical possibility of some unnamed witness being so-called intimidated. The nullity is a nullity. That nullity, which was the suspension, must be visited with nullness, which is voidness, and the fact that, quite frankly, we should all erase it from our collective memory. Something that was an unfortunate event, but which has not happened. And the only way to do that is for the restoration of the status quo ante, in respect of which Section 90 of the Constitution is there, and there are all sorts of other avenues. So it's not for this court to try and prevent some theoretical things that we don't know. This court must simply apply the law. Section 18 has requirements. Have those requirements been met? Yes or no? If they've been met, then the court must do Section 86 must be done. And the court can be assured in that by the fact that there are safeguards which are in Section 18. Those safeguards, the first safeguard is the one we're debating here, which is the high standard of owners that the legislature has introduced. The second safeguard is the safeguard of automatic appeal. So they don't even have to do applications for leave to appeal in terms of Section 18.4. It's an automatic appeal. The third safeguard is something that's unprecedented in our law. I've never seen it in my entire life, where it says that that appeal must be heard as a matter of extreme urgency, not just urgency, extreme urgency. In other words, the court must stop everything. So those are the safeguards that that are available to the other side. But public protector is no safeguard. The only safeguard is the 3 justices sitting here, simply reiterating what they said so emphatically last week, which is that the suspension was set aside. Let me to say a point, then he's lost his his pen. The order should then be simple. Leave should be granted, and leave to execute and operationalize the order. And we'll accept that instead of being effective last week, as the court intended, to be effective when this order is granted. And with those, oh yes, I forgot the fourth safeguard, of course, is that they would have, whichever way, they would have achieved what they were trying to do. Because the fourth extremely urgent appeal, the judgment will be suspended. There's nothing we can do about that. It's unfair, it's unjust, it's oppressive. That's what the law says as a safeguard for this kind of situation. It's cruel, actually, but as you say, it is what it is. Maybe one day someone will take Section 18 forward for constitutional scrutiny, but until then, that said situation will prevail. But, okay. Let's go with this. Oh. Malena Junior was saying it looked like Justice Lekuleni wanted to ask me a question.
No.
Maybe he's having mercy on me. I wanted to bombard him.
No, I'm covered. Thank you.
Escort business.
Thank you, Mr. Board.
I'm in the technical.
Thank you, Mr. Malana.
Thank you. My time is 12:31. I hope to be done left to my own devices by 18 out. That's exactly.
That should be in order.
I'm sorry to disturb Mr. Navan. I forgot you had given me a task during the break to speak to my Leonard colleagues. We had a small meeting, justices, and we agreed that we will stick to the times, but we thought that in fairness we should make it clear to the court that if those times are stuck to that we've agreed to, there will be a spillover. There will be a spillover after, but otherwise we'll stick to the collective times on this side. So.
All right.
While we deal with the housekeeping matters, I still have to check out the hotels. We're asked to be excused after the event of this one, so I'll point it here and find it. Justices, we address the issue of exceptional circumstances, as well as the intricacies of the interplay between, on the one hand, Section 15 and Section 18 of the Superior Courts Act, and on the other, Section 172 of the Constitution. I shall only be dealing with the exceptional circumstance aspect of our part. Mr. Masuku will be dealing with the intricacies. The idea is to try to lay a foundation for you in order to pursue the 172, 15, and 18 part. Of course, I'm sure he will be guided by what Mr. Popo has issues. The Supreme Court of Appeal in the Teresa judgment has set the standard for what exceptional circumstances are. I shan't take you to that. The case is well known. It refers to various other judgments, both of the High Court and Supreme Court of Appeal. I'll simply give you the citation as indicated, but for the sake of completeness, it's 2017 Volume 5 of South African Law Courts. Judgment begins at 402. The Supreme Court of Appeal. Relevant excerpts begin at paragraph 34 until the end of that judgment. The application justice is extraordinary. It is extraordinary for its novelty. Never before has the head of a Chapter 9 institution been in the crosshairs not only of the president of the country, but also of the main opposition party at the same time for different reasons. The undisputed facts in this case demonstrate, with respect, a sitting president determined to go to the ends of the earth to protect himself politically, even if he trashes the Constitution in the process. And the nature of the trashing of the Constitution is, with respect, the interference with the functioning of the office of the public protector. which is a clear violation of Section 181, subsection 4 of the Constitution. The facts also show that the main opposition party that has consistently, from the very beginning, been opposed to the appointment of this head of the Chapter 9 institution, going to the ends of the earth to get rid of them. It is a coalition of the wounded, to borrow a phrase. A president wounded politically by a constitutional investigator who dares to investigate him on matters that happen also to form a basis for a criminal investigation by the police, and an impeachment process against him. It is no coincidence, with respect, that the dead hand of the president fell on the public protector the moment she announced publicly that she will be investigating the president, as this court has found this time. The main opposition party, for its part, popped champagne in celebration of finally getting rid of the public protector. This is not some conjecture. You'll find it at page, if I need to refer, at page 139 of the report, paragraph page. It's in the affidavit of General Bantu Bonke on this, in his middle name, Harrington. I didn't know till I read it. In an unprecedented twist of fate, the interests of the president and those of the main opposition party have coalesced to get rid of the head of the Chapter 9 institution, who has been a thorn on their respective sides. That, justices, makes this case extraordinary, and the circumstances that bring us here today equally extraordinary. Now, those whom we represent, driven by a commitment to the oath of office, to be faithful to the Republic of South Africa, and to carry out their functions as members of the National Assembly, have decided they are not going to stand back. They're going to take up the cudgels on behalf of the people they represent to protect the Constitution and ensure that the executive is held accountable as it should be. This is clear from the facts. Only last week, this court, the court as currently constituted, declared invalid the president's hurried suspension of the public protector. And it did so rightly on numerous grounds. One, that the suspension was retaliatory and unlawful. Two, suspension was tainted by bias, not just any bias, but bias of a disqualifying kind. Three, the suspension was for an improper motive, as clearly demonstrated by the sequence of events that this court has detailed in its judgment. Four, that the president could not bring an unbiased mind to bear as he was conflicted when he suspended the other. This is what this court says in paragraph 157 of its judgment. Now, in reaching this conclusion, this court was informed by the sequence of events to which I've just referred. It is very important to go back there, and I won't dwell on it. It is this court that made that judgment, so I didn't read it back. But for emphasis purposes, let's remind ourselves that it was on the 7th of June, 2022, that the applicant informed the president in writing that she had decided to investigate the Phala scandal issue after a complaint had been lodged by one of our clients. On that same day, the applicant dispatched some 31 questions. Well, they're not really 31, they number 31. There are more than 31 questions. There are some questions internal. Dispatched those questions to the president and requested him to give answers within 14 days. The following day, the 8th of June, the applicant made that public announcement, which proved to be the kiss of death, that she had decided to investigate the president on the Phala funds. Then the very next day, the 9th of June, the president suspends the applicant. The following day, the 10th of June, the full bench in this court renders the judgment in relation to an interdict application that had been sought by the applicant to stop the president from suspending her. Now, let's remind ourselves, take a step back. The invitation by the president to the public protector to give reasons why, or to make representations to him about why he should suspend her, go back a few months in March. Now, based on this sequence of events, the full court concluded rightly that the president's suspension of the applicant was triggered by her decision to investigate on the Phala farm incident. And it's not just that. The link between the facts that inform that investigation is important to the fact that those same facts are the facts that inform the criminal complaint to the police, as well as the impeachment processes or process against the president. I understand from yesterday that a panel has not been set up, so it is something that is in motion. This, justices, is the context in which the president's suspension of the applicant was received. It is the context in which this court set aside that suspension and did so with immediate effect, granting a just and equitable order. This is the context in which this court must determine the applicant's application. And this is the context that provides clear, exceptional circumstances. I want briefly to take you to the record, because this is very important for exceptional circumstances purposes. But before doing that, let me say this. If the removal by a sitting president of the head of a constitutional institution for daring to investigate on serious allegations, which, as I say, also involve the criminal investigation and impeachment process, if that conduct does not constitute exceptional circumstances in an application intended to reverse that perverse result, then, justices, South Africans and the South African legal system and justice system is on a high level. We will be deluding ourselves for believing that we live in a constitutional democracy. In an old democracy such as the United States, for example, a president lost the election for the sort of thing that the president of South Africa is accused of, a criminal violation of the Constitution. And unlike in this case, no court, as I understand it, had found that that president had breached the Constitution. Another president in the United States was forced to resign for breaching the Constitution. Instead, in this case, or in our country, our president gets cheered on by a main opposition party for interfering with the functioning of a Chapter 9 institution by removing a public protector shortly after she makes an announcement that she's investigating the president. That is an exceptional circumstance. So we say the facts in this case bristle with exceptional circumstances. The Constitutional Court characterized this sort of conduct, of which the president is being investigated, as theft. Theft of the power that was vested by the people in the president. Mr. Pofu has already referred to the UDF chapter, and I'm giving you the citation, or he has given you also the correct citation. Now, how did the president know that he was free at the time that he did it? How did he know that he was now unshackled to exercise his power to suspend the public protector at the time that he did it? Before the judgment of the full bench was publicly announced. This is where the record becomes important. The Pan-African National, the PAC, Pan-African Congress Party, which we represent, believes that he was informed of the outcome of that case. That is why he lodged a complaint with the just president of this division, who pointed it to the JSC process. You'll recall this in its annexure BH3, I think. Oh, I don't think I know the exact number. It's BH3 on page 155 of the record. The complaint itself is at 155. The response by the Judge President is BH4 at 157. And this is how he concludes. Well, he says at 157, after receiving your letter, the same was forwarded, writing back to the PAC. The same was forwarded to the judges who sat in the matter, namely Erasmus Dolamo Willing. Oh, not to pronounce it. Apologies to the as per my letter dated 23 August 2022 and enclosed here too, and he enclosed it. He attaches the responses from the members of that bench. Then he recounts what each of them says. And the conclusion is important. He concludes at 159 of the record by saying this. Finally, (159) almost half of page 3rd. He says, finally, may I draw your attention to section 14 of the Judicial Service Commission Act, which regulates complaints against judicial officers, which has been enclosed hereto for your ease of reference. Should you wish to take the matter further, your submission must be in writing in the form of an affidavit to the Judicial Service Commission. The Judge President of this division, in response to a complaint about information about a judgment having come into the notice, that is the complaint. I'm not saying that's what happened. The complaint is that the President got to know of a judgment of the full bench involving whether he can suspend the Chapter 9 head, the head of the Chapter 9 institution or not. The President suspends her the day before that judgment comes out, and the Pan-Africanist Congress feels aggrieved, feels that there must be some skullduggery here. They lodge a complaint, ask for investigation to the Judge President, and the Judge President points him to the Judicial Service Commission. I missed one point, which is important to me, on the exceptional circumstances part. When the Judge President narrates his discussion of the issue with the judges, he makes mention of a WhatsApp with one of the judges. He says at page 158 of the record, he says, on 9 June 2022, that's the day in which the suspension is, I received a WhatsApp message from Village that reads as follows. Quote, have you ever seen this? The judgment to be delivered tomorrow is date stamped in George. Today, 2 question marks. I replied by saying, this is hilarious. So the complaint is not frivolous by the PAC. That is what this points to. This is an exceptional circumstance. Before that incident, a member of the public somehow wants to know of a decision of the Constitutional Court before it was made public, which also had a bearing on the relations between the President and his parliament, because it had to do with the Section 194 process being triggered. I don't want to get into a debate about whether the committee had started or not. I'll leave that to Mr. Fofu in another day. But the point I make is one cannot divorce the application before the Constitutional Court, which I think was a decision, from the Section 194 processes in Parliament and the interdict application in this court. Those three are interrelated and have to be seen together in order to appreciate the exceptional circumstances that dog this case. So a certain Mr. Abramowitsch, who, as far as I know, is neither a journalist or I don't know. It doesn't matter whether he was a journalist or not. I hear he's been called an analyst or something. To be safe, I'll call him a member of the public. Somehow he has to know of the decision of the Constitutional Court before it comes out, and alerts a member of one of the legal teams, for I'm not sure, Speaker or Democratic Alliance, one of the two, the Speaker, about the outcome of that judgment. The question is why? What's his interest in this? how did that information get to a member of the public from the constitutional court? To this day, we don't know that there was an investigation which was not a JSC, as I understand it, investigation, which didn't answer the question, how did this happen? These are questions that relate to this exceptional circumstances in this case. By the way, you'll find this, I don't want to be accused of arguing outside the papers. This is a paragraph 144, paragraph 19 of
Page
144, paragraph 19.
Okay.
The president and the main opposition party will have this court and the citizens of this country believe that all these are irrelevant coincidences. But those whom we represent do not share that, shall we, well, I'm not going to name it, do not share that thing. Their role is to hold the president and the executive accountable. Well, that's exactly why they are here. Which is why, and this is the point I wanted to make earlier, Justice Luke, when I lamented the fact that the vote had said in relation to the intervention application, I hope I'm not seen as sneaking aside from it, but I just want to make one point on the role of those whom we represent. They see themselves as protecting the Constitution. And so for the acting public protector on the affidavit to accuse them of seeking to interfere with the processes or functioning of the constitutional institution in the form and shape of the office of the public protector is regrettable. I'll put it no higher or lower. It is not an accusation that should have been made on affidavit. These facts provide exceptional circumstances within the meaning of Section 18 of the Superior Court. 3 minutes to spare. That's my contribution to the debate on behalf of our client. And if I may just take some views, maybe I've missed something. Unless there's anything else, Justices, those are our submissions to the exceptional circumstances.
Thank you, Mr. Malona.
And Mr. Masuku will address this over which is 172, section 15 and 15.
Thank you, Mr. Masuku. How long do you think they're going to make?
I do promise to take less than 20 minutes. I'm permitted without any interruption, and it seems that's a possibility, judging from how smooth sailing my learned friend Mr. Ngalana's address went.
Well, you may proceed, but you can't promise.
The order granted in paragraph 187.6 was justified by the exceptional circumstances that Mr. Ngalana has pointed out, which reflect an extraordinary constitutional dilemma triggered by the unconstitutional suspension of the public protector. But the real question that I intend to address the court on is, what is the effect of an application for leave to appeal the orders, whether it's 187.6 or 187.5? The second related question is what is the effect of confirmation proceedings. We know the general principle that the operation and execution of a decision, which is the subject matter of an application for leave to appeal, is suspended pending the outcome of the pending decision of the application and appeal. But section 18.2, which is really the nub of the submissions I intend to do, says that the operation and execution of a decision that is an interlocutory order, not having the effect of final judgment, which is the subject of an application for leave to appeal, or an appeal is not suspended pending the decision of the application for appeal. So if
that's section 18.3.
18.2.
2.
I believe it's section 18.2. It is section 18. But also, we have to look at the nature of the order that was granted in 187.6. Because 187.5, the order in paragraph 187.5, is the order that finds that there is the order which you would call an order of constitutional invalidity in respect of the president, of the conduct of the president, and therefore an order for which confirmation ought to take place in terms of section 172(2)(a). But 187.6 is not an order of constitutional invalidity. It does not relate to the conduct of the president. It is what is classically regarded as an interlocutory order, given under the principle of just and equitable in section 172, 1B of the Constitution. Honorable Justices, an interlocutory order was defined in South Cape Corp Private Limited versus Engineering Management Services Private Limited, 1977, Volume 3, SA 534. It's an appellate division judgment at paragraph 549G. And in that judgment, an interlocutory order was defined as follows. It said, in a wide and general sense, the term interlocutory refers to all orders pronounced by the courts upon matters incidental to the main dispute, preparatory to or during the progress of the litigation. But orders of this kind are divided into two categories: those which have final and definitive effect on the main action, and those known as simple, purely interlocutory orders or interlocutory orders proper, which do not. The order in 187.6 is what you would call an interlocutory order, because it is an order that regulates the period between the time the judgment is given and the time that the Constitutional Court confirms the order of constitutional invalidity in 187.5 of the judgment.
Just so that I understand your submission. So what you are telling us is that that order is the sort of order that would not be suspended pending the appeal.
That is correct.
Okay.
So I'm accepting what the public protector said about the need for bringing an application to enforce the order under section 888 under section 18. But the submission I'm making is that the public protector must go to work, because whether there is an application for leave to appeal or not, it is of a nature that does not have the effect of suspending 187(6) of the judgment of the judgment, because it falls within 18(2) of the Superior Court Act. But honorable justices, in the judgment, you do reflect on what the order that you believe would be necessary to give upon pronouncing the conduct of the president unconstitutional. And you said in 187, you said that that order has to be a just and equitable order, and that would fall under 1721B. And I've made submission that that order, that is not an order of constitutional invalidity relating to the conduct of the president, but it's important for the court to reflect a bit more about what orders that are referred to as just and equitable, which are discretionary orders, what they intended to achieve. The first is that they regulate the period that it takes to confirm an order of constitutional invalidity. So they mitigate the effects of an order of constitutional invalidity. They are designed to avoid unnecessary disruption in governance or public affairs, especially where a constitutional invalidity order is granted in relation to legislation. They are also designed to ensure that fundamental rights are not affected by an order of constitutional invalidity. In fact, just and equitable order must protect fundamental rights of persons who could be affected by an order of constitutional invalidity. And this takes me to why the order under 187(5) (187)(6) is an order that is not suspended by an application for leave to appeal in terms of 18(2). It is so because you would know from provisions of 181 the responsibility of everyone in relation to Chapter 9 institutions. 181(2) says these institutions are independent and subject only to the Constitution and the law, and they must be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. And of course, an order as this court has granted in paragraph 187(6) is an order that affirms this particular provision. It reinforces the independence of the public protector. While there's a controversy about the constitutionality of the conduct of the president through confirmation proceedings, it says to the public, the office of the public protector must be protected in terms of the Constitution. It also requires that other organs of state, through legislative and other measures, and in this case, I would say the judiciary, through its power, its judicial powers, must assist and protect these institutions to ensure their independence, impartiality, dignity, effectiveness of these institutions. So in a way, what paragraph 187(6) does is to ensure the independence, the impartiality, dignity, and effectiveness of the public protector. More importantly, it's a constitutional prohibition against the president that no organ of state may interfere with the functioning of these institutions. And where the court has found that there's been a constitutional suspension of a Chapter 9 institutions, that provision is implicated. And an order that she must return and perform her duties advances the principle that is set out in paragraph in section 181(4). The constitutional rights that are implicated in the unconstitutional removal or through an unlawful suspension of the public protector are self-evident. The dignity of the public protector, and Mr. Boff has dealt with that. But it's not just the dignity of the public protector in their personal capacity, it's also the dignity of the public for whom the office has been established. Those people who, on a regular basis, go to the public protector to ask for relief that they would not get elsewhere. So it is for the interest of and the confidence in the office of the public protector that an order as this one must be granted. Finally, it's important to juxtapose what you are protecting by ensuring that the public protector is resumes her functions immediately. On the arguments you advance, which I'm sure Marine friends have no difficulties with, there is no order. This order 1876 is not suspended because it's an interlocutory order. Right? So she can go to work tomorrow, if that is accepted. I accept the arguments they are making, which is an enforcement application. That succeeds too. That the same result is still accepted. There is a presumption, a very important presumption, that is extended to constitutional institutions or heads of constitutional institutions as those that occupy these Chapter 9 institutions. Presumption of integrity. She has not been found guilty in the process for which she has been suspended. It must be presumed that while that process goes, she must be treated as someone who is not guilty, or who's not guilty as not in the criminal sense, but in the sense that would attract the severest sanction that Parliament can give to her, which is a removal. So would submit that this order that is granted under section the order in paragraph 187(6) is a just and equitable order that protects not just the constitutional rights, but protects the public confidence in the institutions of our constitution. Possible that one day a judge who is hearing a matter involving the president may be suspended because there's a JC process against that particular judge. That cuts deep into the integrity of our constitutional system, and it should not be allowed. What protects the constitutional system is an order, as the order that was granted in paragraph 187.6, which order requires no confirmation by the Constitutional Court, which order also is not suspended because of its very nature, the order being an interlocutory order.
Perhaps just ask a question for me to understand. You're saying, or are you saying that paragraph 187.5 must be severed from 187.6?
Absolutely.
And 187.5 must that be referred to the Constitution for?
Yes, because it's an order falling under the 172(1)(a) of the Constitution.
Now, what can happen if the Constitutional Court decides not to uphold the judgment or confirm? What happens then?
Then the consequences follow. If the Constitutional Court reverses your judgment, in the sense that it doesn't confirm the finding of this court in paragraph 187.6, then of course the suspension kicks in.
Yes, but surely 187.5, 187.6 must be read together, because the face of it, 187.5 is a declaratory order in a sense. Suspension was unlawful. Now, because the sense of suspension was unlawful, consequences follow, and those consequences are 187.6. So they've got to be read together.
They've got to be read together, except that Justice Francis. But what is referred for confirmation to the Constitutional Court is not 186.6, it's 186.5, because that is the only order that relates to the conduct of the president. The consequences under a just and equitable order are exactly that. It's applying your own discretionary powers as a court, you try and regulate the impact of a constitutional, a finding of constitutional invalidity. In the mystery case, for example, when the court found that the legislation governing the Medicines Control Act gave the inspectors expansive powers, the court declared that legislation unconstitutional, but then they asked the second question, which was, what is the impact of that order of constitutional invalidity? And they said, well, there won't be any regulation or that governs how medicines are kept by medical practitioners. And so they suspend the order of constitutional invalidity. Position stays the same until the Constitutional Court confirms that particular order. I'm saying the order that is subject of confirmation is not 187.6. Even if you read them together, they're separate orders. They regulate separate aspects of the complaint. One is a just and equitable order or a temporary order that is intended to mitigate the effects of an unlawful suspension. And what other, the most appropriate just and equitable order to mitigate the effects of an unconstitutional suspension is to reverse it. That can be, there can be no doubt about that, especially where there is no evidence whatsoever that if the public prosecutor were to return to the office, she would bomb the office, or she would commit crime, or she would do anything. You have to give her the presumption of integrity. Presume that even though she's gone through this difficult process, this difficult political process, she is in fact, she's got the integrity, she understands her constitutional duty, and she intends to perform her constitutional duty as required by the Constitution. That is not what you confirm. What you confirm is whether or not the president's power has been exercised in accordance with the law. That's what the Constitution says. You don't confirm a just and equitable order. My then friend relies on a judgment just slip my mind. But the principle there was that the court had read in certain words into legislation. And of course, that's where the order of constitutional invalidity and the remedy, the constitutional remedy given for that are linked. It could never be suggested that when a court reads into legislation, that is something akin to a situation where a court finds that the president has acted unconstitutionally by suspending a head of a Chapter 9 institution, and this court has said, well, she must go back upon setting aside that suspension decision. There are two different situations. There will be situations where a just and equitable order, perhaps in an order of constitutional validity, can be read together, particularly in legislation, where you are dealing with the constitutional invalidity of legislation. But where conduct is involved, because you have to think about what other areas the president's power reaches that could be challenged as being unconstitutional. He declares a war, or he imposes an unconstitutional state of emergency. We rush to court and we say, but you can't do this because the jurisdictional requirements for this action are not satisfied. You agree with it. But then you say, no, actually, the just and equitable order is that it must remain, this state of paralysis must remain. People must stay in their homes and not move out until such time the Constitution is confirmed. That wouldn't be a just and equitable order, because a just and equitable order must advance and protect the constitutional rights of citizens. That's why it's a just and equitable order. It cannot perpetrate an unjustified suspension, because that's exactly what this whole application by the DA and the president seeks to do. It seeks to regulate or seeks to promote an unconstitutional suspension. In the eyes of the public and in the eyes of the law, when a court has spoken and said it has found, but for a moment, that the Constitutional Court must still deal with it. But none other than a court of law they say this exercise of this power has been done in a way that is contrary to the Constitution. That is important.
But isn't it the Constitutional Court that has made the determination, not this court?
The determination?
The status of the president, his clinical role in as far as the Constitution is concerned, it's not for a high court to determine whether the president's conduct is impugnable. Ultimately, it's the Concord that makes the decision.
No, with respect to that, that's incorrect, Manoj. Because if you look at what your powers are in terms of what the court's powers are in terms of 172.
So while you're looking there, I've just picked up on the point. You seem to accept that what we're dealing here, when the president suspends, we're actually dealing with conduct.
Yes.
Now, it's conduct of the president. Are you saying that this High Court can make a definitive finding in relation?
No, I've not made that submission. It has made a finding that it's unconstitutional. That finding has to be confirmed by the Constitutional Court. So if the Constitutional Court confirms it, what does it say? It says the finding of the High Court that the president's conduct was unconstitutional is confirmed. It's confirming the decision that this court made. So it's really just important to emphasize that you must lean towards eliminating from our constitutional system a practice of unconstitutional behavior, especially by powerful individuals in the position of the president. Where you have found that the conduct of the president is unconstitutional, an appropriate order would be to restore order in the sense of looking at the rights that are implicated, looking at the institutional integrity of the Public Prosecutor's Office, which is implicated in that decision, and make an appropriate order that the suspension that you've set aside or that you've declared unlawful must be set aside, and the public protector must return to work. And of course, that's all interrogatory because it's pending the outcome of the Constitutional Court judgment. Those would be our submissions, unless the court has. My Lord, perhaps I rush to conclude. No, actually, my little friend Mr. Garana reminds me, Section 15 argument is really no big argument to make. Section 15 simply regulates how you go to the Constitutional Court when you're confirming when you're seeking confirmation of the orders orders that are made under Section 172 2A of the Constitution. So the process through which you go to the Constitutional Court is regulated in Section 15 of the Superior Court Act. That's really all that we submit. So we submit that on two levels. The public protector can go to work on the basis that the order in 187.6 is interlocutory. An application for it to appeal does not suspend it. Alternatively, that you grant the relief that is sought by the public protector through its enforcement application. Those would be our submission. Unless there are any questions, just go there.
Yes, in other words, if I understand you correctly, the application for leave to appeal doesn't do anything to as far as the order
187.6. Yes. Because that is correct. The application for leave to appeal is of no moment. It doesn't suspend the operation of that order because that order is interlocutory. It's in between litigation. It's the finding of this court and the confirmation proceedings.
Yes. In other words, it's also in terms of Section 18.2.
Yes, in terms of Section 18.2. So with respect, what you have done by granting the order in 187.6 is that you have prevented a potential act that could amount to defeating the ends of justice, because it's an unconstitutional interference with the functioning of the public protector. You've also not rewarded that conduct by prolonging the repugnant suspension of the public protector. Those would be our submissions.
Thank you, Mr. Minister. We shall adjourn until 2:15 so that we can assess the situation with the load shedding and give necessary.
So Justices, if I could then turn to the first of those three subjects, and that is just in terms of locating section 172 of the Constitution. We heard much debate in the course of this morning about what the power is, what were the grounds on which it was invalidated, and all of that purportedly in an endeavor to prove to this court that it was not conduct of the President that we're talking about. Can I ask the court to go to 172(1) of the Constitution, please? And Justices, you'll see that's the provision that I will refer to as the source provision for the remedy that will arise. And 172(1)(a) makes it peremptory for a court to declare law or conduct inconsistent with the Constitution to the extent of its inconsistency. And 2 is the ancillary power, which is to give the court the discretion to grant a just and equitable remedy in these circumstances. There's nothing defining about it other than for the fact that the court derives its power to grant a constitutional remedy from section 172(1) of the Constitution. And then, Justices, section 172(2) goes on to identify what the effect of certain orders may be. And it says in terms that the High Court may make an order concerning the constitutional validity of an act of Parliament or any conduct of the President, but an order of constitutional invalidity has no force unless it is confirmed by the Constitutional Court. So what 172(2) does is it identifies what the status of the order is. And it tells us in unambiguous terms that it has no force unless and until it's been confirmed by the Constitutional Court. Members of the Court, if I could ask you then to look at section 167 of the Constitution. And you'll see there that it says that the Constitutional Court makes the final decision when, in respect of the conduct of the President as to whether it's constitutional, and it must confirm any order of invalidity made by a court before that order has any force. So it's clear, I would submit, from both those provisions that unless and until conduct and order relating to conduct of the President is confirmed by a Constitutional Court, it has no force. Now, the Constitution itself makes provision for an interim regime, and it does so in 172(2)(b of the Constitution. And this is important because 172(2)(b) must be read in the context of the provision in its entirety. And it does no more than having established in 172(2)(a) that such orders have no force. The sub-provision provides that a court may grant a temporary interdict or other temporary relief in circumstances where the matter is yet to go up to the Constitutional Court for confirmation. So it provides a remedy, an interim remedy, and that remedy isn't one that's synonymous with giving force to an order on the conduct of the President. Because if one were to read it in those terms, then it would render nugatory section 172(2)(a), which says in terms such orders have no force. So, Justices, if I could then, against that backdrop, refer you to page 4 of our heads of argument. And the court will see at page 4 and following, we refer the court to 3 cases of the Constitutional Court, which identify what we would submit are guiding principles when we're looking at section 172(2). And I'm not going to go through them in any detail, but if I could summarize the principles. The first, Justices, is that the Constitutional Court has recognized that section 172(2) is directed at the two highest levels of government. It's the President's. Secondly, according to the case law, it tells us that that provision refers to any conduct. And it says that in those terms, it has a wide meaning. So this court will be guided by that principle when the court comes to consider the question of whether or not a decision to suspend the public protector constitutes conduct as contemplated in section 172(2). And the third principle is that the jurisprudence tells us that given that it is the highest organs of state that we're talking about, it is to have the ultimate power being left in the hands of the Constitutional Court as the controlling determinant of orders relating to presidential conduct. And the last point from the jurisprudence members of the court is that the Constitutional Court has said that the purpose of the provision would be defeated if one were to use it to exclude constitutional issues of import from the controlling power of the Constitutional Court. And so the submission would be, in engaging with the question of whether the impugned decision amounts to presidential conduct or not, this court will be constrained to have regard to each of those principles in the three cases of the Constitutional Court that we refer to. Justices, the next question that we've directed the court's attention to is the cases in which the Constitutional Court has found that decisions taken by the President actually do amount to conduct of the President. And if I could refer the court to page 7 of our case argument, paragraph 12. And the court will see that the first decision is that of the Law Society of South Africa. And there the Constitutional Court dealt with the presidential decision in relation to a SADC tribunal and a number of ancillary orders. And the Constitutional Court concluded that that was a decision of the President which amounted to presidential conduct for the purposes of 172(2). And then, Justices, at 12.2, we refer to the matter of DA versus President of the Republic, and that dealt with the presidential decision to appoint an individual as the National Director of Public Prosecutions. And the court will see there, we've reproduced the order of the Constitutional Court, and the order says that the declaration of invalidity of the Supreme Court of Appeal, the decision of the President relating to the decision to appoint an individual as the National Director, and we would submit that that case, an appointment of a light on presidential powers, is not too far out from what we're talking about in this matter. This matter concerns a decision to suspend, where the source of that power lies. Decision is the one at paragraph 12.4, 12.5 of our case argument. And that was a decision of the President in relation to an increase in annual remuneration of magistrates and regional court presidents. And that decision too was taken by the President, and it was found to have been subject to confirmation by the Constitutional Court. So, what those cases tell us in 3 of those instances, there's a presidential decision taken on provision. And in all 3 instances, the decision is found to amount to presidential conduct and is therefore subject to confirmation by the Constitution. There are 2 other matters and 2 other cases that we referred to, and that shows the breadth of the conduct. The one deals with where the President entered into a settlement agreement. The other deals with where the President dealt with a proclamation. And in those instances too, the court found that those were decisions that were subject to confirmation by the Constitutional Court. So, Justices, in order for any of the arguments that the applicants and those supporting the applicant had advanced to the court, they would have to show or distinguish the matter before this court today from this case of the highest court in the land that tells us presidential decisions taken pursuant to empowering provisions constitute presidential conduct and is subject to justices that they fail to do so. And in those circumstances, this court can only rely on the Constitutional Court in guiding its decision. Justices, there's another leg of the argument that was advanced in the course of this morning, and it went to something. The argument was, and it appears now Leonard Friend's argument as well, it was to say, well, the applicant as one of impugning presidential conduct on the one hand, and impugning. And the argument was the court followed that law against the conduct in reduces to decisions, and that must and can only mean that when one talks about a presidential decision. And we submit that there's no authority for that. On the contrary, the jury tells us quite the opposite. And so in those cases we would submit, the issue is whether on the order that the court made. Can one on any reasonable say that an order that invalidates the President's decision to suspend the public protector does not amount to presidential conduct? We submit it on that argument. Then we submit it matters not as to what the source of that power is, what the reasons for the court's findings are, or any of those, or how the case was actually framed to this court. None of those issues matter. And I make that submission, Justices, for this reason, and that is that if the conduct, the decision in question, amounts to presidential conduct, it matters not as to whether that decision is tainted by virtue of common law bias, whether it's tainted by virtue of the conflict provisions under the Constitution. The primary interrogation is, did that decision amount to conduct by the President? And if it did, that's the end. Our learned friend is trying to locate the order in section 172.1 or 170 as distinct from 172. But that says that these orders have no force. The jurisprudence of the Constitutional Court says that it's with good reason they have no force. It's the most senior organs of state we're talking to, and therefore the power rests in the highest court in the land. And despite that, what this court is being asked to do is to give it the status of an interim order for the purposes of section 18.2 and thereby bypass the plain wording of section 172.2. And I submit there's absolutely no basis for such an approach. So justices, all of that then, and so the perfect submission on that is to say, undoubtedly, this case falls within the purview of section 272.2a of the Constitution.
172.
I'm sorry, 100. That's a product of very little sleep, Justice Eaton, my apologies. 172.2a. And if it does, then the only legal basis for an interim ruling lies in section 172.2b of the Constitution. And that provision, as I took the court to, does allow the court to grant an interim to grant temporary relief. Now, it's important to look at, and I'm going to ask the court to go here for a moment, the notice of motion in this matter. It's volume 1. It's and it's prior to. Now, there's no uncertainty in this at all. The order that the applicant has come to court for and the meet is that the order granted by this court on 9 September 2022 is declared to be operational in terms of Section 18 of the Superior Court Act, giving any application for nature and or unappeal. So that's the order sort. There's no amendment. Those are the clear terms in which it act. If the court would then go to the finding affidavit, it's printed page 8, paragraph 5. Tells this court this is an extremely urgent application brought in terms of Section 18.1 and 18.3 of the Superior Courts Act to render the order operational and executable. So there can be no doubt as to the basis on which this application was brought. The court will then be aware that this was an issue that was raised pointedly in the President's answering affidavit. Can I ask the court to go to volume 8? Page 718, paragraph 16 and following. And there the court will see that Mr. Owen, on behalf of the President, says in terms that the orders have no force until they've been confirmed. The constitutional draft has recognised that there may be exceptions of interim relief and therefore provided for recourse in 172(2)(b). Advocate Emperor elected not to avail herself of the remedy available in terms of Section 172(2)(b). Instead, she proceeded with the main application, knowing full well that her challenge related to the conduct of the President. Despite this, she sought no relief in terms of 172(2)(b, and over the page we go on to say she provides no explanation of that. The court will then see what the reply to that is, and it's in the reply affidavit of volume 9, page 860.
Page number?
860, Justice.
860. Thank you.
And the court will see that the applicant engages with the Section 172(2) debate there, and in paragraph 14, she says, "It is my contention, to the extent that the order does up to a decision, it is akin to a review, and that it was based on considerations in 172(1)(b." And then she goes on to say, at paragraph 16, "However, if on the other hand I'm wrong in my decision, and it is indeed a decision contemplated in 172(2)(a), then one of the two consequences follow, which are both fatal to the respondent. Namely, that the decision is an interim, and the second is that the present application is other temporary relief 172(2)(b). So what do we see there? We see a reply in circumstances on exceedingly short time frame. I think we received the reply at the report, and heads of argument were prepared overnight in order to get this matter into court. We see a submission as significant as that made for the first time in the time. We submit that in accordance with the well-established rules, the applicant is not permitted to do that with its jurisdiction on that case. I would submit to the court that that's not what Section 18 of the Superior Courts Act actually does. what it does is it says to us in no uncertain terms that the default position is that a court order is sustainable. In order to show otherwise, an applicant has to bring themselves within the purview of Section 18.1, Reg 18. Now the court may ask, what then is the role of Section 18 when we have an order that has no force unless and until it is confirmed by the Constitutional Court? Differently put, that order, which has no force, isn't even capable of suspension under Section 18, because it has no life of its own unless and until it's been confirmed by the Constitutional Court. And for that reason, Justices, Section 18 can't be used to give litigants through the back door that which the Constitution expressly regulates in different terms. And if one were to read Section 18 as my learned friend submitted to the court this morning, is saying, well, it's really of no great significance, because what we really have is Section 18 providing the platform or the avenue through which I'm vindicating rights under Section 172(2). I would submit to the court that that's a very different picture from what's actually being out. And that is because we have 172(2)(a), which tells us in terms it doesn't have any force. And if it doesn't have any force, it must follow issues of suspension and lifting of suspension do not arise because there's no life in that order. And so for those reasons, Justices, the submission is Section 18 doesn't find any application at all to presidential condemnation. This application, founded as it is on Section 18, must therefore be made.
Just before you pass on that point, just so that I understand follow your submission. So you say that because an order that is made in terms of Section 172 has no effect as a default position, Section 18 will not apply.
Absolutely so, Justice.
Because otherwise the effect of Section 18 is to put into operation that which is suspended by the noting of an appeal or an application for leave to appeal.
That's precisely the point, Justice. And in putting it into operation, the effect of it would be it has no force in terms of the Constitution. That notwithstanding, I'm using Section 18 as the mechanism to put it into force. And that is a very different consequence from what Section 172(2)(b empowers the court to do. 2B empowers the court to grant an interim intellect or to grant temporary relief, not to operationalize an order that has no force in terms of the Constitution.
But then, where there's an application for leave to appeal also in relation to Section 172(2)(b, will Section 18 not find the application?
I would submit not. Sorry, perhaps as a little tricky to answer, just maybe because is the question if an interim order is granted pursuant to Section 172(2)(b, would Section 18 find application?
Yes, where there's an application for leave to appeal against that particular order. Because if I understand you correctly, you are saying that where such an order has been made relating to the conduct of the president, Section 18 doesn't find an application. Now, I want to find out from you, if an order has been made in terms of Section 172(2)(b, and there's an appeal against that decision, does Section 18 not find any application?
So the first submission is I'm not entirely sure that an order made under 172 is an appealable order, because it's of course an interim regime. It entitles you, so the argument would be it has no final effect. And I guess one can bring it within the purview of any of the exceptions that the Constitution would identify where interim orders are appealable. It wouldn't in the ordinary course be subject to appeal.
Yes, but there are in exceptional circumstances, definitely there will be excuse for that effect.
Yes.
We want to find out from that.
Yes. So Justice McNeely, my first submission would be that I don't believe that it could legitimately fall within any of those exceptional circumstances in terms of interim orders being appealable, because of the very constrained language of the section on its own. But if one were to get out of that hurdle and go next, I'd submit that it may well be that Section 18 might find application. But that's on a decidedly different basis. Section 18 would find application on the basis that there is an order under 172(2)(b) that has legal effect. And that order, assuming for the purposes of the debate that it's appealable, then the question would then be whether it could then be Section 18 that would then apply. I can't see it happening in practice, but the submission is that would be the basis on which.
And I'm raising this issue because if I also understood, I understand your question, your argument that those two orders must not be read disjunctively, because also the fact that this was never pleaded. The argument that has been raised was the order which was granted in terms of paragraph 187.6 was an interim order, hence I'm raising this issue.
Yes. And to that, just the submission would be the one that I made earlier on, just to reiterate it, and that would be that the court derives the composite power from 172(1) to grant an order. That's a composite order that's been granted, and one can't read a 172(1)A order as being separate and distinct from a 172(1)B order. Because certainly in my reading of the jurisprudence around 172(1)B, in most cases, I think my learned friend and I are getting one matter where it's different, but in most cases, the just and equitable discretionary competence of the court follows only after a declaration of invalidity has been engaged on the first subsection. So, thank you. Justices, if I then can turn to the issue, the third of the issues I'm dealing with, and that is the submission that the threshold requirements of Section 18 have not been met. Now, Justices, we've dealt at some length from page 14 and following along the heads of argument with the case law dealing with Section 18 and its meaning, etc. There are perhaps only a couple of points I want to emphasize for the purposes of argument. The first one is this: the three requirements stipulated in Section 18 have been described as conditions precedent that a court must ensure are met before it can go further in respect of the Section 18 order. The second issue is this requirement of exceptional circumstances, and I think Justice Newman asked the question of course this morning, and that is what is the target of the threshold of exceptional circumstances? And I submit to the court that the target is to say that the default position is that an application for leave to appeal would sustain the order. When a litigant comes to court and it asks for the order to be brought into operation, it's incumbent on that litigant to show there are exceptional circumstances that warrant or justify the operationalization of that order. And so it's a very targeted inquiry. It's exceptional circumstances to justify the operationalization of that. And the court will know that that is not what Advocate Nkobane did in this matter, and I'll take the court to the evidence in a short while on that. The next issue is the question of the irreparable harm to the one party and none to the other. And my learned friend, Mr. Nkobane, engaged the court this morning. He said, well, it's about the irreparable harm to the parties to the particular matter. And by no stretch of the imagination could the president or any other party show irreparable harm to themselves. And conversely, Advocate Nkobane could show irreparable harm to herself. And the argument was, well, on that premise, that's the end of having shown compliance with the requirement. Can I ask the court to go to page 26 of our case file on that? That's the Ebenezer Helen Susan Foundation matter, and it's the authority of the SCA paragraph 47 that you referred to. And there the SCA said, insofar as the requirements of 18E are concerned, the High Court could not be faulted for its approach in respect of the question of irreparable harm to general information. On the other side of the coin, there was the public interest and the crucial place that the DPCI enjoys in our young democracy. On a balance of probabilities, the applicants had proven that the public would suffer irreparable harm if the court did not grant the order, and the general would not suffer irreparable harm in light thereof. And so the first point on that is just at the level of principle. When one engages with the requirement of irreparable harm, it's not harm that applies only personally to the litigants to the matter. It's harm that's broader public interest harm that can be considered, or is to be considered. And so, Justices, if one then looks with those preliminary submissions having been made in respect of the threshold test under Section 18, I'm not going to many cases and authorities we've referred to in our case, because I think it's not those. But if I could then take the court to the evidence of this, and we summarize it at page 19 of our document. And the court will one of the factors that Advocate Nkobane relied at against the question of does it succeed an exceptional basis on why this court's order ought to be operationalized even before the appeal is determined. And we say on that, Justices, that the first point she relies on is that is a general conclusionary statement. It adds nothing factually to the matter. Secondly, she says much about the uniquely exceptional role of the office. And we say that speaks to the role of the office of the public. That doesn't provide a basis as to why the incumbent ought to be reinstated, or the suspension ought to be lifted, pending the determination of the Constitutional Court. It's a concern that lies the office of the individual, and it therefore doesn't fall within the threshold of that situation. The third point she relies on is that, well, in our history, this is the first time that this has occurred. That's all the more reason why it ought to be dealt with cautiously. The fact that it's the first time that it's happened, you say, well, because it's the first time in history, we ought to ensure that we operationalize this order. That doesn't provide an exceptional circumstance. The fourth is that Advocate Nkobane says that she's severely hampered in her preparation for the Section 194 inquiry because she can't get access to crucial documentation. Now, this is a prime example, Justices, of where jurisdiction under Section 172(2) the court may well say, I don't have the power to operationalize an order that has no force until confirmed under constitutional court. But I have the power under that section to grant temporary relief. The temporary relief I grant must be directed at vindicating what Advocate Nkubana complains about. And if the complaint properly brought was to say, I've written to the acting public protector and extent, I sought access to this information, she has refused it. I need it for the purposes of the inquiry. I can't get it. The court may well say, notwithstanding the fact that the order hasn't been confirmed, I'm granting interim relief, directing the office to provide these documents. And so I digress, but that would be, when I make a submission in relation to the previous point, that on the issue of being severely handled, the first point we make, Justices, is that there's no specificity to the event. What the documents were, what the endeavours were, nothing of that sort. And so we say at the level of fact, that doesn't take us anywhere in determining exceptional circumstances. But we say it goes even further, Justices. We've referred the court, if the court is inclined to admit the affidavit of the acting public 9, and we refer the court to page 821, where on the facts she rejects that contention. And she says that she's responded expeditiously to Advocate requests for information and documentation, that Advocate Nkubana still has full access to another account and profile, that neither Advocate Nkubana nor her attorneys have recorded any complaint about refusal or failure to provide information or documents, and that Advocate Nkubana does not say what crucial documents she was not able to. And so for that and the other reasons that we set out there, we submit that on the evidence, access to crucial documents doesn't constitute an exceptional circumstance so as to operationalize the order. The next thing is that Nkubana says, well, the root of the matter lies in allegations of bias and possibly bad faith against the president. And to that, the submission is the court's rule in relation to what is called the president's conduct. It is precisely that ruling that is the subject of appeal to the Constitutional Court. And that will be determined one way or the other before the Constitutional Court. But that's not a basis on which to preemptively, through the back door of Section 18, have this court on their Justices, the sixth point that Advocate Nkubana raises is that the investigation has been unduly delayed earlier because of the unlawful suspension. And there, Justices, we say in the first place that she provides no facts before the court to demonstrate that her suspension has impeded the Phala Phala investigation in any way whatsoever, or that it's affected the investigation negatively. The President's evidence is that he's responded to the questions, he's cooperated fully, and the process is underway. Justices, you'll be aware that the President's attorney in the Phala Phala matter, Mr. Harris, provided a set out where the process is on that as well. And then, Justices, you'll be aware that according to the acting public protector, she says there's no delay. She says that Advocate Nkubana's statements under oath are inconsistent with her very own statements to Parliament, where she said that the office has never been able to complete a report on an investigation within 6 months. And she's provided much detail to this court in saying that, and she then reaches the conclusion that when viewed against the turnaround time of 8 different investigations, it is clear that Advocate Nkubana's allegation is without foundation. She then explains in some detail what steps have been taken in relation to the Phala investigation and what steps still remain to be taken. So on the evidence, the issue of the purported delay on the Phala investigation is to be roundly rejected because of what was on. And then, I think Nkobana relies on certain findings of this court in the context of urgency as a basis on which to show exceptional circumstances. We submit that that doesn't get starting blocks. And lastly, she talks about the grave consequences if the findings are upheld in appeal. Well, we say that's a premature assessment at this stage. Justices, you'll see at paragraph 41 of our head's argument, we deal with the further 3 grounds that are raised in the supplementary finding affidavit. The first of those is to draw a comparison between the President's conduct in this matter and the and we submit that that doesn't get through the legal threshold of exceptional circumstances. The second is about the President having been tainted by actual bias and reasonable apprehension of bias or conflict of interest. That again is an issue for the Constitutional Court to determine. It doesn't give answers as to why this rule must be operationalized before the Constitutional Court has pronounced on it. And then the alleged abuse of the President exactly the same. So justices, on the requirement of exceptional circumstances and that analysis that we've undertaken in relation to the 11 grounds I think against the foul, none of those engage the question of why is it an exceptional circumstance to operationalize an order of invalidity against the President at this stage. Then, Justices, the next threshold that Advocate Nkobana has to meet is to show irreparable harm to herself. If I can ask the Court to have regard to paragraph 42 of our submissions. Paragraph 42, the first point that is made is, well, that there's a duration, that the suspension has been going on for 3 months. Draw your attention now, as we did in the main proceedings, to the long judgment of the Constitutional Court, where the Constitutional Court said generally, where the suspension is on full pay, cognizable prejudice will be ameliorated. And then we draw the Court's attention to the Part A judgment, where the Court said a precautionary suspension is by no means punitive, as Advocate Nkobana will not be denied the salary during the period of the suspension. And the point I make here is not to make light of Advocate Nkobana's predicament, but to say in light of the long judgment of the Constitutional Court, where it says the predicament is ameliorated by the ongoing salary reductions that it receives. This Court would be hard-pressed to find that that suspension amounts to irreparable harm in the terms contemplated by Section 18. Advocate Nkobana then relies on reputational harm and harm to her dignity, and we submit that she's striking at the wrong target on those submissions. Those issues, to the extent that they're implicated, they come as a result of the serious allegations of misconduct and incompetence and the evidence that has emerged before the 194 filing. And then surprisingly, whilst Advocate Nkobana argues, well, it's really primarily the harm between the litigating parties that's at issue, she herself speaks of harm that goes beyond that. She talks about broader harm in this regard. And she says that relating to the work of the Office of the Public Protector, etc. And to that, Justices, we say that the affidavit provides the clearest indication of where matters stand within that office, and those are not averments that Advocate Nkebane, who on her own version has not been into office for the last 3 months, is able to legitimately contradict. She then says that the allegations are, she then says there's inevitable destabilization and delays caused not only to the so-called Phala investigation, but general work of the public protector. And there again, we say, justices, no evidence has been placed before court on in relation to that amendment. And we say that it's been violently contradicted by what the acting public protector tells us. She says that the allegations that Advocate Nkebane makes are not informed by personal knowledge. The office is on track with its performance. Various systems have been implemented, and based on the factual evidence submissions that the office is performing relatively well. Reasons, justices, we say that the threshold inquiry of irreparable harm in Section 18 has not been met. There's no irreparable harm to Advocate Nkebane that she has been able to show. Insofar as the allegations of irreparable harm of interest, can I refer the court to paragraph 44 and following heads, where we deal with the public interest threshold. When one assesses that, justices, against evidence, we submit that there are actually 8 reasons as to why the public interest harm outweighs by a long shot any harm that can be out. The first is that she hasn't established that she will suffer any irreparable harm. Secondly, we say if the relevant orders are operationalized at this stage, the potential harm to the public interest and constitutional project is grave and far-reaching. And we then refer the court to the Part A judgment, where the court emphasized the value of accountability and its role in this office. Justices, in subparagraph 3, we say that the suspension is to protect the office of the public protector. There can be no debate about that. It's an office recognized in Chapter 9 of the Constitution that is being protected. We say, secondly, it is to ensure that Section 194 inquiry can proceed unhindered. And we say, thirdly, it's ultimately to protect the public interest. And we say, Advocate Nkebane's return to office in these circumstances will be undermining. Fourthly, we say the nature of the allegations of the very serious form that would justify impeachment is proven. Fifth, and this is a particularly important point, justices, and that is that there's no findings made against the reasons given, the substantive reasons given by the President for Advocate Nkebane's suspension. Indeed, as the court knows full well, that wasn't even a ground of attack by our learned friends. There's a letter they referred to, but it certainly wasn't identified as a ground of challenge. And the court knows from the Part B papers, if I could give the court the reference, it's Part B, page 297, and that's the suspension letter that was sent to Advocate Nkebane. And the President says, at paragraph 6 of that letter, here are the reasons for my decision. And here that comes directly out of that report. And he then says, the institutions, etc., parties that must contribute. And then the sixth reason is that to date, the Section 194 inquiry has run over extended period, 4 weeks at a time of 5 months. concerns around the current staff of the NLS and the fact that the office is, by all accounts, doing very well in this regard based on what's in the application. And so for all of those reasons, Justices, we say that on the requirement of irreparable harm, we looked at in the context of the public interest to communicate evidence. We submit that no cases in made. We submit that no cases in made. And then the last issue is the question of prospects of success in the appeal. And the court will see that we dealt with this in the President's answering affidavit, except volume 8, page 734, at paragraph 54 and following. And the President says at paragraph 59, Mr. Olas, on behalf of the President, in any event, I respectfully submit that the President's appeal has reasonable prospects of success. A copy of the application to the Constitutional Court is attached. I ask that the grounds of appeal as set out therein and the basis for each of those grounds be read as explicitly incorporated into this application. And then if the court has regard to those grounds, they appear at page 752. And I'm not going to be arguing the application for leave to appeal, but the conditional application in the fullness of time to this court. But the court will see the grounds on which the President's identified as the basis for the appeal. And the first is that the first reason given by this court had to do with not the conduct of the President, but the conduct of the public protector that the Constitutional Court found was questionable or trade tainted because she couldn't bring an open mind to bear in relation to engaging with the President. And that was the court's first reason on that, and we submit that there's a reasonable prospect that the Constitutional Court would say that ought not to be a basis on which to find the President's actual or reasonable application bias. The second is that we say that this court concluded that after the President got that letter, and we quoted it in 3.2.2 from the public protector, and the court says to suggest that such a suspension would not have any effect on delaying the course of the investigation would be a difficult proposition to convincingly sustain. And we submit that there's no evidence before the court on delay. It's entirely speculative on that. And as it turns out, based on what the acting public protector has told us in the affidavit, there's certainly not to be no basis to support that. Thirdly, we identify this court's conclusion that's at 3.2.3, where this court says that given the expansive nature of the questions that the President was required to answer in the short space of time, may well have forced the President to conclude there she goes again. And that rather than to have to compare better off with any person but the applicant. And we see that there's no evidence to support such a finding. We then say that the court adopted an unduly limited view on the timeline by focusing disproportionately with respect on the events from the 7th of June, given the history that predated it and going back to 18th of March. Around the allegations that the President suspended in response to the letter, and that the letter had prompted the President to suspend, we submit there's no basis for that on the evidence. And we say there's certainly no basis for the court's conclusion that on the objective facts, there was a reasonable apprehension of bias. And the submission is with respect that on the findings, there's a degree of ambivalence on the court's own findings as to the basis on which some conclusions were reached. Justices, I'm not going to, and perhaps just the last 2 points which we raised there, is just the court's findings on the retaliatory response of the President and on the hurried nature of the response. And we submit that all of that is done and put place before the Constitution Court. At the very least, there's a reasonable prospect that the Constitution Court would find otherwise. And in engaging on that question, I submit that the Constitutional Court will be very much alive to the fact that there is no challenge to the President's reasons for this decision. So substantively, there's no challenge on that. Secondly, on the evidence, there's no basis on which to suggest that the acting public protector isn't bringing an open mind to bear in the vindication of her role as acting public protector. And in those circumstances, one would ask, what then was the benefit, if anything, that the President was to derive from the suspension? And we submit none at all, and none's been shown on the evidence. So for all of those reasons, Justices, we say that there's a reasonable prospect that an appeal court, the Constitutional Court, would find otherwise. Justices, just one last point. You'll recall in the haste in which the affidavits were drafted, it wasn't possible to get the President to sign those affidavits, and they were signed by the President's attorney, Mr. Mark Owen. Surprisingly, we saw that the Friends took that as a point in the replying affidavit. The court is well acquainted with the case law dealing with the public galleries will go there. But if there's any issue, the President has now signed a confirmatory affidavit, which I will do to hand over. I understand that the President's not available for the next 4 days, so he will, the originals will be sent to the Plaza on the 20th. Justices, just on the preliminary investigation that was done by the 994 committee, which preceded the inquiry, if I could just give you the reference at volume 9, page 811 to 900, and at volume 10, 901 to 929. Those are the Part A papers, and the court will be aware that there's no challenge to any of those conclusions in that preliminary report, and the President's reasons for the suspension, the substantive reasons, are largely common in the report. So for all of those reasons, Justices, we submit no case has been laid out, and the application ought to be dismissed for costs, including costs of the council. If anyone has any questions, as an explanation.
Thank you, Mr. Mayor. Mr. Bucklander.
Thank you, Lord. Lords, I've listened carefully to the argument that our learned friend Mr. Pillay has advanced, and much of the argument that we will advance overlaps, and I will ensure that I do not repeat it, save where I need to add emphasis. I'm going to try and be relatively crisp and focused on the critical issue. And in doing so, my lords, I'm going to resist to be drawn into what I can only describe as insult-burning and political sideshows. Our learned friend Mr. Mpofu made various remarks about the scandalous conduct of the DA. I'm not going to get into it. Safe to say that the DA's position is that this is necessary in order for the Constitution to be upheld. But in truth, this case doesn't depend on people's motives, it depends on the law. And I'm going to demonstrate to you why, as a matter of law, this application is fatally flawed. For the same reason, I'm going to resist the urge to get into the speculation and conjecture raised by our learned friends Mr. Ngalwana and Mr. Masuku around what did or didn't happen in the Part A judgment and who stamped what when. With great respect, I don't understand how that can be remotely relevant to the questions which are before this court. And the questions before this court are twofold. Number one, does Section 18 apply? If it doesn't, that's the end of the matter. And number two, if Section 18 applies, have its requirements been met? And if the answer is no, then that is again the end of the matter. So with great respect, you've been taken on a tour of all sorts of things, but I'm going to focus on those points of law because those are what are dispositive of this matter. So could I begin with that first issue, and I'll deal with the first issue first, and that is the section 18 point, and does it apply? And it's linked to the question of confirmation proceedings. My learned friend Ms. Pillay has the court set aside the decision to suspend. It did so not merely on constitutional grounds, but also on common law grounds. And he repeatedly makes the point to the court about what the Part A judgment found. With great respect, what the Part A judgment found is not the debate today. It's what this court found and what the effect of its order is. But there is a far more crisp and decisive answer to this. This argument, which says where you invalidate the president's conduct on common law grounds, that is not subject to confirmation by the Constitutional Court. That very argument, in so many words, was rejected more than 20 years ago by a unanimous Constitutional Court in the decision in pharmaceutical manufacturers. And I apologize for reading at some length, but it is dispositive of an argument that was pressed with considerable gusto this morning. Now, in pharmaceutical manufacturers, the court was also dealing with the question of presidential conduct. It was a decision to bring into force certain regulations. The High Court declared it invalid, and the question that arose, just as here, is was that subject to confirmation by the Constitutional Court before it was effective? And the argument that was advanced was virtually word for word the same argument that was advanced today. And you see that in paragraph 21, where Mr. Bertelsmann, one of the parties, said as follows. Mr. Bertelsmann contended that the question of whether the president acted ultra vires also raised an issue under the common law, and that the finding of the full bench was a finding made in terms of the common law, and that it was accordingly not a finding of constitutional invalidity within the meaning of 172(2)(a) of the Constitution. In support of this argument, he placed reliance on the decision of the SCA in container logistics. And then the next relevant paragraph, Justice Chastelson, speaking for a unanimous court, paragraph 33 says, I take a different view. The control of public power by the courts through judicial review is and has always been a constitutional matter. And then there's a discussion about the interim constitution, and then Justice Chastelson says in paragraph 33, the common law principles that previously provided the grounds for judicial review of public power have been subsumed under the Constitution, and insofar as they might continue to be relevant to judicial review, they gain their force from the Constitution. In the judicial review of public power, the two are intertwined and do not constitute separate concepts. I deal with this more fully below. And Justice Chastelson then went on to deal with it in considerable detail, and in particular with the container logistics dictum, which had been relied on by Mr. Bertelsmann, as he then was, and which is the effect of the argument now. And in paragraph 44, he rejected it. Justice Chastelson saying, I cannot accept the contention which treats the common law as a body separate and distinct from the Constitution. And then it's arguably the most famous dictum in that judgment. There are not two systems of law, each dealing with the same subject matter, each having similar requirements, each operating in its own field with its own highest court. There is only one system of law. It is shaped by the Constitution, which is the supreme law, and all law, including the common law, derives its force from the Constitution and is subject to constitutional control. Now, so the suggestion that where a court says the president is biased at common law and sets his decision aside, that's not subject to confirmation. But if the court says the president is biased and in breach of 96(2), then it is subject. It was rejected squarely in this judgment. And just to finish at the point, paragraph 56 says, this is the context in which section 172(2)(a) provides that an order made by the SCA or High Court concerning the constitutional validity of blah, 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 the president of the conduct has no force unless confirmed by the Constitutional Court. And it goes on to explain the purpose. We've quoted paragraph 56 at length, and it says this purpose would be defeated if an issue concerning the legality of the conduct of the president, which raises a constitutional issue of considerable importance, could be characterized as not falling under 172(2)(a and thereby removed from the controlling power of this court. I am accordingly of the opinion that the submission made on behalf of the president is correct and that the decision of the full bench is subject to confirmation in terms of 172(2)(a of the Constitution. And that, with respect, has never been departed from. It's been consistently applied, and it is the end of the common law argument which is advanced by Advocate Mkhwebane. That then takes us to the second route by which Advocate Mkhwebane seeks to avoid the effect of this argument, and that is the attempt to try and disaggregate paragraph 187.5 and paragraph 187.6 of this court's judgment. And the argument is curious with respect, because our learned friend Mr. Mpofu accepts that it could have been a single order, and it need not have been two separate orders. But with great respect to our learned friends, both Mr. Mpofu and Mr. Ngalwana and Mr. Masuku have not done is they have not taken this court to its reasoning on 187.6. And when you do that, it becomes absolutely clear. So could I ask the court to turn to its judgment, and the judgment is found in these papers at page, or the relevant portion, I should say, is found in these papers at page 92 of the volume. So what this court does with respect in its judgment is it begins on this point by explaining that there was a breach, a problem of conflict or bias, which it concludes with 171, paragraph 171. And it then says, we now turn to deal with the just and equitable remedy. So the court is very correctly and explicitly saying, first we determine whether it's unconstitutional. In other words, 172(1)(a), just getting the Constitution here, 172(1)(a), and then we turn to deal with the just and equitable order, 172(1)(b). Those are the two sides of the same coin. And the court says under 172, the court then says under the heading, the just and equitable remedy. So that's the 172(1)(b) remedy. The court says, just and equitable remedy sought by the applicant is the setting aside of her suspension. Just let me pause. It's therefore clear that what we are talking about is the setting aside. That is the debate, nothing else. We are talking about the setting aside when we deal with this. And the court says the president made no submissions, and the DA was submitted, that's over the page, that the court should limit the retrospectivity of this order. Now just let me pause there again. We of course know that where conduct is unlawful under the Constitution, the default position is that it is invalid from the moment it came into conflict with the Constitution, that is from the moment it took place. That's the objective theory of invalidity, which has been part of our law since Ferreira versus Levine. So on that theory, it's invalid from the moment the president makes his decision. That's the objective theory. But of course, we also know that the court has the power to defer or prevent the retrospective order, and that's what the DA had asked it to do, and that's what the court did. So it was submitted on behalf of the DA that in the design of a just and equitable remedy, the court should exercise its power to limit the retrospectivity of this order. And there's a reference to Kunjana, there's a reference to the importance of the public protector, and the problem with retrospective invalidity. And at 175, this court says, an order setting aside the suspension retrospectively would have no practical positive effect. On the other hand, it would risk disrupting the affairs of the Office of the Public Protector. We are thus of the view that a just and equitable remedy would be to set aside the suspension prospectively. We now turn to the issue of abuse. So, it's with respect, crystal clear, what this, and quite correct in terms of the approach to remedy, the two things going hand in hand. Whether the right remedy is granted is a different debate. So the approach is quite correct. You'll see then that what the court has done under 187.5 is it's granted the order under 172(1)(a), the decision of the president to suspend the applicant is hereby declared invalid, and then over the page, the suspension is hereby set aside effectively from the date of this order. And my learned friend is right. The court could have done it in one sentence. The court could have said the decision of the President to suspend the applicant is hereby declared invalid with effect from the date of the order. Quite right. But what that proves is that this attempt to sort of hermetically seal the two parts is hopeless with respect, because they are orders contemplated by 172(1), A and B. They are orders. They are orders which are the declaration of invalidity and the just and equitable relief, which is sometimes called the ancillary order, to give effect to that. And both of those orders are subject to confirmation by the Constitutional Court. How do we know that? We know that because of what my learned friend Ms. Pillay so helpfully draws to our attention, paragraph 18 of Darwood, which says, quite expressly, all of the orders granted relief consequent upon the finding of unconstitutionality and are accordingly before this court as part of the confirmation proceedings. And similarly, in that same paragraph, for it is not only the direct order of unconstitutionality itself that must be confirmed, but all the orders made by the High Court that flow from that finding of unconstitutionality. It couldn't be clearer, but if it needed to be clearer, it is made clearer by the judgment in McBride, which we have quoted to you, which was the exact same principle. What happened in McBride is there was a statute which was declared invalid. It was the IPID Act. And well, let me go back a second. What happened in McBride was that the Minister of Police had suspended Robert McBride and had done so pursuant to a statute. Mr. McBride challenged the statute and succeeded in challenging the statute with the consequence that the suspension off the back of the statute was set aside. And when you have a chance to read the McBride case, you will see that. I'm talking about the McBride case we refer to in the heads. It's the judgment of the Pretoria High Court. And what happened there is Prayer 1 declared various provisions unconstitutional. Prayer 2 suspended it. Prayer 3 granted interim reading in. And Prayer 4 said, it is declared that the decision of the Minister of Police to suspend the applicant is unlawful and invalid, and the decision is set aside. And there was a fight in that court. I was for Mr. McBride, my learned friend Mr. Luca Tolby was for the Minister of Police. There was a fight in the High Court about which of these orders are subject to confirmation. And the judge said expressly in the paragraphs we cite, all of these orders are subject to confirmation because it's the main order and the subsequent orders that go off the back of it. And she referred in this regard to the judgments in Satchwell, the judgment in Bori. I must confess she didn't refer to the judgment in Darwood. That is because I hadn't found Darwood. If Ms. Pillay had been in the case, she would have referred to Darwood and it would have put it beyond doubt. But I didn't find Darwood. But the point is, it's clear on the basis of Darwood and McBride that all of the orders are subject to this. This discussion also makes clear with respect, Justice Nuku, members of the bench, that the belated argument to suggest that this order granted under 187.6 is a 172(2)B order. That's the argument of our learned friend Mr. Masuku. The argument goes, well, actually, that order is a 172(2)B order, but that with respect is not so. None of us advanced argument to you on 172(2)B and interim relief pending confirmation. None of us even advanced argument to you on confirmation. It just wasn't an issue that arose. So you were not asked to make an order under 172(2)B, and if you had been asked to make an order under 172(2)B, the order would have had to be something like, the suspension will take effect today and will endure until the question of confirmation has been decided. That's not what this court's order said. It's not what this court's reason said. It is with great respect a make-weight argument for and I would, with great respect, hazard a guess that this court would be surprised if it has been told, as it has been, that it was actually making an order under 172(2)B when it made that order. It plainly wasn't. It made an order under 172(1)B and it passed an equitable relief, which is what 172(1)B says. So, the common law argument, with great respect, cannot get out of the starting blocks in light of pharmaceuticals. the attempt to separate the arguments and contend, the orders, and contend that the 187.6 order is not subject to confirmation, cannot get out of the starting blocks in either Darwin or Drive. And so plainly, all of this has to go to the Constitutional Court for confirmation. That much is clear. The only remaining question is, what does that mean about Section 18? And what it means with respect is that Section 18 plainly doesn't apply, because as our learned friend Ms. Pillay explained in answer to the question from Justice Nuku, Section 18 exists in order to create a position where an order applies and displace the effect of an appeal. The ordinary effect of an appeal is to suspend. Section 18 allows the court to depart from that, and so it says the court can override an appeal and apply it in the meantime. That's not this case, because in this case, the reason that 187.5 and 187.6 are not operational has nothing to do with whether anyone appealed. It flows from the Constitution. The orders are incoherent. They are of no force in effect because of the Constitution, and whether the DA lodged its appeal or didn't lodge its appeal, and whether the President lodged his appeal or didn't, is irrelevant as a matter of law. I'll come in a moment to why the appeals were lodged. It is irrelevant, and 18, therefore, Section 18, therefore, patently has no application whatsoever. Let me just make one last point on that. Where the Constitution provides that an order is incoherent and will have no force or effect pending confirmation by the Constitutional Court, that doesn't render the order interlocutory. That's the additional new argument that we've got. We all know what an interlocutory order is. An interlocutory order is an order postponing a matter, or an order compelling production of documents, or even an order. It's the sort of procedural orders that make the courts run. And that's why 18.2 says the ordinary rule is it doesn't suspend, because if otherwise everyone would appeal against every procedural order and the courts would never get anywhere. I don't mean to be disrespectful, but it's the lowest of the low. It's the orders which don't determine anyone's substantive rights. They just regulate who's going to file when, discovery, etc. The order we're dealing with is the very opposite. It is the highest of the high. It is the determination of whether the President's conduct is constitutional and what the remedy should be and when it should take effect. It is the kind of order which the Constitution reserves for only the Constitutional Court to finally pronounce on. To say that that is now an interlocutory order with respect makes no sense whatsoever. This is a special category of orders created by the Constitution, and it would require the clearest of language to say that it is now subject to some different regime and there's nothing in it. So, Section 18, we say, does not apply for all of the reasons I articulated. And what that means, and I'm not using my words here, I'm using those of my learned friend, Mr. Mpofu, and this is what he said this morning: if Section 18 doesn't apply, we can all go home. That's what he told this court this morning, and with respect, it's the only submission he made that I agreed with, but it's correct. If Section 18 doesn't apply, we can all go home. And why can we all go home? Because this is an application that was brought in terms of Section 18. Prayer 2 of the Notice of Motion says so. The founding affidavit says so, again and again. This is an application brought in terms of Section 18. If Section 18 is not applicable, and it is not, we can all go home, and that ought to be the end of the case. What cannot be done with respect is a last gasp attempt to smuggle in 172.2b. So, well, actually, this is sort of an application in terms of 172.2b. That is not the case that is made up in the papers, in the affidavit, or in the notice of motion, and it is not the case that's been argued to, because with great respect, the test for under 172.2b is something you haven't heard any argument about. And it goes to the points that our learned friend Ms. Pillay made about why the court has, the Constitutional Court, not this court, the Constitutional Court has said that holding litigants to pleadings is not pedantry, but is in fact an essential part of fairness in litigation. If you are going to try and decide with great respect this evening, or tomorrow, or whenever, whether 172.2b is applied, you are going to have done so with no argument whatsoever on the test for 172.2b, on the basis of facts which have not engaged 172.2b, and in circumstances where no one's had a chance to answer that case. And that would be grossly unfair, and with respect, it would be an overreach. But what's more, it's not as though the public protector was not told. The public protector was told in advance that the DA's understanding of the law was that this was all subject to confirmation. And I'll take you to the letter in a minute. So it's not as though this is some clever point raised in answer. It was a point that was raised in advance. And that is my last point on this score, and I'd like to just briefly deal with it. Because the other argument that is advanced is that somehow the DA's application for leave to appeal is fatally defective or flawed or various other words. Well, I say two things with respect. Firstly, it's not, and I'll deal with the why in a moment. But secondly, even if it is, it's irrelevant. Because as I've explained, even if the DA hadn't applied for leave to appeal, even if the President hadn't sought leave to appeal, the orders are still inchoate, they are still not enforced. Why? Because that's what 172.2a and 167.5 of the Constitution says. But let me just round up on this first leg of the argument by just very briefly taking into the papers. And you know the sequence, but let me take you there anyway. If we could begin briefly at 101. What happened, of course, is that this court delivered its judgment. And at 101, there was a letter that was written by my attorney, which said, to avoid any confusion, we draw your attention to 172.2a, which is the one we've been debating, it quotes it. The High Court order therefore has no effect unless and until confirmed by the Constitutional Court. We trust that your client will in due course seek the necessary confirmation. That's correct with respect, but it was put on record. What came back is what can only be described as vitriol. Carrie saying it's vindictive desperation and rejecting it with the contempt that it deserves. I'm not going to get into it. The bottom line is the PP disagree, is the most polite way of putting it. It then became clear that there was a disagreement between the parties. The DA said this is subject to confirmation. The PP said it is not. And so the DA did not something that is abusive or improper, but something that is eminently proper, which is it said, well, in case you're right, we are now exercising our rights to go to the Constitutional Court. And you, of course, have the application. It appears at page 106. And you will see there that what the DA does is it does two things. It notes an appeal on the assumption that the matter is subject to confirmation. And in the alternative, it applies for leave to appeal in the event that it's not. And that is, as the grounds of appeal appear at pages 110 to 112. I don't need to go through them. The DA explains quite openly what it's doing at 115. The DA explains at 115, paragraphs 8 to 13, that the DA's position is subject to confirmation. The DA even draws attention to a case on that point. It's the answer decision. And then at 160, the DA says, but in the event that we are wrong, the DA, paragraph 17, page 116, the DA wishes to avoid this case being mired in such technical debates and the confusion that could result. Therefore, in addition to appealing of the right, in terms of the provisions set up above, the DA, in the alternative, hereby applies for an order granting it leave to appeal directly. The DA does so purely as a matter of caution. Our learned friend says it doesn't tick the boxes necessary to be an application for leave to appeal, but with respect, that's not right. Over the page, you will see, paragraph 19, I reiterate that the DA's proposed grounds of appeal are set out in Annexure A, and I pray that they be incorporated. Paragraph 20, I submit that it's plain from a mere reading of the grounds that all of the issues raised are constitutional issues, that the constitutional issues and remedy are novel and far-reaching, and that the DA bears at least reasonable prospects of success. So the boxes are ticked for an application for leave to appeal. And then paragraph 21, I accordingly submit it's plainly in the interest, should read in the interest of justice, for direct leave to appeal to be granted to this court, because finality and certainty must be obtained as a matter of urgency. So the DA even explains why the SCA should be bypassed, direct leave to appeal should be granted. Now, the Constitutional Court will have to decide in due course what to do with all of this. We say they will decide that it's subject to confirmation. But to suggest that there is no pending application for leave to appeal is plainly bad. And lastly on this point, if I could go back to page 104, the DA put its cards on the table. It wrote its proposal to the PP's attorneys and said, 104, we respectfully disagree with your views and reiterate that the orders of the High Court have no force and effect until confirmed. We draw your attention in this regard to the decision in answer as paragraphs 30 to 37. So the DA said, that's the law. However, as you would have seen, our client is in any event served an application for leave to appeal. This means if our client is correct, if your client is correct, etc. So I make this point because if there was a moment to say, okay, we're now bringing an application in terms of 172.2b, if that was even permissible, and I don't concede that it was, but if it were permissible, that was the moment to do so. Then, to say, all right, we see you say it's subject to confirmation, whether you're right or not as a matter of caution, we hereby apply in terms of 172.2b. And we could have had a different debate. But the PP doesn't. The PP launches an application, knowing about the answer judgment, knowing about the DA's position, she launches an application in terms of Section 18, and with great respect, the application is fatal for the reasons I've articulated, and it can't be resuscitated by some vague reference to 172.2b in reply or in argument. Justice Luca, members of the court, that ought to be the end of the case. Because what that means is that the application has been improperly brought, that this court has no jurisdiction to grant it, because the court can't put into force an order that is incoherent because of the provisions of the Constitution. And on that basis alone, the application should be dismissed. But if we're wrong on that score, we then deal with the substantive requirements of Section 18. And I need to be emphatic about this. We don't raise this technical point because we're scared of the substantive requirements. We say the substantive requirements, if anything, are even stronger that they haven't made out a case. But with respect, the court doesn't even need to get there. But let me deal with the substantive requirements, because we say that the public protector does not even get out of the starting blocks. Now, could I just take a step back for a moment on Section 18? Section 18 says the following. The common law used to say, and I'm doing an injustice to Justice Corbett, but you'll forgive me, you pretty much weigh up irreparable harm when you're trying to decide an interim execution. You weigh up harm to the one party, you weigh up harm to the other party, you do a balance of convenience, and you figure it out. Now that is an injustice, but that is the gist of it. Section 18, the SCA has repeatedly made it clear, is a change. It sets a series of 3 requirements that must be met. Overlapping requirements, but 3 requirements. If those are not met, this court has no jurisdiction. Not more. The first requirement of the case must be exceptional, and I'll come back to what that means. The second requirement is that there must be prejudice, irreparable harm, to the winning party in the court below, that's the PP, if interim execution is not granted. And the third requirement is that there must be no irreparable harm to the other parties if immediate execution is required. Now, let me just say, Section 18.3 makes it absolutely clear in words of one syllable. Firstly, that the onus to demonstrate that and prove that rests on applicant and provider. That's what it says. The onus to prove it on a balance of probability rests on applicant and provider. But secondly, you have to tick all 3 boxes. You have to tick the exceptional circumstances box, and you have to tick the irreparable harm to advocate and providing box, and you have to tick the box which says no irreparable harm to the other parties and the public, which I'll come to in a minute. If you can't tick all 3, if you can only tick 2 out of 3, then you lose if you are advocating per bond. The cases say that. Justice Wallace says it in Kroon. Yeah. He says so expressly. So this is not an interim intellect case where you weigh on the one hand, on the other hand, then you take a rough and ready approach. It's not the South Cape approach, pre the 2013 Act. It is an exercise designed to promote suspension, mostly pending appeal, except in the most extraordinary circumstances. So, let's deal with each of those 3 requirements. Exceptional circumstances, irreparable harm, and irreparable harm again. On the exceptional circumstances, we agree with our learned friend, Ms. Pillay, with respect. It's not that you've got to show that the case is exceptional. You've got to show that do more. You've got to show that there are exceptional circumstances which warrant the operationalization, let me get that right, of the order. That's what you've got to show. Our learned friend, Mr. Mpofu, said that's not the law. You've just got to show it's exceptional. And the exceptionality has nothing to do with irreparable harm. That's wrong with respect. It's wrong with respect because that's exactly the opposite of what the SCA held in the Premier Gauteng case. In Premier Gauteng, which we cited to you, the court at paragraph 13 said the following. In other words, the test in terms of section 18 requires that exceptional circumstances must exist, and this involves two factual findings. A party seeking leave to execute must show firstly that the applicant for leave to appeal would not suffer irreparable harm if the order is put into operation, and secondly that he or she would suffer irreparable harm if the order remains suspended. The circumstances must be such as to justify the deviation from the norm. So it's not enough with respect to say, this is an important case, this is an exceptional case, this is the case that's the first of its kind. You have to show all of that and show that those things are linked to the need to put this order into effect pending appeal. Now, as we've demonstrated, exactly the opposite is true. And I'll come to the cases in a moment. But it is precisely because this is the first case of its kind where a Chapter 9 institution head faces impeachment, that the court should not be putting it into effect because of the harm that that would do and the prejudice that would do to the public interest. And I'll come to that. So it is not enough to say this is an exceptional case. Of course, we accept it's exceptional in that sense. And my learned friend tries to say that concedes the case and therefore we don't vote. That's not, it's quite clear from the affidavit, obviously, and it's quite clear from the case. The difficulty is that it's got to be shown that it's exceptional, such as to justify immediate operation. And that the exceptional circumstances, as the SCA said in Premier Gauteng, are linked to those two factual findings. That, as we demonstrate, has not been met. So let me turn to those two questions of prejudice and let me deal with them in turn. So the first is the prejudice to Advocate Mkhwebane. And the heads of argument, the papers make wide-ranging allegations about inability to obtain documents, about the problems with Phala Phala, about undermining the office of the public protector. But then, of course, came the affidavit of the acting public protector. And that affidavit makes absolutely clear that the allegations made in regard to all of that are, with great respect, incorrect. So what we have in the heads and in the argument this morning is effectively a pivot. And the only argument that is advanced with any gusto, and you will recall this, both in the heads and this morning, is an argument that suspension is prejudicial to Advocate Mkhwebane personally. That's the argument. She's been on suspension for 3 months. It is a breach of her dignity. It is grossly prejudicial to her, so the argument goes, to remain on suspension. That's the argument. The trouble with the argument is that it is utterly inconsistent with the series of authorities that we have put up, and that no authorities, meaningfully, are put up in support of it. The only authority that is relied on this morning by our learned friend is the concurring judgment of Justice Sachs dealing with the issue in Maseka. With great respect to Justice Sachs, that is not the law. It is the judgment of a single judge sitting in the Constitutional Court, and I'm going to take you to the authorities which are the authorities of the unanimous Constitutional Court, which say the opposite. Can we begin with Long? Long is the judgment of the Constitutional Court, which we have cited in our heads of argument. It's Long versus SAB, and we have cited it in paragraph 55. Now, in Long, this is a judgment delivered just 3 years ago. A unanimous Constitutional Court held that in the context of precautionary suspension, there will usually be no perceptible prejudice if the suspension is on full pay. The court said, generally where the suspension is on full pay, cognizable prejudice will be ameliorated. Well, we know Advocate Mkhwebane is on full pay. That is Long. That is the binding authority of a unanimous Constitutional Court. We then know that in Part A of this court, this case, the judgment of this division said the same. It held, and this is in paragraph 57, that a precautionary suspension with remuneration does not result in material prejudice against the person so suspended. Now, of course, I know that there the court took a different view on bias, but I'm not debating bias, I'm debating harm. And what that court found, and it's binding on this court, unless it's clearly wrong, is that precautionary suspension with remuneration does not result in material prejudice. Now that with respect ought to be the end of the case. That's all you need to look at, is one of those two judgments. But it gets even worse, because courts have dealt with this question of prejudice even in the context of 18.3 applications. And that emerges from the decisions around Mr. Motsoeneng. But the background is immensely complicated. I will summarize it crudely like this. The PP, the then PP, made findings against Mr. Motsoeneng, who was the chief operating officer of the SABC. There was a debate about what would become of those findings. This is all pre-Nkandla, so no one knew what the status of the PP's recommendations were. So the DA brings an application which compels the SABC to institute disciplinary proceedings against Mr. Motsoeneng, and the DA ultimately succeeds. But in the midst of this case, bouncing between this court and the SCA and backwards and forwards, an issue arises. Should the order be put into operation pending appeal? In other words, should Mr. Motsoeneng be suspended pending appeal? And Justice Schippers, sitting in this court, as he then did, said squarely that if Mr. Motsoeneng was kept out of office pending appeal, I'm reading paragraph 58 of the heads, if Mr. Motsoeneng was kept out of office pending appeal, he will not suffer irreparable prejudice. That's a quote. Justice Schippers explained, quote, he will suffer no loss of remuneration and the suspension is for a limited period while the disciplinary took its course. Now, that was Justice Schippers, but that was expressly approved by a unanimous SCA in the case of SABC versus Democratic Alliance. Could I give you the reference? It's not in the head. It's SABC versus the DA, 2016-2, SA 522, SCA, and it's paragraph 61. And there the court said as follows. In light of the public protector's findings and the events subsequent to her report, the High Court was rightly concerned that Mr. Motsoeneng should not continue to be in office with serious allegations concerning maladministration and the integrity of the SABC hanging over. Can I just pause? Mr. Motsoeneng hadn't been found guilty in a disciplinary. All that there was a public protector report saying that this is the story and there must be disciplinary conduct. The SCA says the High Court was rightly concerned that he should not continue to be in office with serious allegations concerning maladministration and the integrity of the SABC hanging over. The High Court approached the inquiry thus, and then the SCA quotes it. The allegations against Mr. Motsoeneng are serious. He's the CEO of the SABC. He's the executive member of the board. He has virtually unlimited authority over his subordinates and access to all of the documentation in relation to the charges of misconduct that will be preferred against him.
Please try again.
I'm hoping it's not me who's causing trouble with the connection. Given the nature of the allegations and the persons involved referred to in the report, Mr. Motsoeneng's fellow board members and his subordinates would have to be interviewed and the documents produced. What this shows is that unless he is suspended, Motsoeneng poses a real risk not only to the integrity of the investigation concerning the allegations of his misconduct, but to the disciplinary inquiry itself. It is untenable. It is untenable that he should remain in office while the disciplinary proceedings are brought against him. In those circumstances, and in light of the allegations of abuse of power in the report, in my opinion, there can be no doubt that it is just and equitable that Motsoeneng should be suspended, pending the finalization of disciplinary proceedings to be brought against him. Good administration of the SABC and openness and accountability demand his suspension. That was Justice Schippers. And what did the SCA say about that? Unanimously. The approach of the High Court cannot be faulted. Now, with respect, all of that applies.
But is this not distinguishable in the sense that in this matter, this court is dealing with the head of a Chapter 9 institution?
No, with respect. That is not distinguishable because the principle that I'm arguing, there are two principles. The first is it prejudicial to be suspended with pay pending the disciplinary? And long, this court, SABC, all say no. And that doesn't matter with respect whether you're the head of the SABC, the head of SAB, or the head of a Chapter 9 institution. The second principle is it prejudicial to leave someone in office while they are being subject to a disciplinary inquiry when they are the head of the institution? And on this authority, the answer is it is. And again, it doesn't matter whether you're the head of the public protector, the head of the SABC, or the head of SAB, the same principle applies. So with respect, Justice Lukuleni, it's an important question. but there is no distinction on these principles. And that's why, with respect, the argument advanced by our learned friend Mr. Masuku is most surprising. You heard a long argument about the presumption of integrity. Well, no authority was given to you for that proposition about the presumption of integrity. But more importantly, it flies directly in the face of these sorts of judgments, which say, where allegations are made, you haven't been convicted. Where allegations are made against you, you can be suspended. It can be just and equitable suspending, changing the argument. So what we say in respect is when you consider when you consider the Part A judgment, when you consider SABC versus the DA, it's absolutely crystal clear that there is no prejudice, never mind irreparable harm. There is no prejudice caused by being kept out of office pending appeal. That's what we're doing. What authorities have you been given on the other side of the table? Justice Sanders, that can stand in the way of the authorities you've given. So that suspension prejudice point, which is the mainstay of the argument you had today, is with respect to dead in the water. What is left then are 2 points. The first is an argument that the suspension, that if the order is not carried out, this will harm Advocate Mkhwebani's reputation. But that argument, as we've explained, is if there is harm to her reputation, it's not caused by a failure to implement this court's order. It's caused by all the allegations that have been made against her in the Constitutional Court judgments and the ongoing impeachment process. That's not me saying that. That's what the FCA said in Mhlomeza. It's exactly what the FCA said in Mhlomeza, paragraph 46. We've quoted it at 60.1.1. And of course, if she ultimately succeeds in the Constitutional Court, perhaps the reputational damage will be undone. Lastly, there is the reference to the inevitable destabilization and delays to the Phala investigation and the general work of the public protector. That argument with respect does not go anywhere in light of the answering affidavit of the acting public protector, and it simply doesn't go anywhere. So, what irreparable harm has Advocate Mkhwebani established to justify the order being put into effect? The simple answer is none. And that is the end of the matter, because she has to tick that box to have any hope of succeeding. But even if we're wrong on that, even if somehow she could tick that box, she still has to tick the second box. And the second box is that there is no irreparable harm caused in putting into place this order pending the appeal. Now, our learned friend argued at some length, that there was no harm because all that counted was the parties and the DA couldn't point to any harm, and therefore that was the end of it. But with great respect, as the bench put to him, this is a case where the harm to the DA overlaps with the harm to the public, and it is that harm to the public which is not only permissibly taken into account, but must be taken into account when dealing with this question. But before I get there, I need to make 2 points. The argument that was advanced this morning almost acted as though there was no justification for the suspension of Advocate Mkhwebani. But that, with respect, was not this court's judgment. This court did not find that the suspension was substantively irrational or unreasonable. As our learned friend Ms. Pillay argued, that was not even the argument that was advanced. This court found that the decision was taken by someone with a conflict of interest. Now, if that is correct, let's assume that's correct. That decision could be taken again by the next person. So with respect, there is no basis to say Advocate Mkhwebani has a right to be in office because this is also egregious. With respect, the only debate is the second point is that there is no evidence at all that the acting public is anything in the form of lacking in independence, lacking in impartiality, like comments. There was no evidence in that case, there is no evidence now. So when we talk about public, does the public's harm count? with respect, quite expressly in the Motsoeneng and Inhlemeza judgments, public harm counted. So in Motsoeneng, which we cited paragraph 69.1, Justice Skippers held that if Mr. Motsoeneng was allowed to remain in office, it would, quote, constitute irreparable harm to the public interest. And I've just pointed to you that that was approved by the SCA. In Inhlemeza, the SCA held that given the crucial place that the Hawks enjoy in our young democracy, the public interest would suffer irreparable harm if Mr. Inhlemeza were allowed to remain in his position pending appeal. Now, with respect, who were the parties in that case? Well, in one case, in Motsoeneng, it was the DA. In another case, in Inhlemeza, the parties were the Helen Suzman Foundation and one of the other NGOs. They were not parties who were directly involved in the dispute. They were parties who came in the public interest. And yet the SCA held again and again that that was good enough for harm. Now, if harm to the public interest because Mr. Inhlemeza and the HSF would be harmed was good enough for Section 18, and if harm to the public and the DA, for if Mr. Motsoeneng were allowed into office, is good enough, why would the same not apply here? Because if anything, there's a greater duty. Why? Because Justice Lekulin, because it is the head of a Chapter 9 institution, it is all the more important that there not be someone in office over whom this enormous cloud looms and the difficulty. So when we ask the question, whose harm counts? The answer is the DA's harm and the harm to the public unquestionably count on the clear and binding authority of Inhlemeza and Motsoeneng. So we say with respect that the forms of harm that exist are helpful. The first is that the courts have found, rightly or wrongly, whatever Advocate Mkhwebane may think, the courts have found that Advocate Mkhwebane is dishonest, she has misled the courts, she has not carried out her duties properly. The 194 Sifting Committee, led by Justice Mkhwebane, found that there was a proper case to answer on that score, sometimes in ringing tones. The evidence then in Parliament plainly needs to be answered. So we are dealing here not just with someone like in Mr. Motsoeneng's case, where there's a finding by the PP, we're dealing with a finding by the Constitutional Court. In those circumstances, the harm to public faith of keeping Advocate Mkhwebane in office before she's been cleared is truly irreparable. I'm told the second applicant in Inhlemeza was freedom under law, so that one makes sense. So the harm of keeping Advocate Mkhwebane in public office, heading up a Chapter 9 institution, is enormous until she's been cleared. Now, if she is cleared, then the story is different. But until she is cleared, to say that we're going to have one of the most important institutions in government, one that is immersed, as you can see, in all of these endless political debates, to have that headed by someone who has been held by the courts to have acted improperly, that is obviously damaging for exactly the reasons that the FCA gave in the Inhlemeza case and exactly the reasons that the FCA gave in the Motsoeneng case. That should be enough. But secondly, there is the difficulty, which has been alluded to, of delays in the 194 proceedings, because it is difficult to understand how you can be the head of the Public Protector Office, an extraordinarily demanding job, and similarly be attending hearings, defending yourself every day in the 194 process. So what will inevitably happen, as has already happened this week because of this application, is there will be postponements and delays, and that is prejudicial, as the Constitutional Court has told us, because the 194 process needs to be concluded one way or another. If Advocate Mkhwebane is acquitted, fabulous. We must get on with it, she must get back into office. If she is convicted, equally fabulous. We must get on with it. But we cannot be in this state of limbo indefinitely. But thirdly, and more importantly, there is the problem of interference with witnesses. Now, the evidence, the common cause evidence, is the following. The evidence of the evidence leaders is not yet concluded. There are two employees, one of whom still has to be cross-examined, and another who has to be led and cross-examined, who are officials in the Public Protector's Office. She is the head of that office, if she goes there. We then have her witness list, which consists of 17 witnesses, 4 of whom are officials in the Public Protector's Office. We then have rebuttal evidence from the evidence leaders. We don't know yet what that's going to say. But you ask yourself, when we know that there are still 6 witnesses coming to testify, and who are direct subordinates, I don't know, direct, who are subordinates of the public protectors in the office, and you go back to the SABC's case, the SABC DA case about Motsoeneng, which says he has virtually unlimited authority over his subordinates and access to all of the documentation in relation to the charges that will be preferred against him. Given the nature of the allegations and the persons involved, then these people will have to be interviewed. What this shows is that unless he is suspended, Motsoeneng poses a real risk to the integrity of the investigation concerning the allegations of conduct and to the disciplinary inquiry itself. It is untenable that he should remain in office while the disciplinary proceedings are taking. That is the approach of Justice Schippers, as he then was, expressly approved by the SCA. It is binding on this court, and that means that harm has been established. That is without even having regard to the evidence about the 194 inquiry, where employees were testifying about the culture of fear that was present in the Office of the Public Protector. You don't even need to go there. You don't even have to make a finding that Advocate Mkhwebane is the sort of person who would intimidate people. It's the mere risk of it. How do we know that it's the risk of it? Because Justice Schippers told us in Motsoeneng, the SCA approved it in Motsoeneng, and there is no distinguishing feature. That ought to be the end of it. You do not, in organizations, put people in office where they are the head of the organization and where their subordinates will have to testify against them, particularly in a matter as contested as this. So, what is the form of harm to the harms of office and the harms of the public? We are talking about the harm to the disciplinary proceedings, which must be concluded promptly and expeditiously, and we are talking about the harm in terms of witnesses and intimidation of witnesses and the risk. And it cannot be seriously contested that what the DA and the public and everyone else has is the right to a fair, effective, and efficient 194 process. Putting Advocate Mkhwebane back in office, pending the outcome, risks all of them and causes harm to all of them, and therefore cannot possibly be done with respect without breaching Section 18 of the Superior Court. So if I could then just conclude on Section 18, I explained that there are 3 requirements: exceptional circumstances, harm to Advocate Mkhwebane if she is not granted execution, and no harm to anybody else if she is granted execution. None of those 3 boxes are ticked. The case is exceptional, but the exceptionality operates against it, because the exceptionality demonstrates that there should be no interim execution until the Constitutional Court is pronounced. On the irreparable harm to her, none has been shown. None at all, in light of the binding decisions of the SCA and the Constitutional Court in Long and DA versus SABC, to which we refer. On harm to the public, extensive harm has been shown on the binding decisions of the SCA in Ntlhameza and the SABC, to which we have referred. If she had only ticked one of the 3 boxes or 2, she would not be entitled to relief. Advocate Mkhwebane has ticked none of them. This, with respect, is the easy Section 18 case, because none of those boxes are ticked. That means, Justice Nuku, that I can be very brief on prospects of success, because prospects of success in the appeal tend to be used to tip the balance if there is some doubt. This is a case in which there is no doubt whatsoever. So let me say only one word on prospects of success. We have set out the grounds of appeal. This court was confronted for the very first time with the question of what is the standard about a conflict of interest. No, let me say, this court was confronted with the standard of conflict of interest applied to the president, which has never reached the Constitutional Court squarely in this way. There were only high court decisions. This court did not have the benefit of guidance. So the questions of the law are considerably complex and cannot be said to have been shown. On the questions of fact, those too are considerably complex, because depending on the lens through which you view it, you either say it was a hurried decision, as this court did, which leads to an inference of bias, or you say, as we argue, that the president took too long. He gave Advocate Ngubane far too long, and that in fact, if anything, he was overly generous when you view the matter in that whole history, and therefore that there was far from being biased. If anything, he should have taken a decision earlier. I'm not arguing that today. That's not the purpose of today. I'm simply making the point that at the level of law and the level of fact, there is at the least a reasonable prospect another court would disagree. This is not the JASA case, where the appeal was so hopeless or obvious that that resolved it. This is not one of those cases. And I, again, with great respect, would hasten to add that the court must have thought long and hard about trying to untangle the web of law and facts that it did in its judgment. So we submit with respect that for two reasons this application was failed. A, because Section 18 doesn't apply at all, and B, because even if Section 18 applies, the requirements, none of them have been met. The application should therefore be dismissed with costs, including the costs to counsel. The only remaining questions are the questions of the scale of costs and the questions of whether they should be paid personally or not. We submit that the costs should be paid personally, whatever the scale, by Advocate Ngubane. This is not litigation that is brought in the interests of the Office of the Public Protector. This is litigation, good or bad, that is brought to protect Advocate Ngubane's personal interests, and you know that because of the repeated contention about how she's personally prejudiced. Wrong as they may be, how she's personally prejudiced. There is no reason that the taxpayer should have to foot this bill, and we ask that the cost be paid by the person. Even if the court finds there was nothing improper about bringing it, there is no reason the state should pay.
But is there any authority to support that proposition that where the litigation is brought to protect the interests of an office bearer, that office bearer should pay personal costs?
Well, there is the authority in the Zuma judgment in the SCA, which makes clear that the state should not be funding endless litigation we'll find it, brought by persons to protect their own interests. That was in a criminal context, and the challenges to those, but we submit that the same applies here. And we submit that squarely there is no basis to say that the state should pay costs.
I'm asking this because my understanding is that there must be something which the court is really not happy about to multi-litigant in personal costs.
Well, with respect, you make with respect a very fair point, Justice Nuku. Personal costs can be given, as I understand it, in two situations. One is where the litigation is brought improperly, and I'll come to that. But the second, we say, is that where the litigation is brought for the pursuit of private interests rather than public interests. In other words, there is a limit to the extent to which public officials can have the state cover their costs and certainly expect the state to cover adverse costs. I will find you when my learned friend is on to speak the Zuma case. And
but it would be a very dangerous precedent to say that any public office bearer runs the risk of having to pay the cost personally without any misconduct in the process of litigation.
I do understand the concern, Justice Nuku, but there is equally a dangerous precedent to set that you can litigate any case, no matter how much it's about yourself rather than your institution, in the hope and expect that any adverse costs of law will be covered by the state. Yes. Just one. Yeah. So the case my learned friend has pointed me to is in fact not the one I had in mind, but it's very helpful. Give me one moment. Let me look at it first. I'm going to make a fool out of myself if I try and read and speak at the same time. And I'll just spend one moment giving you the reference. That's the first submission. But the second submission, Justice Nuku, and this goes perhaps to your point, is that this is an application that was utterly flawed from the beginning, because we had pointed out that it was subject to confirmation proceedings. And the contention that it's not, and therefore is subject to Section 18, we submit is patently without merit. And we had drawn attention to the Armster judgment in the letter before this had even been law. And so we say with respect that this is a case in which it's been improperly brought, and on that basis alone. But can I speak frankly for a moment? This case is not mainly about costs. This case is about the integrity of the public office. And so what matters is that the application is dismissed with costs. Questions of scale and questions of who pays, we have made our submissions on, and we leave in the hands of the court. I will simply get to the references before we end, but I will not re-argue it. I'll see the reference.
Is that your?
Those are
Is that the end of?
Indeed, thank you, Justice.
Thank you, Mr. Bartley. Hopefully, Mr. Murphy, you will appreciate the fact that we have more than indulged. We've got staff, personnel that we have not even spoken to them about staying there. So if you could just try to be succinct in your submissions, without unnecessarily rushing.
Just let me just I can deal with the issues. I'm not going to address, the unfair and unjustified attacks and misrepresentations of what I said. I think by now it is to be expected. Although it is quite regrettable. But it's very sad that my friends can even resort to castigating the public protector for being sick and asking for postponement this week. As we obviously have been reading in the media. But that's fine, that's all fine. I think she by now can not expect much from the TK. But to misrepresent me, at least because the contract is not here, she can speak for herself. But to misrepresent what I have said to this court this morning is really a little bit, and for that to just go. So I'm supposed to have said if Section 18 doesn't apply, we must all go home. When did that happen? I said here, it was a question, I think, from Justice Nikulin. Oh, no, it was from Justice Nikulin. About whether the implications of what is being argued doesn't then render the order interim and of no final effect. Then I said, if that is the case, that then means that the order falls under Section 18(2) of the Superior Court Act. And if that is so, then let's all go home. Because I read the section thereafter, it says if that is the case, then the order is not suspended. And now I'm just being, it's suggested that I said something that I certainly did not say.
I thought that all that you were saying was that he agrees with you, but for different reasons. The reason for saying that we should all go home is because you were saying that if this is an interim relief, it would not be suspended by the noting of an appeal. And as you were saying that we could just go home.
Yes, that's what happened. That's what Mr. Badlander just said to you. Mr. Badlander said, Mr. Mpofu said, if Section 18 doesn't apply, let's go home. That's a lie. It just did not happen. So what you are saying, Justice Snow, is exactly what happened, which I just summarized here. But anyway, the other issue is about the section 172(1)(b). Mr. Padlander says to you, and again, just gets away with this, says that this court was only asked to make an order in terms of section 172(1)(b), and the court would be shocked to learn that it was an order in terms of 172(2). And yet, in the affidavit, in their affidavit here, they say that the court actually made an order in terms of both 171(1)(a) and 172(2)(b). The very shocking thing that he alleges is exactly what they said happened. So I'll he says at page 219, the argument that the full bench made an order in terms of section 172(1)(b) and not 172(a) is difficult to fathom. The full bench plainly did both. That's their case.
What paragraph is that?
It's 20.2, my lord. 20.2. 219, yes. So the idea that this court would now be shocked to do one of the two things that it...
I'm sorry to interrupt, but it's actually just a misrepresentation of what it actually says on the page. It actually says 172(2)(a), not 172(2). I'm sorry to interrupt, but it's just plainly wrong when it's being submitted to the court.
My lord, let me explain what I'm saying. You see, it's easy to make these questions and then try to disown them. If our law had 172(2)(a) and it's stopped there, then how but you can't do this. You can't kind of reach into the law. 172 is a whole section which you can't just pick and choose which one you like and leave out and say, okay, let's look at the two areas that in order of invalidity can no force unless it's confirmed by the Constitutional Court, and let's stop there. No, it doesn't work like that. In fact, because it should create an absurdity of a situation where, as we said earlier, when we made those examples, even if it means the world must come to an end, the minute you have made an order of constitutional invalidity concerning the president, well, that's it, whatever the implications. The law doesn't work like that. The reason why there's 172(2)(b) is exactly to cure or to deal with situations such as the one that we're facing now. So that there is, if you like, an escape route from the absurdity that I have postulated. So you can't pick and choose with respect. That is why 172(2)(b) says, and a court which made an order of constitutional invalidity, in other words, the one that we've just referred to in A, may grant a temporary interdict or other temporary relief to a party or may adjourn the proceedings pending the decision of the Constitutional Court. I mean, this is plain and simple. Now, my learned friends, both my learned friend Ms. Pillay and my learned friend Mr. Padlander, tell us that we should have done something called a 172(2)(b) application. There's no such thing called the 172(2)(b) application. What 172(2)(b) says is that if you are faced with that situation, you may either go and ask for an interdict. That interdict will be an interdict, a normal interdict like any other interdict in civil fire law and all those cases. It's not going to be called a 172(2)B. The mere doing it for the purposes of a particular situation which has been caused by order of invalidity. It's neither here nor there. It's that temporary relief, again, that temporary relief can be anything, as long as it is temporary relief to govern the situation. And that's all we're saying. It's quite simple. And we're saying the temporary relief that in this case is being asked for is called a Section 18 application. And I showed why Section 18 application, by definition, is temporary relief because it's extending an appeal. That's really, we're just complicating things that are unnecessary to complicate. So here's the situation. Let me start by asking a rhetorical question. So, if according to my learned friend, Mr. Badlena, the Section 18 doesn't apply, and my learned friend, Ms. Pillay, then the letter that I read to you, the paragraph 5 of the letter of the DA, which responded to us on the 9th at night, the one that accompanied the application. You remember where they said, okay, well, it's still a confirmation, but we've just, as they say, out of caution, we've put an application for leave to appeal. And that then suspends the judgment, and your client suspension, therefore, is still in place. That's what the DA said. Now, my question to them is, in terms of what was that judgment suspended? In terms of which law? That it can only have been suspended in terms of Section 18. That's what they were saying to us. That remember that we've now launched this overnight application for leave to appeal, midnight special. And therefore, in terms of Section 18, your application, or rather, your suspension, or rather, the judgment is suspended and your suspension, the one from work, is in place. That's what they were saying. They were invoking nothing apart from Section 18. And they come here now to say Section 18 doesn't apply. What is that?
Well, is that a correct characterization, Mr. Ngogo? Because if I understand that letter, their principal position was that these orders are subject to confirmation.
Correct.
But we see that we are not in agreement.
Yes.
Just to avoid a situation where the applicant goes back to office, will note an appeal as we are entitled to.
Yes.
And will also, out of caution, apply for leave to appeal,
yes,
which will have an effect of suspending these orders if you are right.
Yes. How will it be judged in terms of what law?
No, that's what I'm saying. If you are right,
yes,
in saying that these orders are not subject to confirmation,
yes,
then the situation will be that they will be suspended by the noting of the appeal or the application for leave to appeal.
Yes, in terms of what law?
I'm not quite sure if
I'm saying yes. No, I'm with you all along that they are saying yes, if you are right, and so on and so on. But out of abundance of caution, we will put an application of notice of appeal, which will suspend the
operation of
yes. In terms of which law in our country would that suspension of the operation happen? If it's not Section 18, there's no other law in South Africa. Let me answer my own question.
Yes.
There's no other basis upon which what you have just said, Justice Nuhu, would be achieved, except by Section 18 of the Superior Courts Act. So, the one. Okay. So let's cut out this gymnastics and accept that they themselves. I'm trying to portray a very serious thing here, that they themselves, by invoking Section 18, with all the qualifications that you have currently put, Justice Nuhu, are saying that once we put this application for leave to appeal, Section 18(1) kicks in, and Section 18(2) kicks in. But anyway, that's the answer. In the rhetorical question, normally doesn't need an answer, but I've just given an answer. The answer is that it's Section 18 that they were invoking. So that's the one. That's the fallacy of this whole, when you build a house of straws and stones, this is what happens. So, two things you must accept. One, that the Section 8 application, which they provoked, because that only will what else are we supposed to do? If they come to us and they say, effectively, the judge is offended. But according to them, we must hold our arms. We must now not really go to Section 18 and say, what is the remedy that we can get, which is to come to this court and seek an order and ready free. No, they are the only ones entitled to invoke Section 18, but we can't do anything. Well, that's no. So let's do systematic. I said this morning, and I was avoiding this. My learning friends, both of them, spent half of their allocated time to explain, to say to this court that the order is an order made in terms of 172.2. But what is the purpose of that? Because I said, when we stood up here, I said, let us assume that they are right about that. Okay. I said, let's assume that they are right. Let's assume the common law point is not, but we see a chapter and verse of the common law point. I said, let's assume everything that they are saying is correct. That this is a 172.2a order or 2b order. But I'm saying the recourse for that is, and that exchange Justice Nuhu, because they said, well, then you should have brought an application in terms of 172.2, and I've just explained that's exactly what we're doing now. So that is just a waste of 2 hours to try and convince the court that this is a 172.2b. And I remember Justice Nuhu even asked me, are you, and we had that discussion, is this a concession or is it? And I said, no, let's assume, not considering, I'm simply saying, assume for the sake of progress that everything that they are saying is right. They must answer 2 questions, and those 2 questions have not been answered. Simple. Question 1, is Section 18 not the, or rather, why is Section 18 excluded from the definition of other interim relief envisaged in 172.2b? There's no answer to that, because it's not. That provision deliberately seeks to be wide and does not foresee every type of interim application that may be brought. Then I said, forget even about that. Let's now look at it from the point of view of Section 18. On their version, what they have brought is an appeal and an application for leave to appeal. And if you look at Section 18, it says pending an appeal or an application for leave to appeal. And unless that section says pending an appeal and an application for appeal, except an appeal described in section 172(2)(d), which is what they are doing. It's a 172(2)(d) appeal that they have put now. But there's no such thing in section 18. It says an appeal. Any old appeal, if or application for leave to appeal, once you file it, then you invoke 172, or rather section 18(1). The only question, and this is Mr. Masuku's point, which again is being frivolized for no reason. What Mr. Masuku was saying is that if if you accept partly what I've said, that this is an interim order, and if you look and go and interpret order number 187.6, then he says, okay, let's assume this court, well, only this court knows what it was doing, but we have to interpret it. This court, in my respectful submission, was granting an order in terms of 172(1)(b). And I said, for the sake of, I'm prepared to accept that, even if this court was not saying we're doing this, and I said 172(2)(a), if that is the effect of the law, fine, we'll live with that. But what is the nature of the relief that this court granted? And Mr. Masuku says, when the court says 187.6, we're setting aside this suspension with immediate effect. By doing that, it is what must happen, right? Even assuming the still confirmation proceedings pending. But this court cannot sit in appeal of its own decision. That decision is made. All we can do now is to interpret it. We can't say no, don't interfere with witnesses. I mean, I don't understand how we can sit here and re-argue the case that we argued in July about the whys and wherefores of the suspension. Because that's done. It's water under the bridge. Having listened to all those things, this court decided to set aside the suspension. You can't appeal to the same court now again. No, but this is what will happen if she goes back to the office. It's done. And so the only thing this court can do is to say, and that's what we're imploring you to do. Even if you read 187.6 as it were a just and equitable order, and it doesn't matter whether it's a 172(1)(b) or 172(2)(a) order for the purposes of this argument. But we did not keep quiet. This court could have kept quiet. Could have done 3 things. Could have said we declare the conduct invalid and goodbye. Or it could have said, as it did now, we declare the conduct invalid, but we also set aside the suspension with immediate effect. Those two things are not the same legally. Or it could have said, we don't declare anything. We're just setting aside the suspension for this or that evidence. But now we can't change the clock. We must look at what actually happened on the ground. What happened is that this court gave 2 orders. One, a declaration of invalidity, and the second one, in order to set aside the suspension of the public protector with immediate effect. And that's the point Mr. Masuku is making. Saying that second order must therefore be the interim, it's what governs the interim situation. All these cases that they're talking about, Dawood and McBride and so on, were all about that. They were saying we've declared something invalid, but what must happen in the meantime? I think in the one case, it was the declaration was suspended for 2 years or something of a particular act. But then the court has to ask itself the question all the time: what should then happen? What must happen tomorrow? We know we've made this declaration. We know, but what must actually happen in real terms? This court answered that question in the order in 187.6 when it said the suspension is set aside with immediate effect. So there's nothing more that this court can do to re-engineer or rethink its order. It's to quote Justice Lekule, it's untis for here. It's done. Now, on that score, then says Mr. Masuku, if you accept then that the second order is a holding situation at best, assuming they are right in everything that they are saying, there's still going to be confirmation proceedings somewhere. So 187.6 is a holding position. Because this court didn't say the order will be effective next week or once the witnesses have finished giving evidence in the section 194. But it said now, today, on the 9th of September, it's effective. And the most benevolent reading of that for the respondents is that the court was saying it must be that the public protector suspension must be removed pending the confirmation proceedings. That's the best that they can contend. But you can't wish away that the court did govern what must happen as of the 9th. And the only reason that thing did not happen goes back to the question I was asked, the rhetorical question, was because they put up an application for leave to appeal invoking section 18 of the Superior Court statute. It's that simple. It really is. And so then they say that no, but you can't apply section 18 into an order that is still subject to confirmation. But then, what's the point of then 172.2b? We must just scratch it out then and repeal it. Because 172.2b was meant to govern that exact situation of what happens after 172.2a while you are waiting for the confirmation. 172.2b says, in the meantime, the court that gave the order, namely this court, and I've said this, we have nowhere else to go. This is that situation. It's only this court, the court that gave the order, may then govern the situation. So it is either the situation has been governed already and there's nothing more to be done, as Mr. Masuku says, or logically that also falls under 18.2, or as I say, I'm saying, well, this court, even if it did govern it under 186.7, but there's nothing stopping it from governing the real complex situation now that they have invoked section 18. And I'm sure the court will find it easy to reject the notion that we can invoke section 18, but we can't. It applies when it's done, but it doesn't apply when it's asked. Because that's just legal The next issue is this, and this is conceptually maybe more difficult to define. Nullity. I have said that it is not true, Mr. Pakland said that if something is invalid, it's up to the date of when it happened. No. Our law is very clear since 4th May in 1997. It was said that an act will be invalidated to the date of the promulgation of the Constitution, as if it never happened at all. But for the purposes of this debate, it doesn't matter whether it's nullified from the date of suspension or to 1996. But nullity, right, is an outcome in a case like this of two separate juridical acts. Let me repeat that. In a case like this, where there are two separate orders of constitutional orders, the nullity arises twice. Let me put it down. Okay. If this court had simply said the declaration, rather, the conduct of the president in suspending the public protector is invalid, and stop there, that would visit that decision with nullity, right? Of the kind that I've just explained, 1996. And if this court had not done that and simply said, we're setting aside the suspension with immediate effect, that would visit the decision with nullity as well. Okay. Now, one has then to understand why then, if both of these things result in nullity, why does the court have to do them both, so to speak? Because by the order in 187.5, you've already achieved nullity. Why do you have to do it again? It is because those two orders serve two different purposes. The order of invalidity, which is the one that is susceptible to confirmation, basically describes the status quo. Sorry, just want to. Yeah. Let me click this explaining this thing about the decision and which, as I said, is not quite final argument, but I want to explain. Let's assume that what we were dealing with here was Mr. Baglet read you the case of pharmaceutical about there are no two sets of law and what is in the common law. That's true. But what you forget, that case is about a review. He said it about 3 times when he was reading. If you are reviewing law, you can't then say, now I'm reviewing under the common law, now I'm reviewing it under the Constitution. If that was not understood in pharmaceutical, it was made very clear in Battlestar. Battlestar or Reagan made it abundantly clear that the so-called common law review, because it was believed by some people that common law review somehow has survived. And she said, there's no, it doesn't, it's not there, because now the review has been taken over by Page. That has absolutely nothing to do with what we're debating here. What we're debating is having said that, for the purposes of what I'm going to say, I want to say that it should better not be talking about illegality that is brought about by Section 72. I'm talking about this setting aside.
Sorry, before we do that, Mr. Mboko, how long are you still going to be We are now really constrained for time.
Well, unfortunately, I have to reply.
Yes, no. I'm just asking, how long do you think it will be?
Maybe up to 4 months. Up to, let's say, up to 12 months.
We'll proceed then.
Thank you. So this is what I think. Again, as we shall see, I'm sorry, it's the book that I read here of Books and Method, page 757. It defines what is setting aside. As we shall see, both the common law and the partner and administrative decision continues to have effect until such time as it is set aside by a court. Setting aside is simply a way of saying that a decision no longer stands, that it is null and void. The effect of setting aside is in the absence of an order to the contrary retrospective. Once it has been set aside, the decision not only ceases to have effect, but it is to be treated as if it never existed. Now, what's the relevance of that? The relevance of that is that the minute this court set aside the suspension of the public protector, the legal effect of that was as if it never happened, right? And that's why, and when this court even made it better by saying it is with immediate effect, then it meant as of that minute she could walk to the office. I've explained that before in the morning. I won't go into it today. But that is the effect of setting aside. Now, there's a whole complicated debate, and I'll just refer you to some of the cases about the differences between setting aside and nullification. And this order basically says that the Constitutional Court, she says at 783, the Constitutional Court has for the most part struck at its two-stage characterization, which assumes that there is a difference between a declaration of invalidity and setting aside. But if there's really no difference, the problem is that the obligatory nature of a declaration of invalidity under Section 172(1)(a) leaves no room for judicial discretion not to set aside unlawful administrative action. What that means in simple terms is that if we didn't have the extra remedy of setting aside, then you would only be left with the remember Section 172(1)(a) says must. A court which finds conduct to be inconsistent with the Constitution must declare that to be invalid, and that would mean that it visits it with nullity. The setting aside issue is about now doing something more. It's not a duplication. It is now saying we are now that we've declared the thing invalid, we're setting it aside with immediate effect, separate theoretical action, so to speak. Now, the relevance of that is this. It goes back to Mr. Masuku's formulation. We then must take the second order as the order that was regulating what should happen if in the meantime, so to speak. But all I was saying about the common law issue, which is being misunderstood, was not that there are two systems of law. I was saying that it is conceivable to have the setting aside order without the invalidity order. Let me make an example, Justice. It is not true that everything that is done by the president, which can be set aside by court of law, amounts to a conduct of the president in terms of 172(2)(a). Let's assume the president and he'll forgive me if I say something. Takes somebody, locks them up in some office there in Matamando, or down the road here. And that person or their children go to court and they say, we would like you to order the release of that person because that person is being held unlawfully there by the president. Habeas corpus type of order. The court will do exactly that. To say, what happened? No, we had this person, she was suspected of pala activities or whatever, and locked up in some room there. The court will say, release that person. There's the court order. That whole thing will have been based on the conduct, quote unquote, on this fallacy, on the conduct of the president in doing what? In locking the room. But according to this, that person should not be released until the Constitutional Court has confirmed that order. What? No. The pure, simple fact that that order would be deriving, as it would, from conduct of somebody called the president, would not change the nature of the release order of this court. But if that same person came here and said, I want you, because this person is the president, first it must declare that that conduct is unlawful of locking me in power, and secondly, you must release me. All of a sudden, it has a different meaning. I mean, what kind of law is that? Because surely, and the cases that they read of Dawood, two words that are left out from Dawood. Dawood says that if the ancillary order, and that's why what we're trying to demonstrate that this is not an ancillary order per se. And I've even said, even if it is, it's not solely derived from the invalidity order. But what they say is that if it flows directly, those are the words that are used in the Dawood, paragraph 18. If the second order flows directly from the other one, then it must also go for suspension. Exactly the same words are used in McBride. The direct relationship between the two. But justices, again, I don't know how many times I must say this. The answer to that is, so what? So let's assume then that both orders are susceptible for confirmation. So what? You still have recourse to 172 and we still have recourse to what we are doing now, which is Section 18, as part of the other interim relief that is envisaged there. So whichever way you can look at it from the north, south, east, west, it will come to the same thing, which is that an aggrieved litigant who has to await confirmation has a recourse primarily from Section 172B, but also in terms of the law of interdict, just the normal common law of interdict, to find a relief to govern their predicament, so to speak. Or they might accept their fate. Another litigant next door might say, okay, I've got this order of invalidity and it's subject to confirmation. I'm fine with it. That was the case in my primary. He said, I remain suspended. It's okay. As long as it's not going to be done legally. That's his choice. But that's not the choice of the protector. The choice of the public protector is to invoke protection of the law in by bringing this condition that the court can release her from the undue suspension which has been called by the application of such a so that's the only reason she's sitting at home. What other reason? Maybe I start that and talk about apart from sitting at home. There's only one thing, the one that is yes. Then we are told that so I'll come back to I know I'm moving to the marriage, but I'm trying to take time. Mr. Baglander actually says that there's no harm that is being suffered by the public protector. Yeah. And for that, one of the arguments advanced by both Marlene's friend is that, she's been suspended for 3 months now, so what's the problem? But that's exactly the reason why the harm is so egregious. The fact that she's been sitting at home for 3 months as a result of the abuse of power by the president, for no other reason except the criminal, corrupt abuse of power of the president. That's the only reason she's been sitting at home for 3 months. But, she must just grow up and take it on the chin. So, my learned friend, Mr. Baglander, then relies on the case of Long for that proposition. The case of Long is not authority for this. They say themselves correctly in their answering affidavit that the public protector is not an employee, must not behave as if she's just employed. She's the holder of a constitutional office and so on and so on. All correct. But when it suits them, they want to invoke labor law principles. This is what Fundament J said in the case of Long at paragraph 23. This case concerns fair labor practices in terms of section 23 of the Constitution, and specifically whether there is a requirement for a pre-suspension hearing in the case of proportional suspension. The court's jurisdiction is engaged. So the Long case concerns what they say we must not invoke. Again, we must not invoke these principles because we are not employees. But when they want to buy the public protector, they go to a court, a case that is in the heartland of employee relations and deals with, in fact, in Long, it's very short, but if you excuse the pun, Long is a very short judgment. So that was not intended. But the judgment simply says there was this that happened in the labor court, and the judge referred it here. And it's the first court case that said under the Labor Relations Act, a precautionary suspension can happen without Audi, basically. That is the long and short. So that case can never be authority for the proposition that Mr. Baglander wants to tell us, that a person can be bundled out, suspended, kept at home, and there's no harm to them that is being suffered. And the reliance was not just on Justice Sachs. Mohutle that's the case that I had forgotten. Mohoka versus NEC for Education, or Premier and Northwest, is a case that established the principle of arrest and so on. And I refer this case to this court to Wachenuka. It's a case we referred to this court in the part we had, you'll find and then, Justices, before I can be stopped, let me just, unfortunately, you know, urgent applications, these things happen. Although the letter that we attached to the reply affidavit is a letter dated 26 May. That the only outline affidavit deals Chaka Invest with the merits of the suspension. This is the representation letter. But that was not a letter we wanted to refer the court to. Fortunately, and those are the advantages of having this kind of thing in the same court that we're in. This court will remember that there was, I think it was in the previous litigation called SPP 10. There was an 8-page letter which was written dated the 13th of June, that's post the suspension. That letter, 8 pages, blow by blow, dealing with the reasons why the suspension should not have been given. Since we don't have time, I can't go to the whole 8 pages. But I just want to refer to the fact that one of the things spoken about there was this whole thing about witnesses. That there's no, I've been there for 2 years, she said, already. When this thing started 2 years ago, I've been there, there can be no harm by me being in the office at this particular stage. And invoking the 3 well-known reasons for suspension. Suspension is done if there is classically in situations where it's not a precautionary because they're wrong, where you've had your Audi rights, and here the Audi rights were granted, which was a letter to show cause and what have you. Secondly, if you are guilty or charged of serious misconduct, and more importantly, if there's an extra reason such as interference, which you must be taken away from. But you see, that's what is called the garden path. We cannot be led to the garden path of revisiting the suspension decision. This case is not about that suspension of the public protector. It's about the suspension of the order of this court. The minute we allow ourselves to go to the whys and wherefores of the actual suspension of the person, then we are falling into the trap that the DA wants to lead us to. Because I don't know if the issue of when the serious misconduct and you're still in the office, then that should apply to everybody. It should apply to the president as well, because he's also accused of a serious offense. He's got people who might be witnesses in his office and so on. So it's not that simple that merely because there's Malene Trent even introduces a new test, Malene Trent is defining called the risk of harm. I mean, what is that? The law says you must have not just harm, but irreparable harm. But now we're told, no, the risk of harm, the mere fact that there might be, I'm not saying the public protector will do it, but the mere risk must count against that. That's new law. Because if there's, even if they could show harm, it would not be sufficient. They would still have to show that it's irreparable. In other words, those witnesses will have no recourse. The law uses words for a reason. When it says irreparable harm, it means irreparable harm, not any old harm, let alone the mere risk of it eventuating, which may or may never happen. you know. So the long and short of it is that on the merits, because that's where I am now, assuming that the court accepts as it should with respect that all the arguments have shown that Section 18 applies. Then the issue, in fact, it just so happens, it's just lawyering, I suppose, that we always start with exceptional circumstances. In real life, this inquiry should always start with that issue of harm. And my learned friend, again, falsely says that I said that the exceptional circumstances have nothing to do with the harm. But I said the exact opposite. I kept on apologizing to this court to say I'm now conflating the two because they are so interrelated. But I'm accused of having done the exact opposite. No. When we were talking about the calamities and the exceptionality of this matter in relation to the public protector as the target of those activities, that's exactly what we're explaining. We're not saying it's exceptional because somebody somewhere was suspended in vain. No, we're saying the public protector was the target of everything that we've said and that Mr. Ngabane has said about the Phala saga. So that's where the conflation between exceptional circumstances, which is correct, and the harm happens. Because these things, it's just legal conceptualization, but these things are interrelated. So you can't have exceptional circumstances which are divorced from the actual predicaments or the harm of these litigants. But again, I was told that that's what I said. I never, for the record, I never said such a thing. Like I said, the exact opposite. There's just one aspect which well, the issue of the salary. Oh yes, for Zay, this is the case of 1997 case. The first case I ever did in the Constitutional Court. It was said there by Ackerman, when a court declares conduct invalid, this is paragraph 69, for Zay is 1997, bracket 3, SA 786 CC, paragraph 69. When a court declares conduct invalid, it merely confirms a pre-existing state of affairs. For conduct becomes invalid the moment it clashes with the Supreme Constitution. Sorry, just that I'm not misleading the court. I want to check if this is not a. Okay, let me get the actual quotations. Paragraph 69. What I'm reading is from 783 of the book. The conduct becomes invalid the moment it clashes with the Supreme Constitution. Okay, it starts like this. Voidness or nullity is also consistent with the doctrine of objective constitutional invalidity. As was made clear in Fosay, when a court declares conduct invalid, it merely confirms a pre-existing state of affairs. For conduct becomes invalid the moment it clashes with the Supreme Constitution. What that means in simple terms is the notion I was talking about of if left to its own devices, the order will be retrospective ab initio from the moment the Constitution was I know that there's a point which I made a note of which I don't want to. Yes. In Kelland, the well-known Kelland case, Zondo said, Zondo J. In my view, there is no difference in law if a court decides certain administrative decision is invalid and of no force and effect, the position is that that administrative decision was never taken in the first place. The same applies if a court sets aside an administrative decision. That's what I call the no difference principle, which was criticized. Then let me just say, I've commented on Dawood. The issue about prospects of success is that both my learned friends and the acting public protector misread what the public protector is saying and what this court actually said. And it's very sad, I don't know where this comes from. It has never been the case of the public protector that the acting public protector or the deputy public protector, the president basically sat there and said, I'm going to suspend this one so that this one investigates me. That has never been the case. And this court articulated this so well. All that happened is that the president said, I'm not going to be investigated by Mkhwebane, and I'm going to remove him. If the person who's going to be there is Mr. Bishop or Mr. Bartlander or Mr. Lay, I want anybody but this one. And that's where the illegality is. And the court articulated that position very clearly. That is illegal in its own right. You don't have to vilify the acting public protector as some puppet of the president or whatever, or that they've got some scheme going. No. It is sufficient for the president to have done what he did only to make sure that Advocate Mkhwebane is not the person. You can't do that, right? In a constitutional democracy. That is banana republic stuff. You can't say, I do something wrong, but I must decide which police station must investigate me. I must decide which court and all those things. No, if you are in the wrong, if it so happens that the police person who's at the police station at that time is the one you don't like, well, tough luck. So you can't choose. And that's exactly that was the principle of our law in the so-called the case that I did say that to Mr. Bartlander and I were in. Yes, the state of capture case. It was saying President Zuma cannot be the person who chooses the person to investigate him, even if that person is a judge. Even if that person is a judge and we know there's a presumption of impartiality. But the very idea is obnoxious that the person who, the alleged wrongdoer, is going to pick and choose their investigator. This is the same script, it's just playing itself slightly differently. So he was going to be choosing who investigating, and President Ramaphosa has chosen who is not going to investigate him. But it's the same calamity. It's the same assault on our constitution.
You must conclude, Mr.
Yes, I'm Justice. Yes. So the bottom line is this. What do we have here? We have what Mr. Marwana tongue-in-cheek called a coalition of the wounded. We have 3 litigants, about 2 and 1 aspirant one, who in a clearly well-coordinated move seek to do everything, I can't remember, go to the end of the earth, to take Mr. Malala's analogy, to ensure that this woman is not going to go back, irrespective of what the Scot has to say about it. So you have a situation where, just look at what happened on Friday evening. The public protector has an arrangement with her subordinates, including the deputy public protector and the CEO, to say, I'm going to come to the office tomorrow, everything is fine. The DA, 8 o'clock, gives us the application. 10 o'clock, the deputy public protector issues a letter to say, I've just been advised that there's an application. I don't know by whom, because it was not served on them. But you can't come to the office tomorrow. Sunday, the president mimics the application of the DA, and here we are. All of them, for various reasons, which I won't go into because I don't have time, have a conflicted interest in ensuring that by hook or by crook, the public protector is not, the work of this court is not going to materialize as it was intended. That's the only thing that makes them to have this well-coordinated approach. Please, justices, don't allow it. And more importantly, don't allow it on the basis of the fancy footwork that seeks to avoid the Constitution. The purpose of remedial action, of remedies in this country, is to right the wrongs that have been done upon citizens, upon the weak by the strong. The purpose of remedy is not some politically naked ladder. It's to ensure that once unconstitutionality has been visited upon you, a court of law must rescue you out of that morass into freedom like everyone else. And that, with the greatest respect, is your solemn duty. It is a duty that must be approached by definitely being able to separate the wood from the trees and look at the final prize, which is freedom, the liberty, and the human rights of the public protector, who has been assaulted by someone with criminal intent, with a corrupt intent, who wants to make sure that she's not there. Whatever method she uses, whether it's interpretation of personal tradition, is not coming to the same. And therefore, I don't want to repeat the submissions I made on the front. But this time, we go to both say something about the conduct. What they are doing is actually standing there. Approach. Because what they are doing is not allowed.
Thank you, Mr. Chair. Do you have any? I do. I know it sounded like you wanted to marry me a lot, but I did I'm unavailable. I intend to take very basic submission or two aspects. But let me just, this might look, it's in fact frivolous for me to make this submission. The judgment in my sector was not decided 30 years ago. It was decided in 2007. But just
Not all of us are very strong mathematically.
Yes, no, I appreciate that. But the reference to Tsone's judgment and the Semedo's judgment misses the point. There was no order of constitutional invalidity in relation to their suspension. If the courts had reviewed and set aside their suspension, it's unlikely that the similar arguments that my learned friend seeks to rely on in order to mitigate or to suggest that somehow a suspension is an appropriate order, where a court has found that a president has suspended a head of a constitutional institution in a manner that is in conflict with his duties, in a manner that is in conflict with the Constitution. So they are distinguishable from what we're dealing with here. They should not be authority for the proposition that a suspension is of no consequence. Where a court has said a suspension on its own is unconstitutional or has been arrived at unlawfully, the arguments ought to be absolutely different. I'm not going to deal with the issue of what the purpose for a just and equitable order is. It's self-evident. It avoids. It is an order given by a court that grants an order of constitutional invalidity in order to avoid disruption as a consequence of that order of constitutional invalidity. It is meant to operate immediately. It is meant to continue operating until such time either the functionary tasked with correcting that constitutionally invalid state of affairs corrects it, or until such time the conduct of, until such time the Constitutional Court confirms the order of constitutional invalidity. Just to place the issue of Section 172 into context, all courts, the High Court, Supreme Court of Appeal, and the Constitutional Court, must act in terms of 172(1)(a) when they're dealing with the constitutional invalidity question. They all must deal with that. When a High Court makes an order of constitutional invalidity, that must be confirmed. It must, in terms of Section 172(1)(a), declare that conduct unconstitutional. That's mandatory. That's not even optional. What is discretionary is how the court mitigates the effects of that order of constitutional invalidity. And that is the purpose of 172(1)(b). So the court says it's invalid what has happened, but to avoid a lacuna in the law, to avoid disruption in the administration of justice or in the administration of municipalities, to avoid a situation where decisions are taken by a functionary and as a result of the order of constitutional invalidity, those decisions may well be placed in jeopardy. The court says, no, we're not going to do it retrospectively, we're going to do it prospectively, as this court did here. The intention of a just and equitable order is to operate immediately. Now, I just want to say something about the arguments that all orders of the High Court, which either go by way of confirmation proceedings or by way of application to appeal, must be confirmed or not confirmed by the Constitutional Court. What the Constitution says is that an order of constitutional invalidity is the one that goes on confirmation, and Section 15 of the Superior Court regulates that. And you'll see that Section 15 says a High Court must refer the order of constitutional invalidity to the Constitutional Court for confirmation. That's Section 15(1)(a). But Section 15(1)(b) says, whenever a person or organ of state with a sufficient interest appeals or applies directly to the Constitutional Court to confirm or vary an order of constitutional invalidity by a court, as contemplated in Section 172(2)(d) of the Constitution, the court must deal with the matter in accordance with the rules. My learned friends who make regular appearances in the Constitutional Court know that when you appeal, when there is an order of invalidity that ought to be confirmed by the Constitutional Court and is referred to the Constitutional Court for confirmation, you don't just show up there and argue the case. My learned friend and I were against each other maybe 2 weeks ago.
And one of the points they've taken is that I had not applied for an application for leave to appeal the orders that related to my client, right? So what happens is that the order of constitutional invalidity goes on the confirmation procedure that is set out in section 15. But the other orders related to that in the sense of maybe a consequent order or an order that is just and equitable, but not necessarily, not all orders under just and equitable necessarily need to be attached to the constitutional invalidity order. And I'm referring to authority for that proposition, which is judgment from Seneca in a case that I will refer to now. But what happens is that a litigant who has an interest in either supporting the variation or supporting a confirmation of an order or in varying an order would then apply to the Constitutional Court for leave to appeal that order. And often it's the order, that order that is appealed is the order that is just and equitable. The order that is granted under section 172B. In the case that Malene Friend and I were against each other in the case, the order that we appealed against were orders that gave effect to that is essentially were granted in order to ensure that the tax records of the former head of state were immediately granted to media applicants. And we said no, but those are not orders of a temporary nature under section 172 be. They were not temporary. Because once you hand over the tax records, then of course the media has the tax records. We can't do anything about it. That was the reason why that is why those orders did not fall under, were not competent to be given by High Court, because they were not temporary. They did not occupy the space between an order of invalidity and a confirmation of process, which we, as I've submitted, is a period that is regulated by a just and equitable order if it's granted under section 172 1B, or a temporary order if it's granted under section 172 2B. Those orders are meant to operate immediately, but they're meant to operate pending the outcome of a further litigation, which is the confirmation of the decision of the Constitutional Court on confirmation. So they operate as interlocutory orders. Malene Friend tries to poo-poo this idea of an interlocutory order, reducing it to mere postponements and mundane issues. I've given you an authority on what interlocutory orders are. Him and I know what an interlocutory order is. I want to mention too that section 17, only the High Court or the Supreme Court of Appeal may operate in accordance with section 172 2B, not the Constitutional Court, because the Constitutional Court's job is to confirm the order of constitutional invalidity. So it's very unlikely that the Constitutional Court will be saddled with the responsibility of issuing a temporary order while confirming an order of constitutional invalidity. I mean, I'm not saying that it may never arise, but I'm saying it's very unlikely where Constitutional Court is faced with an order with a process of confirming an order of constitutional invalidity, and then invokes 172 2B and says, well, while we're considering this, here is an interim order or a temporary order that we need to insert in order to regulate a lacuna. It may happen where a court does not give an order under section 172 1B, a just and equitable order. They just give an order of constitutional invalidity and leave nothing and do nothing after that. It may happen that way, but it's very unlikely. In the following, this is a judgment of the Constitutional Court in Hall School, MLO. I'm not African literate, so I'll just spell this. It's HOERSKOOL Emelo, ERMELO, versus Head of Department, Mpumalanga Department of Education, 2010, Volume 2, SA 415, Constitutional Court. There, the court proclaimed that the existence of remedial powers in Section 1721B does not depend on the declaration of invalidity. And in fact, Mseneke, to quote paragraph 97 of that judgment, he said the following: it is clear that Section 1721B confers wide remedial powers on a competent court adjudicating a constitutional matter as this one. The remedial power envisaged in Section 1721B is not only available when a court makes an order of constitutional invalidity of law or conduct under Section 1721A. A just and equitable order may be made even in instances where the outcome of a constitutional dispute does not hinge on constitutional invalidity of legislation or conduct. So you can see why, and in fact that case confirmed an order of former Justice Richard Goston, Department of Home Affairs, where he laid down the proper approach in assessing whether a suspension should be ordered. In that judgment, whose details I can send the court later on, in that judgment, he said the suspension of an order is appropriate in cases where the striking down of a statute would, in the absence of a suspension order, leave a lacuna. In such cases, the court must consider, on the one hand, the interest of the successful litigant in obtaining immediate constitutional relief, and on the other, the potential disruption of the administration of justice that would be caused by the lacuna. Then it goes further and says it will also seek to tailor relief in the interim or to provide temporary constitutional relief to successful litigants. Then it says the two important principles emerge from these statements. The first is that a successful litigant must obtain immediate constitutional relief. This accords with what the court pronounced in Bulwana in these terms. Central to the consideration of the interest of justice in a particular case is that successful litigants should obtain relief they seek. It is only when the interests of good governance outweigh the interests of the individual litigants that the court will not grant relief to successful litigants. And then he talks about, so I mean, this addresses the purpose for a just and equitable order that sits between the confirmation process, at the end of the confirmation process, and the granting of the constitutional invalidity order.
The Goldstone judgment, we say what?
I'll give the full details of it, but it's a judgment that I think the department, the DG of Home Affairs was involved in it. I can't quite remember the full citation, but if the court bears with me, I'll go and find the full citation of the judgment. But if my learned friends remember it.
It's Jacobs.
Yeah, there you go. That's the constitutional law book. Thank you. So I heard that. Yeah. So honorable justices, do not be swayed by references to Mtswane, who's my other client, or to it was Mtswane in Shemeza, my friend. Don't be swayed by those references to those judgments. They do not take into account the gravity of the situation you're dealing with here. A finding, it doesn't go further than this. This stuff is serious stuff. That judge who is considering a judgment or who is running a criminal prosecution has been suspended by the very person is prosecuted, or by the very person who they are deciding a judgment is a crisis by any means. An unlawful suspension of an investigator of constitutional delinquency.
No, but Mr. Maso, I think you're straying from your point, because I understood your point to be that Section 18.2 applies, and that's the case by the UDM, the PAC,
yes,
and the
No, I know it's too late in the day, so perhaps if I'm straying, bear with the because I'm sitting here and my learned friends were behind me. There was a lot that was coming directly to my ear, so I'm trying to respond to some of the submissions they were making, even though they were not classically the submissions that we were making.
Yeah, no,
They are of
to
assistance to the court.
the submissions to your client's case.
No, but my lord, with respect, I'm submitting that you have to differentiate between the authorities you refer to.
No, I accept that. That's very helpful.
But I'm also submitting in the thank you, my lord, that you accept that, and that will be reflected as so in the judgment. But what I'm further saying is that once your lordships accept that proposition, you must then go further and say, but what are we dealing with here? Why do they want this particular order that would allow Mr. Mkhwebane to return, or Advocate Mkhwebane to return to your office? And the simple answer is because you have declared that his suspension is unconstitutional. Because that device, that constitutional device of suspending somebody, the power to suspend somebody, has been used inappropriately in a constitutionally offensive manner. It should not stay a day on, because nothing goes further in violating the Constitution than an exercise of this kind of power in the manner that has been exercised. And that is to buttress the point that why this case is distinguishable from the Mtswana case or from the Nhlabeza case. We submit respectfully, honorable justices, that for the clients whom we represent, who have a duty of oversight in relation to executive action, in relation to executive conduct, in relation to the behavior of members of the executive, it's profoundly disturbing that they sit in Parliament with a case in which this court has found that their president, the head of the executive, has in fact unlawfully suspended a Chapter 9 institution. In conducting their oversight duties, they will be failing to express an outrage that suspension should nonetheless continue through the skillful procedural stratagems that were adopted. Application for leave to appeal, stop it. Confirmation, stop it. Stay at home when the court has spoken. The voice of the court ought to be louder than any other voice that must speak on this matter. And we commend the court to be very courageous in insisting that the suspension, which is found to be unlawful, should not live a day longer. On the arguments we made, these applications are irrelevant. Mr. Mkhwebane should go back to work. And if you accept the argument that we've made in relation to whether or not the applicant for leave to appeal suspends an interlocutory order, if you accept that submission, then the result of it is that you should simply issue almost a declaratory order saying that the order you granted is an order that she should go and work and perform her functions, and they should not fear that of nature that our learned friends accept the political hype and the political fear they have of a bold and courageous public protector who tries their best. Just like the judges, sometimes they get overturned on appeals. She too makes mistakes, and those mistakes should not be exaggerated, except for political gain. They can be exaggerated for that purpose only. So we'll submit that the order is prayed for is granted on either the public process application or as we submit, there is no suspension that has been triggered by the respective applications for leave to appeal. Those would be our submissions, and we're greatly indebted to the court for the time to make these submissions and for the lateness of the day, and to the staff that is supporting the court.
Thank you, Mr. Masuku, and thank you. Is that your submission?
Those are submissions.
Oh, thank you.
So I promised to give you two references. I don't want to, but shall I just, out of duty, finish it? The two references for cases are Zuma versus the Democratic Alliance, 2021, 5, SA 189, SCA, at paragraphs 39 to 40, and Zuma versus the Office of Public Protector, 2020, ZASTA 138, at paragraph 35. And for the assistance of my learned friend, Mr. Masuku, the case he was looking for is J versus the Director General, Department of Home Affairs, 2003, 5, SA 621, decision of the Constitutional Court. That's what we say.
Thank you, Mr. Bartlander. I must thank all counsel involved for the submissions that were made, both written and in court. I must also thank the court staff for assisting us to sit until this late, and our colleagues for the patience. We have to consider all these submissions, so judgment is reserved. In court staff.
When it's on Teams, so I just unplug it. When it's on Teams, so I just unplug it. That's right. Shouldn't be safe to some things.